I declare open this public hearing of the Joint Standing Committee on Aboriginal and Torres Strait Islander Affairs for the inquiry into racism, hate and violence toward Aboriginal and Torres Strait Islander people. I wish to acknowledge the traditional custodians of the lands on which we meet today. I pay my respects to their elders, ancestors, past, present and future. I extend this respect to all Aboriginal and Torres Strait Islander people and their cultural and spiritual connections to Australia's lands and waters. In accordance with the Committee's resolution of 6 August 2025, this hearing will be broadcast on Parliament's website and the proof and official transcripts of proceedings will be published on the inquiry website. Any answers to questions or notice taken at this public hearing will also be published on the Committee's website. I remind members of the media who may be present or listening online of the need to fairly and accurately report proceedings of the Committee. I now call on representatives from the Australian Human Rights Commission to give evidence. For the Hansard record, would you please state your full name and the capacity in which you appear?
Katie Kiss, Aboriginal and Torres Strait Islander Social Justice Commissioner.
Giridaran Sivaraman, Race Discrimination Commissioner.
Thank you very much. But although the committee does not require you to give evidence under oath, I should advise you that this hearing is a legal proceeding of the Parliament and therefore has the same standing as proceedings of the respective houses. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege and is being broadcast live. You can see from the nameplates in front of us which committee members are joining you this morning. I now invite you to make a brief opening statement before we proceed to questions.
Thank you, Chair. Before I begin, I also acknowledge the traditional owners of the lands on which we come together today, the Yuggera, Turrbal and Quandamooka peoples of this area, Magunjan. Thank you for inviting us to give evidence today. As I've already stated, I'm the Aboriginal and Torres Strait Islander Social Justice Commissioner, appointed under the Australian Human Rights Commission Act 1986. This is my colleague, Giri Sivaraman, the Race Discrimination Commissioner, also appointed under the same Act. I'll be making our short opening statement today. The Australian Human Rights Commission made a written submission to this inquiry on the 8th of May 2026. As we know, Australia was founded on the mistreatment of and racism towards Aboriginal and Torres Strait Islander peoples. To fully understand the degree of racism and violence experienced by First Peoples requires a solid understanding of Australian colonial history and of Australian governance arrangements and systems since colonisation. To fully address any and all forms of racism in Australia, we have to start by addressing this most foundational racism, which allows for all other forms of racism to fester. Unless and until we address racism against First Peoples, we will not be able to create a culture which effectively addresses racism more generally. Our submission refers to several Commission publications and other research which document the racism experienced by First Peoples, as well as our work that addresses the broader need for a National Human Rights Act, the implementation of the United Nations Declaration on the Rights of Indigenous Peoples, and the implementation of the National Anti-Racism Framework. These are essential pillars of a comprehensive, integrated and comprehensive approach to countering racism. Since our submission, the Attorney-General has tabled my first social justice report, which sets out a blueprint for a fair and just future for First Peoples. It incorporates the findings from my Informing the Agenda engagements, the voices of over 1,600 participants from across the country. Those people told us about the breadth and depth of the racism they experience across all areas of their lives and which is pervasive throughout mainstream institutions and systems. They spoke of the increase in racism during and after the 2023 Voice referendum, and that impact is still felt. They emphasised the need for better education to protect Australians from susceptibility to the mis- and disinformation that underpins racism and hatred against First Peoples. I want to note Commissioner Sivaraman's supplementary submission also drawing the committee's attention to a statement by the United Nations Committee on the Elimination of Racial Discrimination regarding the persistent overrepresentation of Indigenous children in Australia's criminal justice system. This was one of the many specific areas that we heard a lot about in Informing the Agenda engagements. The racism that Aboriginal and Torres Strait Islander children experience is both interpersonal and structural and is destroying the opportunity for our children to have positive and meaningful futures. Finally, members, both Giri and myself encourage the committee to strongly advocate for real and accountable reform that addresses racism against First Peoples in all its forms. Recommendations must drive action. The time is now to finally confront the foundation and ongoing scourge of racism against First Peoples, in turn creating the conditions to address it for all Australians. Thank you.
Thank you very much for that opening statement. We'll go to questions and begin with Senator Thorpe.
Thank you, Chair. I'll first go to Kiri. In your submission, you say if we don't address racism against First Peoples as a national priority, we can't address any other forms of racism, including that being examined in the Royal Commission on Anti-Semitism and Social Cohesion. What do you mean by that? And why will it not be possible to address any other forms of racism unless we address racism against Aboriginal people as a national priority?
Thanks, Senator. I'd also like to begin by acknowledging the Yagara and the Turrbal people, the traditional custodians of the lands on which we're on, and pay my respects to elders past and present. And I actually want to explain why I acknowledge country to help answer your question. The reason I'll go back a step. Not that long ago, we saw a terrible thing where we saw people booing at an Anzac Day ceremony from a welcome to country by a veteran, an Aboriginal man. And the thing that really angered and disappointed me after was that all of the debate, particularly in the media, became about whether or not there should be welcome to countries, rather than why were neo-Nazis openly and brazenly attending an Anzac Day ceremony. The reason I acknowledge that I'm on country is because I'm someone that's leading anti-racism work. I'm someone that's experienced plenty of racism, none more so than when I became Commissioner. And all racism, whether it's directed to me or to Katie, results in a denial of equity, dignity and respect. But in addition, the racism that has targeted First Peoples for 237 years has also resulted in a denial of sovereignty and self-determination. And I've benefited from that racism because I've benefited from the taking of land by settlers before me. So it's a very, very small thing for me to acknowledge that I'm on country. But then, flowing on from that point, what is it that someone like me, a non-Indigenous person of colour, wants when we look, and the many, many that are out there, when they look at institutions or systems? They want to be seen, reflected, they want to be safe, they want to be included, they want to be valued, they want to be recognised for their contribution. Why doesn't that happen? It doesn't happen because many of those same systems and institutions were built in colonial times, baked in during the White Australia policy. They were built on the notion that some people belong here more than others and some people are superior to others. Aboriginal and Torres Strait Islanders have been challenging that lie for 237 years. When Aboriginal and Torres Strait Islanders succeed in that challenge, they break open those systems and institutions so that they have to be reformed so that they represent and they reflect all of us. That is why I think that racial justice for First Peoples is so critical. That is why I think truth-telling is so critical. That is why I think the incredible work that my sister here, Katie Kiss, is doing is so important. And that is why I don't think we can ever have racial justice in this country without racial justice for First Peoples.
Thank you. Well said. You handed down the National Anti-Racism Framework, which the government haven't responded to in 18 months. They haven't said anything about it. I met with Minister Anne Ali, who has the framework in her bookshelf, and she told me in a meeting that the framework is not operationalised. It can't be operationalised. What do you say to that? Because it's just sitting there going, well, it's just a doc, can't do anything with it, so what's the point of saying anything about it? That's what she said in a meeting. Are they saying that to you? And what do you say to that?
No, that's not what's been said to me. So in correspondence that I've received, predominantly from Minister Rowland, as the Attorney General is really the minister that I suppose has oversight for the Australian Human Rights Commission. I have written to her, to the Prime Minister, to Minister Ali and to Minister Burke, at least 4 times now I think, asking for them to move on the National Anti-Racism Framework, because I think that racism is a scourge that is intensifying. It's things are being said and done, whether it be in public or online, that may not have been said and done a few years ago. Terrible, racist, violent things. Racist violence is occurring. Of course, we saw the most horrific act of racist violence in the last year in Bondi, but we also saw what almost was a horrific act of violence at Boorloo. It just could have been a lot worse. The response that I've received is that they're considering it. I haven't heard anything about operationalising it. But just to deal with that point, the framework is broad in its scope, but it is First People centred, and it had to be broad in its scope. I mean, if you wanted a framework to eliminate sexism in Australia, you wouldn't expect less than 63 recommendations. We knew that the next step would be critical, implementation of the recommendations, and that's why the primary recommendation was to set up a task force with government, community, the Commission and others represented to work through how to implement the recommendations. And in fact, we have ideas on exactly how to do that, and we are doing it at a state level. I'll just give you one example. Recently, I met with the head of the New South Wales Teachers Federation and the Secretary of the Department of Education of New South Wales, and we have formed a tripartite group to work towards implementing the National Anti-Racism Framework recommendations into the New South Wales education system. It can be done. There just needs to be political will.
Sorry, Senator, so before you proceed to your next question, I understand we've got somebody who's joined us on chorus call, and I just wanted to check who we've got joining us via teleconference.
Tom Benning, Chair.
Oh, great. Thank you, Mr. Benning. Senator Thorpe.
We do have a Libyan out there somewhere. Commissioner Kiss, the Bringing Them Home report from 1997 and Europe Justice Commission both called the removal of our children an act of genocide. As Aboriginal and Torres Strait Islander Social Justice Commissioner, you see what the system is doing to our people every minute of every day. It's killing us. The boot is on our neck and we are dying. Do you agree that what is happening around the country to Aboriginal people fits the term genocide?
Thank you for that question, Senator. So, genocide is broad in its application. I'll clarify, I'm not a lawyer, so I don't have legal background to this, but when I look at the Convention on Genocide and I look at the 5 actions that constitute what genocide looks like, for me, what we see in our communities, the exposure of our people to harm is consistent with the definition of genocide. And I'll go through the 5 elements of genocide under the Convention. The first one is killing members of the group. We are seeing every day reports of deaths in custody at the moment. Our people are dying in systems. Our people are being killed by systems. 2, causing serious bodily or mental harm to members of the group. Our people are dying of suicide every single day. The numbers are increasing. The Closing the Gap target on this one is going backwards. These are systemic responses to harm that's being caused to our people. 3, deliberately inflicting on the group conditions of life calculated to bring about its physical destruction in whole or in part. The removal of our children from their people, that is the separation of us from our communities, our culture. It's destroying our group collectivity. 4, imposing measures intended to prevent births within the group. There's not much that I can say about that one. But 5, forcibly transferring children of the group to another group. Permanency principle in Queensland and the child placement principle wind back in the Northern Territory. These things are all consistent with the definition of genocide under the Convention. Australia has embedded those things as criminal under the Criminal Code in Australia. I think that on the face of it, it is consistent. I think we need to give further inquiry and investigation into what that means for our people. And I suppose just in terms of your introductory comments, Senator, under Bringing Them Home, those provisions were incorporated into the Criminal Code, the Commonwealth Criminal Code, post the Bringing Them Home inquiry. They were not retrospective, so stolen generation members were not able to actually prosecute claims under those provisions. Yeah.
Thank you. Sounds like a royal commission into genocide against this country's first people. Thank you. Do you see the current federal government doing anything that effectively addresses the racism against First People in this country?
One of the things that concerns me, Senator, is that we have a national framework in place under Closing the Gap. Priority Reform 3 under that agreement is to eradicate racism across our governments, across our systems, across services. We're now 5 years into that agreement. There's a requirement for a national accountability mechanism to be incorporated under that framework. That includes monitoring the eradication of racism across all systems, policies, practices, and how they apply to First Peoples. We don't have that in place 5 years into that national agreement, and there's not a lot of evidence in place where action and activity is happening to eradicate racism within those systems. In fact, you know, when you think about here in Queensland, for example, the application of adult crime, adult time legislation, there's a disproportionate impact on our children in those systems. And so when you think about targets to reduce child incarceration, adult incarceration, out-of-home care removals, all of those things that are captured under the Close the Gap agreement, and then we have policy like adult crime, adult time put in place, and the withdrawal and the wind back of the child placement principle in the Northern Territory, how can we say that we're moving towards eradicating racism?
So we have some pretty racist governments in this country, and the NT is certainly winning the gold medal on that one. But this state here is very close behind, and then WA, and then so forth and so forth. The federal government has constitutional power to override these states and territories, particularly the territories. They could, if they chose, make the Aboriginal child placement principle a national piece of legislation and hold all governments to account. Is that something that you would support?
I would support a national approach to the application of the child placement principle. It's a principle that's been developed by First Peoples across the country. It's supported by the majority of states and territories. I think there needs to be government accountability on these kind of principles and agreements and commitments that governments take up. And I feel that with some states and territories hostile to those things, we do need national principles, national standards and national accountability around those things. I've recently submitted my social justice report, A Fair and Just Future for First Peoples, to the Federal Parliament. We recommend on a number of fronts national standards, national accountability mechanisms to enforce basic human rights principles as they apply to First Peoples, including a national action plan to implement the Declaration on the Rights of Indigenous Peoples, including recommendations under the Help Way Earlier report around standards to protect children in damaging systems, including national standards around the investigation of deaths in custody. So, you know, we are trying to encourage and advocate for those things. We're not getting much feedback or support from any of the governments on those things at the moment.
Thank you. Government are good at getting us to write reports and hold inquiries and royal commissions, deaths in custody. We're still waiting for those recs to be implemented. So they like to keep us busy in the paperwork, not like we haven't been telling the colonisers this for over 200 years. I've been calling for an oversight of the implementation of the Royal Commission into Aboriginal Deaths in Custody recommendations for years. My mother was part of that in the early days. I engaged yourself and your predecessor, June Oscar, on the issue because we haven't had oversight of the 339 recommendations for 20 years since the demise of ATSIA. So the government have just like, don't worry about deaths in custody, we're getting away with killing Aboriginal people, so let's not count them. So the Office of the Social Justice Commissioner would be the obvious entity to take oversight of these recommendations. Both yourself and June Oscar were open to having this oversight. I also got the whole Senate to agree that there needs to be an oversight. But I understand you can't do this without the resources that go with it. ATSIA had a whole unit dedicated to the recommendations.
It did.
And I understand that government are not willing to provide the resources to set up this unit. Do you think it's intentional in that if there is no monitoring, then there's no failures to see?
I can't comment on the intent of government, Senator, but it is concerning, and it is disappointing that after over 30 years since the Royal Commission, we still don't have any monitoring capacity. As you said, ATSIC had a dedicated unit to monitor the implementation of those recommendations, 339 recommendations across a broad range of areas to prevent and respond to deaths in custody. Since the demise of ATSIC, there has been no mechanism to monitor those recommendations. We do have the Institute of Criminology that keeps the dashboard on the numbers of people who are dying in custody, but there's one thing to monitor how many people are dying, and the media are reporting on this almost every day at the moment. We are seeing people dying in jails across the country every single day, if not in jails, at the hands of police during arrests, and we've seen that in just the last couple of days. So it is very concerning to me that there is no oversight mechanism for this. As it is concerning for me, there's no oversight mechanism for the Closing the Gap targets, which, by the way, address every single target addresses a human rights breach. If there wasn't a human rights breach in place, those targets would be unnecessary. So government accountability for me is something that's very important. Yes, the Commission has put their hand up to say if we had the resources, we would take that on. There's a question about independence around that. So, you know, that would need to be considered, but the absence of it means that we are not getting any responses. We are not getting independent investigation into deaths in custody, into police engagement into that, into corrections engagement into that, and there's not enough information and care given to the families of those people who have passed away in custody.
Thank you. And we got that one recommendation during the referendum, and that was through my negotiation, and that's all Mark Dreyfus would give us. And it was a slap in the face to the families to count the body bags coming out of the prison system, all these cells, was an absolute joke. And it's, mind you, on the criminology website. So our people who are killed in custody then get their name on the criminology website. Anyways, in 26-27 budget, the Albanese government cut the Commission's budget by over $9 million from the previous year. Can you talk about how you're meant to do your work with a $9 million cut?
Makes it very difficult, Senator, especially when we've got issues for First Peoples that are extensive across every sector of our lives. You know, we have very small teams. We make do with the budget that we have. You know, Gary and I try to work closely together, particularly around First Nations racism, but we can't do it all. And, you know, the state of First Peoples' livelihoods, the state of our existence is reflected in the fact that we don't have those human rights protections in place and we don't have an effective response to that.
The AFL and the NRL do better out of the budget than the Human Rights Commission. Go figure. I'll handball over to Labor if you like.
Thank you, Senator Thorpe. I'm going to go online and go to Mr. Venning.
Yeah, thank you, Chair. I'm sorry I couldn't be there in person today. Thank you for coming in giving evidence. The Commission, just one question for you. The Commission has previously supported reforms to anti-discrimination laws, while also recognising the importance of freedom of expression. How do you believe Parliament should balance protecting people from radical hatred while protecting Australians' right to engage in robust, even controversial public debate?
Senator, this is Commissioner Sivaraman. I'm happy to take the question. I'll just say you weren't completely clear, but I think the question was about the balancing of rights between freedom of expression and freedom from racial vilification.
Correct.
Yeah, thank you. So I think a good example of that is the Race Discrimination Act as it stands. Section 18C provides protection against racial vilification, but Section 18D also has a number of defences or carve-outs to that exemption, to that provision, which provide protection for freedom of expression. I think that the problem is a lack of accountability, particularly online, for what are effectively public comments that are often horrific in their racist violence, where there is no action possible about those comments, and that is a systemic failure in the way in which online forums are regulated. And the second thing I'll say is, ultimately, I've said this before and I'll say it again, I think freedom from humiliation is more important, and racial humiliation is more important than freedom of speech. There will always have to be, freedom of speech is very important. It's an integral part of a democracy. Protest, freedom of speech, are critical parts of our democracy. But with every aspect, with any balancing of rights, there has to be an appropriate understanding of what is the impact of what people are doing on others. So, Senator, I mean, I could go on. This is a big topic that you've raised, but I suppose that's all I could say in terms of general principles.
Yeah, thank you. And it is a big topic, but I think, this committee, this report will provide some level of recommendation in this space. Can you build on where you think the line should be drawn between speech that is offensive or hurtful and speech that should attract legal sanction?
The line is there in Section 18C of the Race Discrimination Act, and I note that we don't actually have similar protections in other legislation. So we've seen Section 18C utilised, and we've now got a pretty decent body of jurisprudence on how it should be applied in terms of the contours between when something is regarded as a breach of that section and when it's not. So in that sense, I don't think you need to reinvent the wheel or actually look elsewhere. You can look at that body of jurisprudence and understand how to apply the balancing of those rights. I actually think that the problem is more so that a lot of public debate now will escape the reaches of 18C, or let me put it another way, people who are the targets of racist violence are not going to be able to use 18C to seek justice, because you can't even get past go by identifying who is the perpetrator of that racist violence online. And that cloak of anonymity is one that social media platforms are more than happy to give because it's in their business interest to do so. Racism is profitable. I mean, it always has been in some senses, but it is for social media platforms. So I actually think the question that should be agitating our minds is, how do we better protect people against the torrent, the unchecked torrent of racist violence that is flowing online?
Thank you. Thank you, Chair.
Thank you, Mr Venning. Ms Cook.
Thank you, Chair. Thanks to both of you for being here today. I want to change the direction of questions a little bit into the work of the Commission explicitly. Can you talk about some of the challenges that First Nations people might experience in trying to make a complaint, from when they first start their process to then all the way through to what would be considered a resolution, and maybe the different types of resolutions that people might expect through that process?
I'm happy to take this, and Katie can add to it. I'm drawing, and the reason I'm happy to take it is just because for 20 years before I was a commissioner, I was a practitioner who utilised the fantastic services of the Human Rights Commission many a time, or defended my clients who were being brought in there. But I think it starts from, well, let me go back a step. For the consultations that led to the creation of the National Anti-Racism Framework, we significantly consulted with First Peoples. We actually went out to remote and regional, hard-to-get communities, consulted with 496 individuals, plus 300 community organisations, both Indigenous and non-Indigenous. And the ability to use complaints processes, including Australian Human Rights Commission complaints processes, was a topic that came up consistently.
Same as in the informing the agenda consultations.
Yeah.
Yeah.
Because, and so the difficulties, the barriers to accessing the service, they're not unique to the Australian Human Rights Commission. They're the same sort of barriers that are faced in any type of service. So, for example, what awareness do people actually have of the process? How accessible is it? Because you can't just do it through a phone call. You've got to fill out a form, which might not be very accessible. Is it provided in language? What sort of cultural safety protocols are there in place for people trying to access these services? If you can get past those barriers and file the complaint, and I just want to put on the record, I think the Commission has a brilliant investigation and conciliation service. They work very hard under very comprised resources. Can you access First Peoples staff or cultural liaison or safety officers, which is a matter Senator Thorpe's raised previously, when you're trying to utilise the Commission's processes? Is that actual form of conciliation one that's culturally safe? And then what remedies can you obtain if in the conciliation process it's only by agreement? If you go to court, courts are heavily constrained. And the reality is going through court is inaccessible to 99% of people. It is a very difficult, expensive thing to do. And thankfully most complaints resolve. So these are systemic barriers that you will see in any legal system or any avenue to justice within Australia that are going to disenfranchise First Peoples. And of course we can do better at the Commission. I don't handle the conciliation service, that's done by the President, but I know he's committed to better access to justice for First Peoples, as is the Commission. And I know that, and sorry Katie, Katie will probably talk to this, but Katie has consistently raised this issue. Do you want to step in and say anything on this? Or?
No, you're right.
Okay. But this requires resources. And you just heard in terms of our funding, it's been reduced. Without resources, it is very difficult to provide a broad range of services that can be accessible for everyone.
Thank you. Just following on to that, when you said about the number of complaints you receive specifically from Aboriginal and Torres Strait Islander people, do you have any data that you can provide to us in that regard?
Yes, thanks. Thanks to Katie just underlining it.
That was very, very smooth between the two of you.
So I'll just read it out to you.
Yeah,
So the period,
sure. Thank you.
the period of 2017 to 2025 saw increasing numbers of complaints from First Peoples to the Commission. In 2025, there were 523 complaints lodged at the Commission under the Race Discrimination Act. 17% of those were lodged by First Peoples. And the number of RDA complaints made by First Peoples peaked, perhaps unsurprisingly, in 2023 at 119. But it is, in an overall sense, risen from 56 to 89 between 2017 and 2025. And in a general sense, the greatest number of complaints by the greatest area within which First Peoples are making complaints, when you consider you can do it under the race, sex, age, discrimination acts, is a disability, of course, is under the Race Discrimination Act. I should just note of caution, the proportion of people that make complaints is a microcosm of those that are actually affected by racism.
Yes.
It is a very blunt instrument to measure the incidence of racism in the community.
Yes. So on that topic, what do you consider the strongest evidence that racism is increasing rather than simply being reported, as you said? You know, what do you feel is the best examples of that?
Well, we can probably both talk to that from. Do you want to go first? Or me? Okay.
Visual space.
Yeah. Tag teaming it. So the first is consultations. I mean, as I said to you, we engage with our team with 496 First Peoples for the preparation of the National Anti-Racism Framework, and consistently people said that particularly the voice referendum in particular just mainstreamed racism online and not online towards people. Secondly, it's in the reports that we've prepared when we've done a number. We've done reports on racism in the health sector, which shows lack of access to health, lack of cultural safety for the First Peoples in accessing health services is a very significant issue. Put very simply, racism is making First Peoples sick, racism is stopping First Peoples from getting better, and sometimes it's killing them. In other work that we've done in terms of racism online, we've seen, we've again in our consultation, we've heard of a stark increase, not only in how much of it, but in just the punitive violence of it, the unashamed violence of it, the lack of fear of any consequence for the violence online. And myself personally, and sometimes with Katie, I've tried to engage as much as I can with communities all around Australia, from Perth to Darwin to everywhere, with First Peoples, with Indigenous communities, and racism and the lack of action and the consistent impact on their lives continues to be raised as a significant issue. So I'll just finish with this last point. The fact that you've had to ask, well, beyond this, what is the evidence of racism, is actually indicative of a very significant problem nationally, which we called out in the National Anti-Racism Framework. There is no comprehensive national method of collecting data on racism. There is no national prevalence survey. We just completed a historic study into racism in the university sector, which surveyed 76,000 people, and over 80%, I think it might have been nearly 90% of First Peoples staff and students who were surveyed reported experiencing racism. So if you just take that sector on its own, that alarmingly high incidence of racism, and extrapolate from that, you can say it is a real problem.
Senator, if I can just add to that, I started earlier talking about the Close the Gap targets, and I talked about the fact that each of those are a human rights breach. The fact that First Peoples are not improving in each of those areas is a sign that racism is in existence, because we're not equally accessing human rights outcomes compared to the rest of the population. During my Informing the Agenda consultations, we did 41 engagements across the country. We spoke to more than 1,600 Aboriginal and Torres Strait Islander peoples. Participants at every consultation spoke of racism, spoke of concerns about our children being treated differently in child safety and policing systems. The E-Safety Commissioner found a rise of more than 10% in online abuse complaints from First Peoples in the lead up to the referendum. The Reconciliation Australia's 2024 Reconciliation Barometer found that 54% of First Peoples reported experiencing racism in the previous 6 months. In 2004, that figure was 39%. And we've also got the Call It Out register. So we do have a number of disparate mechanisms for capturing racism. You only have to go online and read a first person's post to see the barrage of hatred and vilification and extreme racism that comes back at you. And I had an experience of that myself personally over the weekend. I had thousands of people coming back and challenging an experience of racism, saying I was a liar, I'd made it all up, chill out, those kind of things. Like the mental toll that takes, the physical toll that takes when you're an Aboriginal person trying to tell your story and having that discredited constantly, exposing yourself out in the street. You know, we've seen mental health rise in our community exponentially. So we don't just need to look at these kind of measuring opportunities to see racism. We don't just need to go online. The closing the gap targets are the indication for us that racism is increasing. The fact that we've only got 4 of those targets that are actually improving out of 15, and that has been the case since the closing the gap agreement started, mind you. Those same 4 targets have been the only ones that have seen improvement in the 5 years since the agreement started. Gives a clear indication that racism is on the rise, that we're not dealing with it, that we're not addressing it, and policies, practices, laws, and the application of how we live our lives is harmful.
Just in a final question, we are in Queensland today. Are there any things that have happened over the last 12 months, specifically in Queensland in relation to the Queensland government? We've talked about the Northern Territory government, that you're concerned about?
Absolutely there are. As the senators would be aware, prior to me commencing in this role, I was the Executive Director of the Interim Truth and Treaty Body. We spent a number of years pulling together the Truth and Treaty legislation here, the Path to Treaty Act in Queensland. We had full endorsement from the opposition at the time, the Liberal Party, to that legislation. The first action taken by the Liberal government when they were elected in this term of government was to repeal that legislation. So, you know, on the back of the referendum, there's been a perception that rather than just being confined to a representative structure for First Peoples to participate in decisions that affect them, there's a perception that all the rights of First Peoples now are dismantled, non-existent, irrelevant, denied, and that is being seen in the application of policy and practice across the country, but here in Queensland in particular, with the dismantling of the Truth and Treaty legislation. We've seen child safety legislation going into place, so youth crime legislation, adult crime, adult time, rather than seeing investment into preventative mechanisms that support children's development, that support positive pathways for children. We see jails being built. We see bail being denied. We see existential numbers of First Nations children being held on remand in prisons. That is very concerning for me. In the last 12 months, we have seen the dismantling of Queensland-based representative structures. So across almost all portfolio areas in government, there are Indigenous advisory committees established to help provide input and advice to government on how they direct, deliver, develop Aboriginal and Torres Strait Islander policy, law, practice. The majority of those representative structures have been dismantled. We have seen the dismantling of the Indigenous Health Deputy Director's position held by Haylin Grogan. We've seen the dismantling of the Indigenous Deputy Director General of Education, Philip Brooks's position, dismantled. We've seen under the Queensland Family and Children's Commission here in Queensland, the non-extension of the Indigenous Children's Commission here in Queensland. And so that position now apparently is sitting vacant for 6 months, while a review happens into the QFCC that will predictably result in the dismantling of that position. You know, we're seeing the dismantling of all of that. So under the Declaration on the Rights of Indigenous Peoples, we have a right to self-determination, we have a right to participate in decisions that affect us, and in Queensland, all of the mechanisms that assist in facilitating that are being dismantled.
Thank you.
Cool.
Mr. Smith.
Thank you, John. I guess a three-part question. So from a practical standpoint, how would someone engage with the Australian Human Rights Commission? What does that process what would that feel like? What is it going to be like as they go through it? What does an outcome look like in terms of a resolution? And how many actual resolutions with a formal finding for Aboriginal and Torres Strait Islander people would we come across, say, per year?
Yeah, so I'm happy to deal with that, and then Katie can supplement. The first is engagement shouldn't be seen narrowly. So the Commission actually has a lot of different aspects to it. There is, of course, the complaints handling function, but there is also an education team who do a lot of work in terms of race, gender, disability, education. There's a wealth of resources on the Commission's website, which has been relaunched. And I'd encourage people to go there and have a look. It's actually very well visited and utilised. But I think what you're getting towards is the complaints process. So in terms of the complaints process, I mean, the nuts and bolts of it is you've got to actually fill out a complaints form, submit it. It has to be assessed by a member of the Investigations and Conciliation Service. They don't determine the truth or not of a complaint. They can't. Only a court can do that. They determine whether or not, if what you've said was to be true, would it be a breach of whichever act you're complained about. If it could be, they can then invite the parties to a conciliation process. If it resolves there, great. If it doesn't, then they'll usually issue a certificate saying this couldn't be resolved and the person can go to court. In terms of outcomes, the thing is, it's actually really difficult to answer that part of your question because most of them are confidential, if nearly all. So in a de-identified sense, there are some that are reported. There's I think a smattering that are cited in our submission. Discrimination against First Peoples in employment, in the provision of goods and services, in education. And you'll see that generally it just says it was resolved with compensation being paid, perhaps an apology as well. And I think that, and sorry, I know this isn't, I think it is relevant to your question. That's answering the three parts. But what that also shows is how it's difficult in an individual-based service to make systemic change. Because if a matter's going to resolve with compensation or an apology to a person, that doesn't change a system of injustice. Now, there is provision for representative complaints, and that has been utilised by First Peoples, particularly representative complaints, that is where a group comes together and says we've all been affected by the same thing, particularly against police injustice. And we've seen there's been a few representative complaints challenging the way in which police have acted towards First Peoples as a group. But they're not, again, that requires resources and effort, and that's a sort of a rudimentary vehicle to try and bring about systemic change. So the complaints function of the Human Rights Commission can only ever be one of many levers to bring about systemic change. Really, I think the most significant, from my perspective, and Katie will have hers, is implementing the National Anti-Racism Framework, because that is a whole of government, whole of society roadmap to tackling racism. And one of the recommendations specifically was an implementation plan, a First Peoples implementation plan, separate to a non-Indigenous implementation plan, to see whether or not systemic change was being brought about to eliminate racism towards First Peoples. That's what we need.
If I can just add to that, Senator, there are three elements missing in Australia's human rights puzzle. A National Human Rights Act, and so we don't have the embedding of human rights across into Australian domestic law. So the protections are not where they need to be at this point. The second one is the full implementation of the Declaration on the Rights of Indigenous Peoples. We've called for a national action plan on that, and we've also called for an audit against all Australian legislation, policy and practice to make sure that they are consistent with the Declaration on the Rights of Indigenous Peoples. The Australian government has endorsed the declaration. It hasn't yet been addended to the list of human rights commitments that are in both the Parliamentary Scrutiny Act and the Australian Human Rights Commission Act. So there is no obligation on governments to assess against the declaration when they're developing policy, law, practice for First Peoples. And the third one is the national implementation of the National Anti-Racism Framework. So those three things together would create the conditions for government to be accountable to First Peoples on ensuring that they are not exposed to racism across all aspects of their lives.
And that would be the best methodology, in your belief, to deal with systemic racism within health systems, judicial systems, policing, that kind of thing.
I think that it creates an accountability framework for people to measure themselves against, and at the moment we're not using those accountability mechanisms effectively to make sure that we're addressing racism.
Cool, thank you.
Thank you, Mr. Smith. Just following on from some of your comments, you mentioned lots of the outcomes that you deal with where it's kind of resulted in a resolution has ended up in is confidential. One of the big pieces of, also one of the consistent things that we've heard from people through this process is one of the challenges that people find in reporting racism, or whether they decide, when they're making a decision about whether to speak up or not, is that there is rarely any visible consequences for people who are the perpetrators of racism. Do you believe that that needs to change? Like, talking about the confidential nature of the matters that you deal with, essentially people can be racist without any visible consequence or harm to them, but First Nations people bear all the harm from the impact of it. Wondering if you've got a view or thoughts on how we can address the visible consequences part that stops people from speaking up, and I think continues to enable people to be racist without any consequence.
Yeah. Are you happy with me? Yeah. Yes, thanks, Senator. That's an excellent question. The first point is that most often the person that is the target of racism, that calls it out, suffers more than the alleged perpetrator. As Katie just pointed out, they get gaslit, they get denied, they get subject to further racism. There's no accountability. The difficulty is when you place all the onus on the individual to try and bring about the change. If you want systemic change, there is an example, a pretty good one, of how you can do that, the Workplace Gender Equality Authority, because it is only workplaces, but within workplaces that requires employers to report on how well they're doing on gender equity, both in terms of representation and pay. So it's a public process which puts the onus on the institution to report on how it's doing. So that's one. If you had something similar in terms of First Peoples and racism more broadly, some sort of public authority that where people had to report, employers had to report, and then it was published, I think you would see far more change, because employers and bosses are going to be worried about reputational impacts. They're going to be worried about how they look. The second is, and we've called for this consistently, the Race Discrimination Act turned 50 last year, and when it was made, and still as of me speaking to you today, the onus is on individuals to bring complaints. There is no positive duty in there for employers or the providers of goods and services to take steps to eradicate racism. Again, if you want structural change, you put it on the leaders and the people that are running those systems and structures to bring about the change, rather than on the onus on the target of racism, who's usually under-resourced and traumatised, to try and tackle a system.
Certainly the positive duty of care has been raised through this inquiry. It's something that the committee is taking a good look at, and people have talked about the positive impact of the duty of care stuff around the sex discrimination in workplaces. With the couple of minutes that we have left, I want to go to Meta, who is appearing next on our program. You talked about the online harm that our mob experience. It is, through this inquiry, certainly a substantial part of the evidence that we've received is the intensity of the hate and violence that our people experience online, with what seems to be little to no moderation to protect and keep our people safe. And we've had some harrowing evidence about the impact, particularly on kids. What would you, using, like, from your position, I'm wondering what you think the practical things that a corporation, a company like Meta, has the responsibility to do to keep people safe?
Yeah, so I'll say the same thing I said before. and I'll start with that, but then I'll go to what they could do. So racism is profitable. It's profitable for Meta, it's profitable for others. It gets eyeballs onto their platforms. It means people don't get challenged. And in fact, from what we've seen, they're enabling that by getting rid of fact checkers, by getting rid of accountability measures, by making the capacity to report really difficult and our responses really slow.
In fact, there's no racism report at all.
There you go, case in point. One of the things that the Commission has advocated for and is continuing to advocate for, and through my colleague Commissioner Finlay predominantly, is a digital duty of care. We need to combat mis and disinformation. At the heart of racism is often mis and disinformation, racist tropes and stereotypes that are grossly untrue, demeaning in their nature. And if you don't combat the mis and disinformation, if you don't create an onus to do that, you can't really, it's really difficult to challenge the racism, the torrent of racism that's lying online. So I think a digital duty of care could go some way towards that. There have to be other structural issues, other structural remedies as well, in terms of there's got to be some way of strengthening accountability and transparency for what actually happens on these platforms. It's very difficult to know. It's very difficult to know what steps are taken. You can see the corporate spin, but we know from all of our consultations the reality is very different to the spin. The reality is horrific for many people.
In a jurisdiction like Victoria, I don't know if you've seen what they're doing there, which is they're moving to the unmasking, like getting rid of some of the the fake accounts that people can hide behind. Is that something that you see as being useful in this space, or? And then my other question, just continuing on from what you said, is you talked about duty of care. What are the things that need to be in the duty of care, a digital duty of care?
Yeah,
they're two very different questions.
Yeah. So to the first point, yes, I did see that. I should just say this is an issue we haven't discussed yet at the Commission level. So
if you want to take it on notice and have some more thought about it, you're very welcome to as well.
On both of them, it's probably worth taking on notice to the extent that I do want to consult with my colleague, Commissioner Finlay. I'll just answer the first one generally. Anonymity is clearly the cloak that allows people to do and say the things they would never do if they had to look you in the face. Not completely. There are some people out there who will just say anything anyway. As to the digital duty of care, perhaps that requires quite a long answer, and perhaps if I could take that one on notice so that we can give you a more thorough response, Senator. And if there is time, I wanted to say one last thing. But
we've got 2 minutes.
There you go.
I just actually wanted to come back to Senator Thorpe's question right at the beginning and just explain something. What we want is fairness. What everyone wants is fairness. Everyone wants to be treated fairly, to be treated equally, to be treated with respect and dignity. Racial justice for First Peoples is a way to do that. It's because if you make systems and institutions transparent and responsive and accountable, that helps First Peoples, it helps people with disability, it helps people who are gender fluid, it helps people of different class, the thing we never talk about in our society. So action on racial justice is actually a way of bringing us all together and lifting all of us. Nobody gets left behind. It's not about someone missing out and someone else getting something. It is actually a platform in which to bring us all together and to make all our lives better. I just wanted to finish with that. Thank you.
Thank you very much. That concludes the time we have for you this morning. Flagging, you probably will get some questions on notice from this committee as well, and you've taken some questions on notice. If you could please forward it to the Secretary by the 18th of August, we would be grateful, and you'll also receive those from the Secretariat too, and as is usual, you'll be sent a copy of the transcript of your evidence and you have an opportunity to request corrections to any errors that you see there. Thank you very much. We will suspend very briefly while we welcome our next witnesses. I now call on representatives from META to give evidence. For the Hansard record, would you please state your full names and the capacity in which you appear?
Hi, my name's Mia Garlick and I'm a Regional Director of Policy for META.
Good morning, Cheryl Cito, the Head of Policy for Australia, New Zealand and Pacific Islands.
Thank you very much. But although the committee does not require you to give evidence under oath, I should advise you that this hearing is a legal proceeding of the Parliament and therefore has the same standing as proceedings of the respective houses. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege and is being broadcast live on Parliament's website. You can see from our nameplates at the front of us who is joining us today in the room. Also noting we have the Deputy Chair, Mr Venning, joining us via teleconference as well. I'll now invite you to make a brief opening statement.
Lovely, thank you, Chair. And if I can just apologise in advance, I've got a slight head cold, so I apologise if I sniffle in parts of this, but I mean no disrespect. And I will also keep my distance so that I don't get anyone else here sick. But first of all, thank you, Chair, Deputy Chair and committee members for the opportunity to appear before you today. We mentioned, I'm joined here by my colleague Cheryl Cito, and I wanted to begin by acknowledging the Turrbal and the Yagara people, the traditional owners of the land on which we meet today, and pay my respects to elders past, present and emerging, and also extend that respect to any First Nations policymakers who are appearing before this morning and any other First Nations people who are present here or watching online. We have followed the testimony that's been given to this committee across its hearings, and we acknowledge the experiences and concerns that have been shared, particularly by First Nations people who've been directly impacted by online racism. META also understands the concerns about the role that digital platforms can play with respect to racism, hate and violence. And we understand too that there are growing and specific concerns about racism, hate and violence directed at Aboriginal and Torres Strait Islander people, particularly in the light of the recent distressing events in Perth this year and in Melbourne last year. So I thought it might just be helpful to sort of frame our discussion here today by giving you some background context on three areas of our work. So first is with respect to our content policies, second our work with respect to the 2023 Voice referendum, and thirdly our work with First Nations organisations and communities in Australia. With respect to our content policies, we are committed to ensuring that people can use our services safely and positively, and we recognise that we have a particular responsibility when harmful content targets communities that are already experiencing systemic disadvantage. Our content policies have been developed and evolved over many years, and they're informed by input from our community, external experts, civil society groups and regulators around the world, including here in Australia. We enforce these policies at scale using a combination of advanced technology and human review, and we publish our results transparently each quarter so that the public and policymakers can assess our progress. In our experience, there are a number of aspects of our policies that protect Indigenous communities from online harms, and these include our hateful conduct policy that prohibits attacks on people based on protected characteristics, including race and ethnicity. Also our bullying and harassment policy that's designed to protect people from targeted abuse, intimidation and degrading conduct. And finally, our dangerous organisations policy that prohibits terrorist organisations and organised hate groups from using our platforms, and we remove content that glorifies, supports or represents them. In META's latest transparency report for Q4 2025, for example, we disclosed that we'd removed 1.3 million pieces of content on Facebook and 1.3 million pieces of content on Instagram for violating our hateful conduct policy. We acknowledge, however, that these numbers reflect a global scale and may not always match the experience of different communities every day, and that's something we're committed to improving on. With respect to the Voice referendum, we certainly recognise our responsibility during significant civic moments, and in the lead up to the 2023 Voice referendum, we took a similar approach to content integrity as we do for a federal election. So that means that we stood up a cross-functional group 5 months before the vote to identify and mitigate risks. And when we became aware of hateful conduct targeting Indigenous Australians, including harmful stereotypes, we took action. We expanded our Australia-specific slurs list. We created specific policy guidance for content reviewers, and we worked to remove a significant amount of violating content. We consulted with our Australian Combating Online Hate Advisory Group, which includes First Nations representatives, and partnered with the Youth Mental Health Service Reach Out to support the social and emotional wellbeing of First Nations people through the referendum. We also provided a funding boost to our third-party fact-checkers to increase their capacity and coordinated with the Australian Federal Police and the Australian Electoral Commission. And lastly, before opening up to questions, we also work to support First Nations communities in Australia, both within our company and through external partnerships. So internally, our teams work to raise awareness around key cultural moments, so making sure that as a team we're recognising National Reconciliation Week, NAIDOC Week and other significant dates. And our facilities team actively identifies and supports First Nations owned businesses, not only featuring them within the office, but also going on to make sure that some of them become our regular suppliers. Externally, in recent years, we've partnered with First Nations-led organisations including Indigitech and Awesome Black to create First Nations augmented reality content for Instagram. We've supported Indigital, Australia's first Indigenous edutech company, to create immersive tech training for First Nations communities, and supported the Awesome Black Creator Hub for Indigenous artists in Sydney. So I hope that that's some helpful context, and look forward to your questions.
Thank you very much for that opening statement. We'll proceed to questions and begin with Ms. Gork.
Thank you. Thanks for coming today. I have a lot of questions for you, and I suspect we all do. But I might just start with how does this all work in terms of Meta? In terms of, you've talked about the moderators, you've talked about the cross-functional group that you created specifically in response to the Voice. You talked about the slurs list. So there seems like there's a number of different mechanisms. We know that people can report things themselves, but can you talk us through, for example, what each of those tools does and how it does it? Can you give us some specific examples? And if you have any Australian data on what sort of numbers you're picking up through those mechanisms, perhaps, I don't know if you've got it with you today or it's something that you can bring to us later, perhaps on a monthly or weekly basis.
Sure. Maybe it's helpful to sort of start by how we think about it conceptually. So the bedrock, the starting point is our policies. And so we work to have policies that we do need to iterate over the 20 years that we've been developing our content governance and integrity systems, because what's happening in the world changes and technology changes. And so we publish those and they're quite specific in terms of outlining where we do and do not draw the line in respect of those 4 areas of the policies. I mean, there's 24 policy areas, but there are 4 that we wanted to highlight for this committee because we think they're the most relevant to your work. Then there's how we enforce those policies. And so some of that is through these operational teams that I mentioned, who will receive user reports via the platform and then assess that content and remove it or take action against an account if there's been a violation. There are some areas of our policies where there is automatic detection, and so that will then run, and sometimes it will be where there's like a high probability that it's definitely violating, so a fake account or a known piece of terrorist content or organised hate content, then we'll automatically apply the strike or the action. But if it's unclear, it will be surfaced up for the human reviewers. So that's the enforcement bucket. As part of that, there is the slurs list that I mentioned. So we recognise that we need to have moderation and the application of policies in ways that are locally relevant. And so we have a market specialist team that's responsible for Australia, and we work together with them to make sure that they can apply those policies in ways that work for Australia. And then we have sort of additional tools and additional partnerships and awareness campaigns, if that makes sense.
Yes.
So hopefully that's helpful.
And region-specific data?
We don't have region-specific data at this time, and I think I recognise I was giving you numbers from our global transparency report, but we don't break that out into region-specific data at this time.
Would you have any specific data in relation to First Nations people, Australia, or?
I don't think that we would necessarily sort of in the regular course of our business have that data. I think in relation to some of our election reports as part of our transparency reporting under the Misinformation Code, we have given data about hate speech in Australia or certain types of content removals, but they're not broken out depending on the different protected communities. Yeah, that's right.
Okay. And how does that all work when you then look at the algorithm and how content is amplified, and particularly racist content? We just heard from the Human Rights Commission that I think I actually wrote it down, that racism is profitable. So from a meta perspective, how does your algorithm work in terms of interacting with those policies?
Of course. So I think it's really important to understand from our perspective, we're trying to provide services that people find valuable and that they want to use. And also we're trying to provide a business that advertisers want to advertise on our services, and neither of those two groups of people want to experience harmful content on our services. There's been a number of instances over the history of our platform where we've had advertisers undertake boycotts because of concerns around hate speech. So it is absolutely not in our business interest to be promoting or providing a service where people are experiencing harmful content. So in relation to, so maybe I can sort of talk generally about the algorithm and the different algorithms that exist and how they operate. And then I can talk about some of the measures that we take to try to make sure that we're not exposing people to content through that. So there's a range of different algorithms. So the first is a ranking algorithm. So, you know, you might if any of you have used any of our services, you might use the service for a number of years and build up a number of different contacts, but you might not want to see everything from all of your contacts over the years every time you log in. So there's a ranking algorithm that will kind of rank the content by your connections to try to identify if you might find that useful or interesting. Then increasingly, online services are connecting people to unconnected content. So that's content that you haven't, liked or followed that we think you might be interested in based on a range of different signals. And then there's the security and safety algorithms that are trying to downrank harmful content and trying to, make sure that there's a, low value content isn't being served to people. So in terms of trying to make sure that we're not promoting harmful content, obviously there's the work to enforce our content policies to try to make sure that this content isn't on our platform to begin with. And then there's the content distribution guidelines and the recommendation guidelines, where we have additional policies to try to outline what type of content will be downranked and what type of content we won't recommend, to try to avoid it being a harmful experience. And then where we don't get that right, we have a number of on-platform tools to provide transparency to people about why they're seeing content, and also to send feedback to us if they don't want to see particular types of content. So we do try to create an ecosystem where we're trying to continue to provide valuable services.
Can you tell us about your moderators? Do they undertake, for example, anti-racism training? What's their training or qualifications to make these determinations about what is or isn't racist? I know that you talk about hate.
Yes.
But do you have specific training for those moderators around specifically racism?
Yeah, I think the best way to think about it is that the policies really are what sort of govern how the moderators will apply the policies. Obviously, everyone's trained to be the best that they can at their job. But for example, with our policies that are set, we have people who are expert in a range of different areas. So some are former prosecutors or lawyers, or they've been working for civil society groups, and they will sort of be responsible for key parts of the policies. And then where we identify the need for a policy change, for example, or we're starting to see a trend and we think we need to adjust the instructions to the moderators, we'll work with different expert groups around the world. So that will be academics, that will be different experts, that might also be local community organisations, to kind of get their feedback on where and how we can make a policy change that addresses the concern. And then once that policy is set, then we provide implementation instructions to the moderators. So whilst, yes, they will absolutely be trained in a wide range of the areas that they cover, that they really are trying to implement a policy in a consistent way. And so I think in terms of trying to answer your question, the focus really needs to be on the process that we have around the policy development and updating work.
So specifically for Australia, there is no anti-racism training for your moderators.
I wouldn't say that we have specific anti-racism training for Australia, but there are within the hateful conduct policy area, bullying and harassment, the dangerous organisations policy, and within areas that are trying to prohibit graphic and violent content, how we work to protect people based on protected characteristics, including First Nations communities in Australia, is part of the considerations that will go into where those policies are set and how they are updated to try to protect people on our services.
Are the moderators in Australia?
No, they're not.
None of the moderators?
None of the moderators.
And none of the moderators are Australian?
Some of them are Australian.
But located
elsewhere. Yeah, and
are any First Nations people?
Not that I'm aware. But just to give you some context about why we try to co-locate people, we just find, just from a support perspective, but also from a consistency and training perspective, it's better to have people sitting together so that, as new issues come up or there are questions, then it can be sort of like it's a more consistent standard if we have people co-located together. So that's why we've tended to try to place people in the same offices when they're making decisions on moderation.
And do you have any advisory groups or individuals who are First Nations people?
Yes, so I mentioned the online hate advisory group. I'm not sure if you want to share more about those.
Yes, we have an advisory group in Australia that is a combating online hate advisory group that we established around 2019-2020. That is a group that is comprised of a mix of individuals. Some of them are representing specific communities from across Australia, including First Nations communities, LGBTQI+, youth, and Jewish and Muslim communities. We also have within that group a number of experts who are academics or researchers in areas including hate and preventing violent extremism. And we meet with that group once or twice a year and really draw on their expertise and advice as we sort of work to make sure that we're applying locally appropriate enforcement on our policies.
Do you have a written definition of what is racist?
So I think with our policies, and this is what I was trying to allude to, 4 different areas, we've got a definition of what is hateful conduct. And so that is conduct that is targeted at people based on protected characteristics, including race and ethnicity.
And what definition do you use for that, for race and ethnicity?
All races and ethnicities, I think. I'm happy to come back to you with more details if I can elaborate on
Get
that.
the policies on those.
Yeah,
Like, is it Donald Trump's, or like, where does it come from?
So we've built it up over many years, and we've tried to consult with a large group of people to try to make sure that we're understanding, for example, international human rights definitions and things like that. But I guess I can understand very much the focus on hateful conduct, but in terms of some of the negative experiences that First Nations communities or different protected vulnerable communities can experience, we do find that a number of policies work to protect them. And so what we try to do is look at some of these international definitions or human rights definitions and try to make sure that we've sort of encapsulated it across a range of different areas.
Thank you. I'm going to Senator Thorpe's objection. I'll take the opportunity to rotate the call and go to Senator Thorpe.
Thank you, Chair. Could we get on notice who that advisory group is and who the Aboriginal person is representing Aboriginal communities in this country, please?
Yeah, we can take that on
Thank you.
notice.
How does META contribute to systemic, structural and interpersonal racism against the First Peoples of this country?
Well, I think from our perspective, we're trying to provide services that are valuable and useful to people. And one of the pieces of feedback that we've heard from Indigenous communities is that often they find online services helpful because it provides them with an avenue for connection, community and representation that they maybe cannot find in other fora. And so that's why, we've had a long-standing commitment to try to make sure we are understanding the issues and concerns and can try to tackle harm to try to prevent our services from further,
Sorry,
contributing
everyone
harm.
has trouble with this question. I want to know how you're contributing, how your organisation is contributing to the harm against First Peoples in this country. I want you to say how it's harming us. I don't want to know about what you're trying to do and you've got your one little black fella on your advisory and you might listen to them twice a year, may not. I want to know how you're contributing to the harm. That's what I want to know.
Yeah, sure. So I think obviously it's not the intention, so we'll just take that as given. The feedback that we've had from Indigenous community groups is that there can be issues and challenges where there's where there are comments in groups or where there is content that is shared that is triggering and harmful and, perpetuates harmful stereotypes. And so that's why we have the policies that we do. That's why we have the connections that we do to try to make sure that we can work with our teams and try to take action against that kind of conduct or content so that people are not experiencing that.
Okay, thank you. How much does Meta profit from this harm? You can take it on notice and bring back your accounts, but how much do you actually profit? Because it's very profitable to be a racist in this country today. Go to my Facebook and have a look at that. And you'll see threats every day. You'll see constant abuse to my life as a black sovereign woman. So how much do you make from that? Or Zuckerberg, how much does he make from our misery that we see on Facebook? Yes, people use it to communicate, but there's violent harm. So how much do you profit from that?
Well, in terms of how Meta makes money, obviously that's through selling advertising, and advertising is not connected to the type of content that's there. But I think, as I mentioned in some of the responses to the earlier questions, it's actually against our business interest for there to be harmful and hurtful experiences for people on our services. We've faced numerous advertiser boycotts from this, and that's why, even if you have scepticism around, our desire to provide useful services for people, it's also not in our business interest for our people to be experiencing this on our services. So that's why we invest a lot in trying to make sure that people don't have those experiences. And I have seen some of the testimony, Senator, about some of the threats that you've received, and we're very happy to work with you and your team because there are a number of additional... Well,
the AFP are after the one in the US that Meta won't release. So you might want to release that to the AFP so we can progress the Nazis who put it up. So that's one thing you could do. But so can I just give an example? So if someone does a AI generated thing and then there's advertised like a racist meme through AI generation and then there's advertising that comes from that, does your policy shut that off because it's advertising under false pretenses?
So it doesn't matter whether it's created by humans or AI, our policies still apply regardless. And so if content is on the platform that violates our policies, then it should be removed. And if there is advertising around that is targeted based on the the individual, because so when advertisers run a campaign, they say, I want to reach all people who are aged, 25 to 35 who live in Darwin, for example. And so that's the basis for the targeting. There are additional rules that apply to any attempts to use AI-generated images for advertising that I'd be happy to share with you as a follow-up. So we do try to have some protections around that.
Thank you. Clearly, it's good that you've turned up, because you're facing the music, basically. But you can say whatever you like. It's clearly not working. So given it's not working and the rise of racism, hate and violence against the world's oldest living culture on the planet. They tried to wipe us out here through racism, right? When they rocked up on their boats, they came to wipe us out. They failed. So they're continuing to try and wipe us out. What are you going to do given everything that you've talked about doesn't work? What else are you going to do?
Well, I mean, I would like to think that a lot of the work around making sure that our content policies are up to date, that our enforcement is effective, and we have small things that won't seem significant in the broader scheme of things, but for example, as you mentioned, comments, we've got a new program that we're trying to run because we have heard feedback that a lot of Indigenous organisations are experiencing a lot of hate through comments, so we've got new initiatives that we're trying to roll out to support people through that.
Talk about those.
Sure. So there's different tools like the Moderation Assist tool. I did see in some of the testimony before this committee, I can't remember which organisation it was, said that a lot of the low value or hateful comments were coming from accounts that didn't have a profile picture or had sort of things that made them look low value. The Moderation Assist tool is something that we've developed over the years that will automatically block those types of accounts from being able to comment on a page. We know that sometimes there's issues. For example, if there's a particular thing that happens in an AFL game, there can be a pylon on a particular player. We've developed the limits tool that will stop people who haven't followed that account before from being able to connect with it. So there are a number of things that we're trying to do to try to create these safe spaces for Indigenous representation and voices. But I also think, as there's increased use of large language models for content moderation, we're in the early stages of testing and iterating that and evaluating that for efficacy, and we're hopeful. I mean, we've seen some of the testimony before this committee that suggested that sometimes we were getting it wrong in terms of when we were taking down content that was trying to bear witness. We're optimistic that the use of LLMs will allow more nuanced and contextual decision that can then make account for some of these very complex nuances so that Indigenous Australians can bear witness to some of their experiences without feeling like we're imposing policies that are disempowering. So I think there's a lot more space, and I think that's why ongoing dialogue and collaboration together can be helpful and hopefully a reason for optimism.
Well, on that collaboration together, you've got one Aboriginal person for the whole country that advises Meta twice a year. Do they live here?
I think it's more than one, but do you want to explain a little bit more about our work with Indigenous communities?
Yeah, sure. So we have the advisory group, Senator, and they are Australia-based, and we can provide on notice more details about the group itself. But we have also done a number of other partnerships as well with Indigenous organisations, which Mia did mention in her opening remarks. So I'm happy to talk more to those as well. So it's a broader group of organisations, including Indigitech, Indigital and Awesome Black, and we've consulted with those groups. Also, just as an example, I think you did question whether the way that we have taken into account the advice that we receive from the advisory group, and one which Mia alluded to, which I can elaborate on a little further, is a project that we're working on at the moment. It's a new one that has really, in response to feedback that we have gotten from that Combating Online Hate Advisory Group over the last sort of, I think particularly the last 6 to 12 months, which is that the social media managers and content moderators of community organisations, including First Nations community organisations, do experience quite unique challenges in that they are often navigating and having to moderate and deal with content that may be hateful and offensive towards their own community and their own identity. And so really recognising that, we are partnering with one of our long-standing youth partners, Project Rocket, to set up a new program which will work particularly to provide support, training, resources and a place to sort of community to come together and share experiences about navigating those roles and how to connect with the tools that and make the most out of some of those tools that Meta has built to give those organisations more control over the content that they're engaging with on their own platforms.
It's really putting the onus back on the victim though, isn't it?
It's intended
all the perpetrators get to make money, and
it is intended to be in addition to the policies and the enforcement that we have in place, which Mia's responded to, and also really responding to feedback that we have gotten that it is important to provide additional tools and to try and empower and train these particular individuals.
Is there any thinking around having Aboriginal people provide advice on a more regular basis? And I'm sure there's bodies in this country of Aboriginal people that could do that, rather than, you know, a few businesses here and a couple of advisory people there, which would be very difficult as Aboriginal people when you're dealing with if you're gay and you're got a disability and you're black. You know, we tick all the boxes. So to sit with an advisory body that has other vulnerable groups makes it even more difficult for us to get a say sometimes. So is there any thinking around having a dedicated national body here that we can go to as consumers, then could provide the evidence and the feedback to Meta to have it rectified in a more timely manner and a more comprehensive manner? Is that something that you could?
Yeah, we've certainly changed up how we've tried to engage with different Indigenous academics and organisations over the years, and we've tried to be mindful of what you've sort of alluded to, that sometimes trying to ask for advice and assistance can add to the burden. So always happy, and we'll look at the recommendations of the committee with interest to see how we can continue to iterate.
If it were a recommendation, would you support it?
Well, sure.
Resource it?
Yeah, I mean, it depends how it's hard to commit to things that we haven't seen, but I mean, certainly I hope that you take from our statement, we do take these issues very seriously, and we're working to make sure that we're continuing to evolve and be responsive to the issues and concerns of Indigenous Australians.
Thank you.
Thank you, Senator Thorpe. I find it pretty extraordinary that you don't have any of your moderators in Australia to fully appreciate the Australian experience of racism. And I find that at odds with your comments that you take these matters really seriously. My question, I suppose, is goes to thresholds for harm, and in my experience, and certainly the experience of others. Sorry, I realise I was supposed to go to Mr. Venning on the phone. I'll come to you next, Deputy Chair. The threshold seems too high for having content removed that is harmful, that is racist, and when I've reported content, certainly when other people have reported content, there's some very recent examples, like the racist Auntie Lisa comedian that out of Victoria. Lots of people reported her content. It took a long time to get that racist content taken down. And then I look at the now banned pages like Action for Alice. Did a lot of harm to entrench and really platform racist stereotypes about First Nations people in Northern Territory. It took far too long for pages like that to be removed. I suppose I'm wondering how you can reconcile your comments about you taking these things seriously, and then the experience of people who are having an interface with your system, who would say that those two things cannot be true at the same time. Because the experience of First Nations people online is that you are not taking our experiences seriously, and the harm that is done to our kids and to our communities seriously through how you act or fail to act to the harm that is done to us online. What is the threshold, and does it need to be lowered for racist content to be removed?
Sure. So I guess, you know, there is the way the system is intended to work, in the sense of if people see harmful content that, you know, meets the threshold for hateful conduct under our policy.
Ms. Garlick, I think there'd be people who would suggest that the system is intended to harm us. So, I would be careful about how you frame that, because I think there are definitely people who would suggest the system is working as it should, which is to harm First Nations people.
So when the teams become aware of content that violates our policies, we work to remove that as quickly as possible. It is challenging to give specifics without, I mean, you know, if it's helpful, if you wanted to provide like a specific post, etc., we could provide details around that. I mean, in one of the examples that you've given, I think the videos kept getting reposted, and so we were taking them down again and again. So there are issues around that. But I also think that some of this, you know, hopefully will improve over time as we get faster with LLMs and things like that. But
So what's LLMs?
Sorry, large language models and artificial intelligence that can act faster. I apologise.
Yes.
So yes.
So in saying as we get better with LLMs, so you intending to have more artificial intelligence make
Yes.
those decisions,
Yes.
rather than humans?
Yes.
Do you think that's problematic, given that there is not like, how do LLMs actually understand and appreciate the experiences of First Nations people? Like removing more humans from it in terms of understanding the human impact, I'm not sure is the answer.
Yeah. So the way in which a lot of the sort of automated systems works is that you train them based on training data, and unfortunately we have removed a lot of hateful content on our services, and so we can use that as a basis to train up these models. I think that for our content reviewers, when they're looking at a particular piece of content, they're often sort of, you know, looking at the content and maybe some account information. And the reason why we're optimistic about getting more nuance in through artificial intelligence models is that they can look more at the beginning and the end, and look more at the overall context of what's happening, and hopefully make the decisions faster and with a lower error rate. So I very much appreciate, and I hope that my opening remarks also reflected this, I can very much understand the difference between a lot of the experience that people have when reporting content on our services. That is why we do try to have partnerships with different organisations, so that if there is something that is happening within a community where people don't feel like our systems are working as we intend them to be, which is to not expose people to hateful conduct, we can really jump on that and try to understand what's not working, what needs to be fixed, and to get better and improve over time. So that's certainly the goal, and we've got a number of different strategies in place to do it. I recognise your concern around where the threshold is drawn, and I do think sometimes that people can experience content which is offensive but doesn't meet the threshold of hateful conduct under our policies, and where there is a difference between, you know, local law in Australia and where our global policies are, we do work to restrict access to that content in Australia out of respect for local law. So if, for example, we do get complaints from the Human Rights Commission, etc. So there are a number of ways that we try to balance where we've drawn the line and people's experiences, both in trying to improve but also respect different community standards that exist in Australia.
Okay. So if a body like the Human Rights Commission or the Commonwealth was to change laws about what the threshold would be that constitutes harm, then you wouldn't adjust your thresholds or your LLMs or your human people to make sure that that content's removed in a way that's swift?
No. So we have global policies that we apply, and if there's a difference between local and global, then we work to respect the local laws that have been applied by blocking that content from existing in Australia. Yes.
Okay. I don't quite feel like I understand that.
So are you saying that there is a higher threshold in Australia because of the laws here
No, I was trying to suggest to the chair, well, I think that you might say that some of the provisions in the human rights body of legislation, like we have restricted access to content for violating the Racial Discrimination Act for Australia, so I think the threshold there is lower. That is one that I'm aware of that we have done. Yeah.
And so what you said is correct.
Yes.
There were,
sorry if I'm being confusing.
if the legislation was more changed in a way that impacted, you might say that global standards elsewhere are, the threshold is higher again, whereas it has been adjusted for Australia.
Yes.
And I'm interested in how I think that some Facebook pages are very clever about how they incite hate and violence and racism towards First Nations people that would probably wouldn't meet your threshold. But certainly the intent is there when you have a look at the comments. Posting tiles about, do you think welcome to country should still happen? Do you think we should have one flag in this country? Are all intended for one purpose, which is to punch down on First Nations people. Where does that fit? So it doesn't necessarily mean offensive in your category, but it incites a wave of hate towards First Nations people and our belonging in this country. How do you deal with that?
Yeah, so it's hard to talk in generalities without seeing the specifics because it...
the specific is there is a tile that gets posted on Facebook, or
yes.
Facebook in particular, I think is a particular cesspit.
Yes.
With an Aboriginal flag waving, it says, "Do you think we should have one flag in this country?" That is a very specific example of things that appear on Facebook. Again, a flag waving with a question on that tile that says, "Do you think we should have welcomes to country?" Very specific examples. These aren't generic examples. They are very specific examples, and they get pushed to me. I'm not following these pages. They get pushed to me. I imagine they get pushed to Senator Thorpe and other people on this committee. The recommender system pushes them to us, like, I want to see this content. How do you deal with that? I don't imagine it meets the threshold for racist or offensive or whatever, but the intention is very clear.
Yes. So I think you're right that there will be content on the services that is distasteful and offensive. Where I think the teams draw the line is where it's sort of shared in a way, like with a comment, or if it's shared with a caption, or if there are large number of comments under it that's starting to move over to the threshold of targeting people based on race and ethnicity, then it will cross the threshold of becoming violating. But I think that some of what you're explaining is some of the reason for the the overall experience that people are having versus where the policies are being enforced. And I think that's why we need to continue to try to undertake efforts to work with different community groups to understand where these things are crossing the line.
And then do you only deal with on a case-by-case basis? So it would take me reporting that particular post suggesting that the comments on there are verging towards violating your community standards. So there's that instance. Or do you look at, the repeated behaviour of a particular page, or the type of people that would get on there and comment, or whatever it might be? What's the process?
Yeah, so there are different actions that we can take. So obviously there's removing a post that someone has shared, and if a person repeatedly shares content that violates our policies, then we may take action against their account. So for high severe violations, so if it's like a designated hate organisation, including some of the ones that we've designated in Australia, then that will result in account removal. But if it is, I feel like it's silly saying lesser violation, but if it's bullying and harassment, then they might get a strike, and then it depends how many strikes they accrue over time before there might be action on their account, like suspension or account removal.
And what do you use to constitute a hate group? Is it the federal laws?
No.
Or is it your own policies?
We have I think in most instances that I'm aware of, particularly in Australia, we've acted before federal laws, and we look at different signals in terms of whether an organisation is indicating that their primary purpose is violence and hate. And I'd be happy to share on a confidential basis, because we don't like to disclose what groups we've designated and individuals we've designated in Australia since around 2017 and 2019, and then we've updated that list since.
Sorry, Chair.
Ms Cook, and then I'm going to go to Mr Venning.
Just on that, so you don't publish the list publicly
Yes.
of dangerous organisations or individuals.
Yes.
The terrorist designation is based on a country's government's designations. Is that what you're saying? So you seem to have different categories. So you've got dangerous organisations, individuals, and then you've got the terrorist designation. So that list is country or region specific?
We'll certainly give regard to what is designated in a country, but so, for example, I think it was 2019 that we designated 200 white supremacy groups, and I think that was before the majority of them were on different national terrorist lists. So that's just an area where we've got a system where we're looking at a range of different offline signals around intent to violence, and then we undertake a designation process through that. And
can you say how many people, individuals, organisations are on that list?
I don't have that number to hand right now, but again, if it's of interest to the committee, we can look at what we can share.
And just taking on what Senator Thorpe said around individuals that might be undertaking a coordinated campaign either against individuals or against a class of people, are you then providing those details to the Australian Federal Police for prosecution?
So there's a couple of parts to your question. So first of all, in terms of coordinated actions, we'll typically take action on that not based on necessarily the ideology. Like if someone's been designated as a dangerous organisation or a hate organisation, then they're not allowed to have a presence on our service, and we'll remove them and take actions that we can to stop them from using our services. But if there's some sort of coordinated action it's like less than designated organisations, then we have additional policies around coordinated and authentic behaviour where that may capture it as well. And then in terms of working with law enforcement, we have a dedicated law enforcement liaison team, and we're responsive to different requests that they have, and meet with them on a regular basis to share information.
Proactively.
If there's emergency disclosures or threat to life, absolutely.
So only threat direct, not using a carriage service to menace or harass, not other breaches of federal legislation.
Yes.
If you will proactively refer those people.
We have processes for emergency disclosure, and then we have processes for reactive responses as well, and then we have teams that work to share information and understand the threat landscape.
If you can provide the number of people who have been proactively referred to the AFP because you've identified a breach of law, can you give us that information as well?
Thank you, and apologies for skipping the queue, Mr Venning.
Sorry.
I'll hand the call to you.
Thank you, Chair. Firstly, I just want to thank you for fronting up today. Unlike many other organisations, especially government departments, you chose to come and give evidence, and so I couldn't be there in person. Aboriginal and Torres Strait Islander communities are increasingly engaging with public debate online, and NEDA has acknowledged the impact of coordinated inauthentic behaviour and what it can have on public discourse, and this can of course be extended into racism. Increasingly, networks of non-human or automated accounts are being used to artificially amplify content, manipulate engagement metrics, and influence your virality algorithms, allowing those with sufficient resources to manufacture the appearance of public sentiment. As it relates to racism, I suppose more so public debate, what specific measures is Meta taking to detect, remove and prevent these coordinated bot networks? And two, how do you assess whether your current systems are successfully preventing artificial amplification from distorting genuine public opinion?
So I think there's a couple of parts to the response here. So first of all, we do have policies against inauthentic behaviour and accounts on the platform, and we publicly disclose how many fake accounts we remove. And I can't remember what the latest stats were. Oh, hang on, I have them here, sorry. We actioned in Q4 of 2025, we removed 1.1 billion fake accounts proactively within minutes of account creation. Obviously, we have other systems that run on the platform to try to stop them from getting on there in the first place. But that said, if there are accounts that slip through those initial controls, we have teams that are focused on identifying coordinated inauthentic behaviour, and we publish the results of the actions that we take to investigate those networks and undertake what we call strategic network disruptions in our adversarial threat report, which I think we publish once every 6 months and are due to publish the next one. So we can share some details about that work and those reports as a follow-up, if that's helpful.
Yeah, thank you. And do you have any specific data as it relates to Australia, and maybe, you know, the percentage of accounts which you think are inauthentic today?
I don't think we have Australia-specific numbers. I think in our investor portal we estimate like maybe 1% of accounts or something might be inauthentic, but sometimes those are not for nefarious purposes. Sometimes it's because people like to have an account for their pet, or they might have multiple accounts even if our policies don't allow it for different parts of their lives. So again, I'm happy to provide you with that precise number if that's helpful.
Thank you. That'd be great. Meta removes content that breaches its policies on hate speech, but many Australians are concerned about protecting freedom of expression, freedom of political expression. How does Meta determine where the line should be drawn between lawful but offensive speech and content that should be removed for promoting racial hatred?
Yeah, I think so. The way in which we set our content policies, giving people voice is a sort of founding principle, and then trying to make sure that people can express themselves safely is sort of the other part of that. And that's why we do work to try to look at where the threshold can be drawn for hateful conduct content, to try to make sure that where it's targeted at protected characteristics, and it's using degrading or dehumanising language at either an individual or a group of individuals, then we work to take action. We know that a lot of these things are being debated in the public sphere, and so we do, as I sort of mentioned when engaging with the chair earlier, we do recognise that there will be some conversations that are had in the public debate and also on our services that will be distasteful and offensive, that may not meet the threshold for being hateful conduct under our policies.
And is there ever a situation where your policies, your community standards differ from law? And here in Australia, we've recently strengthened laws as it relates to hate crimes and hate symbols. So how do you ensure your content moderation aligns with Australian law, but where it may or may not differ from global community standards?
Yeah, so typically when we're looking at a piece of content, we'll look at the application of our global policies as an initial matter, but where we have reason to believe that it might violate local law, then we'll work with our legal teams and outside counsel or if we've got a complaint from a regulator that suggests that it violates local law, then we take action on it to make sure it's not available in Australia out of respect for local law.
Okay, great. Thank you. The rest of my questions have mostly been answered, so I'll hand back to the chair. Thanks.
Thank you, Mr. Venning. Mr. Smith.
Thank you. Look, it appears that the policies that are in place are working in direct competition with the algorithm that exists to create echo chambers. So if I want to see a certain type of content, I will get that certain type of content, regardless of how hateful that is. The use of LLMs and AI moving into the future is fine. I mean, they are just tools, and they're only going to work as good as the instructions that they're given. The word primate, for example, very loaded term, a term that if used at Aboriginal and Torres Strait Islander people is racist. has been said by your moderators to not breach community standards. If that's the case, how can we have any faith in the rest of it?
So I'm going to have to take that one on notice because I'm not across the details of that instruction being given to our community moderators, so I'm happy to come back to you with details on that. I'm not sure if you have the answer.
No, I don't. Take that on notice.
Yeah.
Do you have fact-checking ability, capacity that you do?
Yes, we do. We work with 2 third-party fact-checking partners in Australia. So we work with Agence France Presse and Australian Associated Press. There are 2 fact-checkers, and so the way they work is they work independently. They are accredited by an independent body, the International Fact-Checking Network, and they look at content that has reached a certain degree of virality and make a decision as to whether there may be a claim or a piece of content, a post that they then choose to investigate and fact check. They conduct their investigation and make a assessment, and depending on that assessment we might take actions such as to label a piece of content that has been assessed as either false or potentially misleading. We also can reduce the distribution of that content if it's depending on the assessment that the fact checkers have made.
So you wouldn't remove it?
You
would label it or like reduce its visibility?
So under our misinformation policy, we remove certain types of content, so particularly that focuses on misinformation that is potentially leading to voter interference, as well as imminent physical harm. And then we have that's under the remove component. Then we also have a reduce and an inform 3-pronged approach to misinformation policy. So where it is not sort of meeting the policy threshold for removal, if it then is fact-checked by our fact-checking partners, we may also then reduce the distribution and also issue labels over that. There's an overlay that sits over that post to inform users that it has been fact-checked.
Who does the fact-checking? Are First Nations people involved in the fact-checking?
So we have the two fact checkers. I'm not aware of the breakdown of their staff as to whether they have First Nations representatives on their fact checking team.
Do you think that's a gap that you don't know? Like, I feel like you've come to an inquiry about racism where we know there's lots of misinformation that gets shared about First Nations people online, and you can't tell me if there's any Aboriginal people in those fact-checking organisations.
All I am aware
are they
is
here? Are they Australian-based?
They are the AAP are Australia-based. I think AFP might have some Australia-based and also overseas. What I do know is that in the lead-up to the Voice referendum, at least one of those fact-checkers intentionally did hire a fact-checker, I believe, who was First Nations to provide that additional capacity at that particular time.
Who was that?
The Aboriginal fact-checker.
The actual fact-checker, I don't know. I'm
We'll take it on notice?
We can try to find out.
I suppose it would be concerning to me if there are, like, you have this capacity to do fact-checking, but there's no Aboriginal people involved in that fact-checking. And so it'd be great to know from you and you said you don't necessarily know if those two organisations that do the fact-checking actually have First Nations people employed, and in what capacity they are employed. What are they actually doing online?
Potentially another question to ask is that as part of their investigations when they're conducting a fact check is that they do consult with a range of different experts that are of relevance to the particular post that they are investigating. So we can maybe try and get a bit more information about the breadth of expertise that they draw on as part of their fact checking.
Yeah, so there's the kind of who they go out and engage with, but I'm also interested in the organisation's capacity itself.
Sure.
To understand and do the, what their kind of knowledge is. I've got just two questions, and I'll go back to Senator Thorpe. And one question on notice. It'd be good to have from you in writing what happens when somebody reports a racist comment, who reviews it, what the average response time is, what proportion of reports result in content removal or account action, and you've also spoken about like impressive numbers in terms of the content that you've removed. I'm interested in also what's the report versus what's the reporting versus what gets removed, because I imagine there's lots of things that also get reported that wouldn't violate your community standards. And then you've got and I think you've talked about this, you share data with Australian researchers or academics, including First Nations organisations. So harm can be measured independently, is that right?
So it would depend how you measure harm, but I mean, we do try to work with different researchers.
So it's through, as I understand, it's through Meta's Data for Good program.
I think the Data for Good is slightly different. I think there's the Meta Content and Research Library. Did I get that right?
Meta Content Library. Yeah.
Meta Content Library, sorry. Yes.
Sorry, say that again.
There's a Meta Content Library that researchers can get access to undertake research using data on the platform. Yes.
Okay, so that's how do you get access to that? And I'm interested to know how many First Nations people, organisations have access to that data. Is it available in Australia?
It is available in Australia, and I don't have the details to hand.
Yeah, happy to take that on notice.
Yep.
As well, and it would be good if you could provide the committee details on how many researchers or organisations have access to the data as well.
Yep.
And what rules or policies you might have about how that data is used.
Mm-hmm.
And essentially my question goes to how do you ensure that it's used for good and not to continue to perpetrate harm?
Yep.
Senator Thorpe.
Thank you, Chair. You've asked one of mine, but that's good, just on the time frame when something is reported. But I just want to go back to your business model, because controversy sells and clicks drive engagement and profits. Am I correct in saying that?
Well, no, I would challenge that. So we publish systems cards that outline why particular content, like how the different ranking and recommendation algorithms work. Engagement and clicks are one component of it, but there's a wide range of other factors. But in terms of how we actually make money, we make money by people seeing relevant ads and advertisers feeling like they get good ROI in terms of the ads that they pay us to show on the site. But that doesn't mean people have to be on the site for a particular amount of time or click on a number of things. If you go on, you see one ad and that works for everyone, that's a great day.
Okay. I'm just curious to know why Meta took down a video from the National Indigenous Times of an Aboriginal girl being brutalised by a racist cop in Perth. Like, why did that get taken down?
I can talk at a high level and then you can maybe talk about the specifics. I mean, I think I saw the testimony around this in particular, and I think this is one of the examples where some of that nuance that we're talking about is really hard for some of our enforcement systems to work effectively. So in that instance, my understanding, at a high level, if there is content that our systems identify to be violent, then it might take it down. But obviously in that instance, my understanding is it was shared to bear witness and for awareness. And I think that's one of the things that we've seen, particularly in relation to hateful conduct, and why we've tried to sort of set thresholds where they are so that people can bear witness to some of this stuff. But I'm not sure if you had anything else to add on the NIT.
That's right. I mean, just in terms of how we responded to that, we someone in our team actually did see the posts that NIT made to draw attention to the fact that this had occurred, and reached out to NIT to understand what had happened, and then worked with our ops teams to rectify the situation. We understand that we did manage to proactively resolve it for NIT.
It's just that was taken down very quickly, and Auntie Karen sniffing petrol was left up there for longer, which causes harm. It's a form of violence against our people. And the only other question I have, and I think you may have covered it, is just the supports available for the violent racist attacks that you see on your platform, what's available to the innocent victims that this is being perpetrated on to?
The people who are in the content, or the people who are seeing
People
it?
who are seeing it and being violated, who get sick, who kill themselves because they've seen something on your platform. What do you do about that? How do you help? What do you do? What's the policy?
Yeah, well, I think in relation to sort of violent and graphic content, obviously, as we've seen from this mistake that we made with NIT, we do have some automated systems that are trying to proactively find that content so that people are not being exposed to it, and that we're taking action on it before they see it. So I think on Facebook, we're proactively detecting and removing violent and incitement content 88.8% of the time before people see it. And on Instagram, it's 89.5%. So we're certainly aware that seeing harmful content can have an impact, and so we try to get on the front foot to remove it before people can be exposed to it. There may be then instances where there is harmful content on the platform, but it's being shared for awareness or for some other reason, and so it doesn't violate our policies, and then we put an interstitial on it so that people are aware that it is potentially violent, and so they can make, and so it doesn't autoplay, they don't automatically see it, so that we can try to make sure that people are only seeing it in an intentional way.
So you take it down. So there's no duty of care to someone who watches that and has their life turned upside down as a result of seeing violent racism. There's no, like, your action is remove it or put a warning on it. It's and that's it, right? Is that it?
I mean,
Like, there's no care afterwards for that person or the group of people.
We do work with a range of safety and mental health partners in Australia as well. And as an example, we work, maybe if I can share an example, leading up to the Voice referendum, we did, again, as part of the consultation with the groups that we did around our approach and strategy to the referendum, had some feedback that the First Nations community would be needing some wellbeing support at that time, and that there was an opportunity for Meta to provide some support. So we partnered with one of our mental health partners, Reach Out, to develop a campaign in partnership with a First Nations creative agency, and they engaged a number of youth First Nations creators to share messages of support to encourage mental health and wellbeing to youth communities generally across Australia at that time, but particularly First Nations youth. So hopefully that's an example of some of the work that we do in partnership with mental health and wellbeing organisations.
Okay. But once the damage is done, that's it, right? You just, that person's left to their own devices, basically, because you either remove it, put up a warning, or you get ready for a racist referendum that we should never have had. But what about now? That's what I'm interested in. There's people dying watching what you see, what your organisation promotes. We see Zuckerberg in the courts in the US for people being addicted to the platform. Is there, there could be a potential lawsuit coming for the harm, the violent harm that your platform is perpetrating, platforming. So is there any other aftercare, or is that it? Is that the end of your statement?
I think this is an area where we're always happy to work with different partners to see if there are additional things that can be done. We do have a number of different tools and support structures on the platform. For example, if we are concerned, or if someone is concerned that someone on the platform is suicidal, there are a number of different ways that we try to have on-platform interventions. We'll when people log back into the platform, there'll be a range of different support tips and ability to message friends or get in contact with specialised support. So it does depend on the, sort of the harm type, I guess, or the experience that people are having, where we do we have tried to work with different mental health and other organisations to provide interventions on the platform, and I think it's an area that we're always open to continuing the conversation about.
Thank you.
Thank you.
Senator Thorpe. Is it correct that Meta's policy exempts content deemed as political speech or humour or satire?
I think it would depend how it was expressed. So we certainly do allow political speech, but a lot of that sort of exemption has tended to move more into the misinformation space. And I think there's been, I think you mentioned one of the examples where there was a claim that it was satire, but
Yeah.
still removed it for being hateful conduct.
Yeah.
So
And,
it can depend.
Yeah, thank you. I'm wondering, how do your human or automated moderators distinguish between legitimate political debate and weaponised dog whistle racism, like targeting First Nations people? I'm wondering what it is the committee can see or have a look at. That what guidance do you have, or what are the things that you've got that is able to decide when it falls into what category?
Sure, I can see what we can provide
Yeah.
to you. I mean, as a general rule, for political speech, we assume the public fora of either the Parliament or, the public debate is where accountability can happen. But I'm happy to see if there's more specific details we give to within our policies and to our moderators around this precise issue.
Because to my mind, it's also about ensuring consistency in how it's applied to. So in 2025, you had policy adjustments about hateful conduct online, which reduced proactive enforcement and expanded exemptions around public interest debate. What measurable change occurred in the volume and prevalence of race-based hate reported on Facebook and Instagram since that policy change?
Yeah, so just to give some context to that policy change, so that was a shift in the hateful conduct standard, and it was designed to sort of marry up, if you will, how our policies were being applied with, the sort of public debate that was happening, on TV and in other public fora. What we have done since then is made sure that we are keeping an eye on a metric that we have in our transparency report called prevalence. So we have teams that undertake a sampling to identify, out of 10,000 views, how many potentially are hateful conduct. And in the measurement of that, we've found that the prevalence of hateful conduct content has been steady since 2022. So for the teams that are working specifically on the hateful conduct standard, they're very focused on this, but so far they're not seeing that there's been a shift in an increase in prevalence. And I think to the example that was given earlier, I do think that example where we'd taken something down even though someone was trying to bear witness, that would probably be less likely to happen now that we've made these policy changes. So it is designed to allow more flexibility because there are a lot of nuances around the ways in which impacted communities also try to bear witness to some of this content.
It's interesting that you say that the prevalence of hateful conduct online has remained steady when the experience of people is that it's increased. So I'm interested then in what your measurements are and how you measure it, because the experience of people on the ground is that it's increasing and it's becoming more intense. So it seems like there's something that's either out of whack with your data,
Yeah.
or out of whack with what we're hearing.
Yeah.
Like those two things aren't quite matching.
Yeah.
So it'd be good to understand actually what are you measuring and tracking to come here and to say that prevalence has remained steady. And to Senator Thorpe's earlier question, your algorithms absolutely optimise for engagement, and there is research that demonstrates that high conflict, racially provocative content often drives higher comment volume. research demonstrates that. How does Meta ensure its recommendation engine does not actively amplify racist commentary targeting First Nations people?
So we have a number of different ways that we try to do that, and also if I'm not sure in looking at the testimony today if I've seen that research, so I'm very happy if you wanted to send that through. We can share some comments on that as well, just to make sure that we're addressing the concerns there. So I think the first part of trying to make sure that the recommendation systems are not amplifying is to try to make sure that that content isn't on the platform, and so that's a lot of the work that I outlined at the start around, you know, having the policies, working to enforce the policies, etc. And then there are additional tools in terms of additional policies and systems in terms of the content distribution guidelines and the recommendation guidelines, where we're working to try to make sure that we're not recommending what we might call borderline content or other content that might be you know, shocking or provocative. And then where we get that wrong, there are also ways that people can send feedback in the system of, you know, like, I'm not interested in this, I don't want to see it from this person, etc. So there are a range of different ways that we try to prevent that from happening, because, you know, if people are having a bad experience on the platform, they won't keep using our services.
I think there are lots of people who have no choice but to engage on online platforms. It's the only form of connecting with family or community or whatever it might be. So I don't know that it's as simple as people withdrawing. I think there are a bunch of people who have made decisions to withdraw from their platforms because it makes them feel unwell. And I think I know the answer to this question, but your response might be interesting. Is Meta generating advertising revenue from engagement generated with comment sections or posts that contain unmoderated racial abuse targeting Indigenous people?
Is Meta generating revenue from comment sections?
Is Meta generating advertising revenue from engagement generated within comment sections or posts that contain unmoderated racial abuse targeting First Nations people?
So advertising is based on targeting people based on demographics and interest areas. It's not directed towards comments. So, I mean, I guess philosophically it's hard to sort of break out, you know, engagement with comments versus engagement with the rest of the platform, but, you know, certainly you know, ad campaigns are not based on how long someone's on the platform or, you know, what they're engaging with. So in terms of the direct, and, you know, the ads system is very separate to the organic system as well. So, you know, from our perspective, they're two different systems. But having said that, you know, advertisers are not going to want their content or their ads appearing next to content that is damaging for their brand. And so not only are we working to try to be true to the principles that underline our content policies, also from a commercial perspective, we have an interest to try to make sure that the broader ecosystem within which advertising is appearing is something that is going to continue to want to make advertisers advertise on our services.
So I might put some more of my questions there, because I know Ms Cook has got one final question, and we are over time with this. I appreciate that you were on the program until 11:15, but Ms Cook's got one question.
Just a final question. So I know you've watched some of the inquiry, so you understand some of the evidence that's been given about First Nations witnesses explicitly saying that they have suffered harm as a result of their interactions with different platforms online. Do you believe that Meta owes Australians a legal duty of care or a digital duty of care?
Certainly, I know that's being discussed right now, and, you know, we've been broadly supportive of the principle of it. We haven't seen a lot of the details of it, but in other jurisdictions where it has been acted, we've been working to be constructively engaged and, you know, compliant with those laws. So, you know, in Australia, I've mentioned our work to be respectful of the Racial Discrimination Act, and we've also had 10 years of trying to work constructively to comply with the different online safety laws and rules that have come out. So certainly, you know, from a first principles basis, we'll continue to work to respect the laws of Australia.
So you would support a digital duty of care?
Well, on a principled basis,
in-
yes, but it's
in
really
principle.
hard to know the
I
details at the
understand the
moment.
detail.
So far, we have a survey and a 2-page issues paper, so we don't have a lot of details. But as a principle, yes.
Yeah. And is there anything that we haven't discussed today that Meta is doing to ensure that people are safe on your platform?
That's actually a very good question. Is there anything else?
I feel like we have had the opportunity to share a lot about our work.
Okay.
Anything you feel like
There's also an option to provide any additional information on notice
Thank
too.
you.
If you haven't had a chance
Yes.
to, if you walk away from
Yeah.
this morning and think, oh, I should have said that.
I mean, it's been fairly wide-ranging and robust.
Yes.
And I imagine the questions on notice will be equally wide-ranging and robust, so we will engage thoughtfully as well.
Thank you. Thank you for coming.
Yeah, absolutely. That concludes the time that we have with you. And thank you so much for showing up and being accountable to committees like this. It is really important, even though they are tough questions. I think we are both equally concerned with people's experiences online. So I appreciate you coming and answering the committee's questions in what is a really difficult conversation.
Yeah.
You have been asked to provide questions on notice, so if you please forward it to the Secretariat by the 18th of August, please. And the Secretariat will also follow up with you after this as well, so with the questions that you've taken, and it's also an opportunity to provide any additional information to the committee that you think that would be of interest. And you'll be sent a copy of the transcript of your evidence from today and have an opportunity to request corrections to any errors that you see there. So thank you very much again for the time you've taken to appear before the committee. Really appreciate it.
Thank you.
We will now suspend for morning tea and return at 11:35. I now call on Dr. Peter Ballon to give evidence. For the Hansard record, would you please state your full name and the capacity in which you appear?
Peter Ballon, I have an OEM by the way, and I am an individual representing a certain point of view.
Okay, thank you very much. Although the committee does not require you to give evidence under oath, I should advise you that this hearing is a legal proceeding of the Parliament and therefore has the same standing as proceedings of the respective houses. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege and is being broadcast live. I now invite you to make a brief opening statement.
Well, dear committee members, thank you for the privilege of being able to present my submission on this really important, it is a very important topic. My concern is for the well-being of Indigenous people, and my wish is for all of them to enjoy a great future as Australian citizens. The approach taken in this submission has been to analyse factors that lead to the interpersonal racism that has been the subject of many submissions to this inquiry. So this submission gives an overview of a number of systemic and institutional racism factors that have had the unfortunate outcome of presenting Indigenous people as separate and distinct from the Australian community in a number of ways, and this has had the unfortunate result of provoking interpersonal racism. The submission proposes a range of changes that would remove or reduce such systemic and institutional racism factors and help Indigenous people enjoy life in line with the Australian value statement and to contribute to and benefit from our nation's development and standard of living. Besides the submission 610, which was lodged some time ago, I will add to this with an addition. I've prepared this, and you'll get this fairly quickly, that addresses important topics of group identification and privilege and their relation to interpersonal racism. I'm happy to elaborate on these comments and respond to your questions. By the way, I'm here for the rest of the day. I return to Adelaide tomorrow, so I'm happy to converse with anyone present if they so wish. So I also include an outline of an implementation plan to achieve the outcome that I've stated. So, yeah, I'm happy to proceed.
Thank you very much. We'll proceed to questions. Senator Thorpe, did you have questions?
Oh, yeah, I do actually. Thank you for appearing. It's a bit odd, actually, I must say, that your submission is kind of, against what we're trying to achieve here, but here you are, let's go for it. My question is, are you recognising that Aboriginal and Torres Strait Islander people as the first peoples of these lands?
Now, I first say that in the same manner as the AHRC that earlier today, I would like to see fairness and people treated with dignity and bring all people together.
Sorry, sir, that's not my question. Can you answer the question, please?
That leads to my very simple proposition.
It's a very simple question.
That I look at this matter in the course of human history. Human history is a non-stop saga of people's moving... Dr. Ballon, yeah.
I've asked you a question. Do you acknowledge that we are the first peoples of this land in this country? Yes or no? I don't need a history lesson.
I think it doesn't matter.
It's not my... Okay, it doesn't matter. All right.
No, that is my response.
Here you are at the racism inquiry.
Correct.
Okay, that's your answer. My next question is, do you acknowledge that the wealth of this country, the stolen wealth, is based on colonial exploitation and oppression of First Peoples? Yes or no?
The wealth of this nation is based on its development by settlers and colonists, and it was they who developed the richness that we all benefit every single day.
Do you agree that the oppression of Aboriginal and Torres Strait Islander people in this country has led to the so-called gap between First Peoples and the rest of the country?
No.
Okay. Do you think that given all of the harm that has been caused to First Peoples, we deserve at least to have the same rights and opportunities as everyone else?
I believe they already have the same rights and opportunities if the doors are only open to them by removing systemic and institutional racism, which is the subject of my submission.
Systemic racism.
Yes?
Do you acknowledge that you're on stolen land?
No.
Do you pay the rent for being on stolen land?
I pay taxes.
Do you pay
as
the
a
rent
citizen.
for being on stolen land?
I don't understand your term.
Well, as somebody who's not from this land, who lives here and benefits from the stolen wealth and oppression of Aboriginal people, do you pay the rent for being on stolen land to the people whose land it is? I understand you're in SA.
Correct.
So do you pay the rent to the Aboriginal people, the traditional owners of that land,
All
for being on their land?
All I do is pay my taxes, or have paid taxes as an Australian citizen.
Okay.
I don't understand your term, paying rent.
Well, paying the
In
rent,
what form?
however you decide.
No,
Obviously-
you're proposing.
Well, let's say you look like a pretty wealthy fella, so a bit of paying the rent with some money that you benefit from
Yeah.
living and breathing on our land.
Yes.
Do you pay the rent to the traditional owners for being on their land, for the privilege of being on their land?
You've used the word privilege, which I'm really pleased, because I would like to make a short statement regarding privilege.
Well, answer the question first.
No.
Well, okay, well maybe that's something you should consider.
Why?
Big.
Sorry, I'm just like a short interjection. Senator Thorpe is asking the questions. Senator Thorpe.
Thank you. Are you acknowledging that First Peoples are the most disadvantaged in this country?
No.
The most incarcerated?
No.
Having children taken at a higher rate than anyone else?
Oh, that may well be the case. In fact, it probably is for reasons of systemic and institutional racism.
Being homeless on our own lands?
Depends how you define own lands. The large majority of people who are classified as Indigenous by the census live in the medium-sized larger towns and cities. There are only 150,000 who live in remote communities and small settlements.
Do you understand that this country was founded based on a lie?
What was the lie?
Terra nullius?
In fact, terra nullius is valid because, as I outlined in the very start of my submission, the first people who came to, or identified this continent found there was nothing to trade. There was nothing, they found nothing of value here, and they pushed off to the East Indies to do trade, which was their purpose. And for more than 170 years, no Europeans settled here because there was nothing to attract them. It was nullius. It was empty of riches, of wealth, of tradable markets.
Terra nullius said that there was no people here. Are you saying that there were no people here when violent, murderous Cook come here?
Well, the violence and
Are you
murder
saying
was
that?
there according to Buckley. It was well established.
Are you saying that there was no person here?
I don't think that's
You're
relevant.
saying no riches?
No, there were persons here, but the land was empty of wealth and tradable
Terra
items.
nullius is about people.
Yeah, but that's irrelevant. Of course there were
Well,
people
that's
here.
the question at hand.
No,
So-
it's irrelevant.
It's irrelevant.
It's irrelevant.
So, are you saying that? Are you confirming that when Cook told the king, the coloniser king, that there was no one here, just wild beasts. Do you believe that?
Cook, no, of course not.
You don't
He
believe
didn't say that.
that? Okay.
I mean, all the history.
Thank you. The erasing of culture and identity is cultural genocide. Are you aware of that?
I've heard the term and I disagree with it.
Welcome to country and flying of our Aboriginal and Torres Strait Islander flags.
1976,
Excuse me.
Mr. Bowen, Senator Thorpe's not finished asking her question.
Just a small way to recognise this country's history and First Peoples. As you advocate for these to be cancelled, can I just confirm that you are in fact calling for cultural genocide, sir?
Senator, you're exaggerating. All I'm arguing for is changes that will bring fairness and dignity to our society, and I observe through many reports that the welcome to country formality invented in 1976 by Ernie Dingo, etc., it serves simply to irritate people and divide them and make them feel antagonistic towards the people making that
Sorry,
welcome.
I find that this witness is totally inappropriate and is causing harm and will cause further harm. And the racism that this person represents is the very racism that we're trying to eradicate. We're trying to eradicate people like you from the system that we have to deal with. So I have no further questions. I don't want to waste my time and my expertise on someone like this.
Senator
Thank
Thorpe,
you.
would you like to call a private meeting to discuss
Yes,
the program?
please. Yeah.
Thank you. We'll have a private meeting. We'll vacate the room.
Thank you.
If people could please leave the room so we can have a meeting. Thank you. We will return from our brief suspension. That concludes the questions that we have for you this morning. Thank you for your time. We will now suspend briefly while we welcome our next witnesses. I now call on representatives from the Currumbin Institute. Said that right? Excellent. To give evidence. For the Hansard record, would you please state your full name and the capacity in which you appear?
Professor Chelsea Wattigo, Executive Director of QUT's Currumbin Institute.
And I'm Dr. Amy Maguire. I'm a Senior Lecturer at Currumbin Institute.
Thank you very much. Although the committee does not require you to give evidence under oath, I should advise you that this hearing is a legal proceeding of the Parliament and therefore has the same standing as proceedings of the respective houses. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege and is being broadcast live. I now invite you to make a brief opening statement.
We'll both be providing short statements.
Absolutely.
We wish to acknowledge the unceded sovereignty of the Turrbal and Yagara people, and we also want to acknowledge the infamous Brisbane Blacks, the spirit and tradition in which we wish to honour, from Dundalli to Pastor Don Brady, who courageously resisted the most intense forms of racial violence enacted here in the state of Queensland. In particular, the 1897 Restriction of the Sale of Opium and Protection of Aborigines Act, which governed or rather imprisoned our people well into the 1960s and 70s. It provided the model for 3 other states in this country. Today we have seen successive Queensland governments suspend human rights to incarcerate our kids. The slogan "Adult Time, Adult Crime" got this government into power and is similarly being adopted in other states. There's no doubt Queensland is a front runner in anti-Indigenous racism. Now, in the aftermath of the referendum, we hear concerns of racism having increased, and certainly the bombing and the booing suggests many have become emboldened in their racism. Scholars Torres and Hamilton explain how these overt individual acts can be observed in the process of commission and thus generally receive public condemnation. But they argue there's another form of racism that is no less destructive of human life. That is the covert forms of racism which receive far less public outcry because it originates in the operation of established and respected forces of that society. This covert racism refers to the conditions that produce racialised inequalities. First coining the term institutional racism, Torres and Hamilton state the society either pretends it does not know of the situation or is in fact incapable of doing anything meaningful about it. As mentioned earlier this morning, one only has to look at the almost 2 decades of failure to close the gap to understand what they meant in their critical text, Black Power, the Politics of Liberation. Black Power reflects the sentiments expressed in our submission. In being both first race and First Nations, blackfellas offer the most sophisticated understandings of racism in all of its manifestations. To accept the radical proposition that blackfellas possess the strategies and solutions for combating racism requires a rejection of the racialised logics of Indigenous intellectual inferiority and the ongoing denial of Indigenous political sovereignty. Having led a national conversation on anti-racism last year, being targeted by the Murdoch press and politicians on both sides, we know too well the resistance to Indigenous-led anti-racism approaches. There is a clear pattern of hostility to any efforts that attend to the structural nature of race and racism. We see it in every coronial inquest, including that of our colleague Dr. Raylene Nixon, whose own family impact statement was censored in the inquest into her son's death at the hands of Queensland Police. We see it in the failure to resource sustained research infrastructure, and it's absent from the Australian university curriculum. We argue there is not an absence of knowing, but an active denial of the full reality of racial violence, as we just saw with the previous person. We observed it also in the inquest into the death of Common J. Walker, where our conceptual understanding of structural racism was deemed helpful by the coroner. Yet she redacted all aspects that applied to its evidence. And of course, in the same year, she received an Australian Human Rights Award. From the far right to the supposed progressive left, blackfellas find no friends or allies in our calls to attend to racism of the structural and systemic kind. Even this inquiry's terms of reference effectively erase almost any possibility of such an analysis. I leave my opening remarks with an acknowledgement of all the blackfellas who, through their testimony, shared their wounds in the hope that this inquiry would attend to them. We know too well the toll of these testimonies and the betrayal blackfellas feel when their cries go unheard. We urge this inquiry to centre the testimonies and theories of blackfellas in your analysis and develop recommendations that resource our people to continue to lead the way in eliminating all forms of racism in this country. Amy.
Thank you. First of all, I'd also like to acknowledge the continuing sovereignty of the Yagara and Turrbal peoples whose land I'm speaking from today, a sovereignty that has never been ceded. It's been 2 years since a parliamentary committee tabled a report into missing and murdered First Nations women and children, and here we are again speaking at another parliamentary inquiry into anti-Indigenous racism. I say another because the killing and disappearing of Indigenous women and children is the most extreme form of anti-Indigenous racism, or should I say racist violence. When speaking of this particular form of anti-Indigenous racist violence, I utilise the definition of feminicide, a term that widens the definition from killing a woman because she is a woman to incorporating the reality of state violence and the role of impunity in the killings and disappearing of Indigenous women. Violence against Indigenous women is not just endemic but foundational to the settler colony, particularly in this colony, the state of Queensland. Aboriginal and Torres Strait Islander women and children are still being killed and disappeared at the highest rates in this country, and yet their deaths are still shrouded in silence. We still don't know how many Indigenous women have been killed or disappeared, and this is another example of the silence. When the Senate committee tabled its report 2 years ago into this crisis, I counted only 11 news reports in total, and the majority of these articles were written by Aboriginal female journalists. Over the past decade, I've sat with many families of disappeared Indigenous women, men and children, who all struggle with the unknowing of what happened to their loved ones, and the refusal of the state to deliver justice in whatever way they define justice. And they still fight for their loved ones today as if no time had passed. We have seen how previous inquiries, particularly in this state of Queensland, has not exposed but rather legitimised the racist and gendered violence perpetrated against Indigenous women and children. And so I end by calling for the committee to ensure that the voices of black women and children and their families are not silenced but centred again in this inquiry's report. Thank you.
Thank you both for those opening statements. We'll go to questions and begin with Ms Cook.
Thank you, Chair. Thank you both for being here today. Your submission was really comprehensive and very powerful. I want to ask you, I know that you've been here today hearing evidence from other witnesses, and today we have heard concerns specifically about the Queensland Government and some of the actions that have been taken over the last 12 months that go to the systemic and structural nature of racism. Are you aware of this? Can you talk to us about some thoughts on that?
Yeah. I think certainly Queensland is unique, I think locally and globally, in terms of making rational state-sanctioned racial violence, making it seem acceptable. I mean, we saw overnight truth and treaty off the table like it was nothing. Project Invisibility is continuing with little challenge. But as blackfellas who live in Queensland, we know, living under the Act, the extent of state control over almost every aspect of our lives. There's not one blackfellow in the state of Queensland who does not explain their family tree via that Protection Act. And the fact that it's even called a Protection Act and the violence it visited tells us how this state has made racial harm seem as though it's in our best interests, when we know clearly it's not.
Yeah, sorry, I would add to that by just saying there has been a lot of talk in the media or just in analysis that there are more forms of violence currently shown. I see it as a continuation, or it's becoming more transparent. I think after the referendum particularly, it gave a lot of people who already held racist views almost a mandate to expose that racism. That's what we're seeing right now. So there's a lot of concern, for example, over the rise of One Nation and her particular brand of racism that has always existed in Queensland, and particularly regional parts of Queensland. And we've seen that in the way the Queensland government has really seized upon that to pass really horrific racist policies that have only amounted to the continual demonisation and hyper-incarceration of Indigenous children, the most vulnerable in our society, the funneling into the child protection system, which then leads into the justice system. And these are policies like adult time, adult crime, which are demonising and criminalising black children. But we've also seen it as well in the continual violence afflicted upon Aboriginal women, both in the justice system but outside of it. And so this is a continuation from the frontier, as Chelsea articulates, to the present in different forms, so it never goes away. But what we are seeing is that there is an added impunity, particularly in Queensland, to this intensified racist violence. And also I would say, a criminalisation even, or of people calling it out, criminalisation of resistance as well.
And if I can just come back to, there are some that, suggest that speaking of this racial violence is buying into the narrative of victimhood. There's a reason why some of the most fierce black resistance came from this state of Queensland, from Brisbane blacks. We had to organise and strategise, and this place has produced some of internationally renowned activists, artists, academics who have led the way in an understanding of how race is working structurally. So rather than being passive subjects of this intense racial violence, we can look to blackfellas here for strategies around combating racism in this place, particularly of the systemic kind. And I think that's the danger in the talk of racism, is the way in which these racialised logics get reproduced on those who are negatively racialised, as though we're sitting here passive in receipt of this violence, when in fact we have been raised in this place knowing how to fight it at our kitchen table before we leave our homes. And I think that doesn't seem to get captured in much of the discourse around racism when we emasculate and dehumanise blackfellas who speak out in the public domain, such as Adam Goodes, who were accused of being sooks. When blackfellas speak out against racism in the public domain, it comes after many sustained attacks of which they've endured, and they finally realise their own power to speak out against it, to know it's not them. And so there is something we do in this country to blackfellas who speak out about racism, how we reproduce that racial harm by suggesting that somehow we're just not strong enough.
Thank you. In your submission, you mention about developing a unique methodology that addresses the issue of systemic racism. Can you talk about that as well?
Yeah, look, I've had an interesting journey to race and racism as a scholar. Now, I did a university degree that was for blackfellas, specifically around the problem of Indigenous health, because after Rickardick, rather than implicate the police for the murders of blackfellas, we said, well, blackfellas are getting incarcerated at higher rates because of public nuisance, minor offences, and because of our poor health, that's why we die in custody. So we saw this investment in Indigenous health courses to improve the health of Indigenous peoples, and I was trained in a 3-year undergraduate degree to surveil the behaviours of my people, to check blood pressures and blood sugar levels. I wasn't taught how to understand how systems were working on our bodies that meant that we had diabetes and hypertension at our early 40s, why our men were having heart attacks in their 30s. And as I tried to understand how race was working to produce what we know are racialised inequalities, I found myself further distanced from my discipline, despite my academic standing. And I learned that we're not allowed to speak about the conditions bearing on our bodies. And we call this, we talk about, race isn't real biologically. But we have a new kind of racism where race is real behaviourally, culturally. Oh, we have those outcomes because we make poor choices. And so what we do in our understanding of racialised inequalities is we reproduce the racialised logic that says, well, black people must be inferior. That's why they die early, and not the systems and structures that are working every day on black bodies, which they are trying to withstand.
You also talk about the difference in anti-racism versus anti-Indigenous racism in your submission as well. Can you talk a bit more about that and why that's important?
Yeah, so we distinguish, I think, the previous Race Discrimination Commission, not this one, the previous one, in one of the conceptual papers, flattened the racisms and just talked about all the racisms that people in Australia experience. And what we know is that blackfellas, we use that term blackfellas, it denotes our being race as black, but also our indigeneity as being First Nations. So at that intersection, we experience a unique form of racial violence. And when you look at, the legal doctrine of terra nullius was made possible by the vehicle of race. We were so subhuman, we lacked any political sovereignty, unlike other English-speaking settler colonies where they acknowledged and, in part, sought a treaty with First Nations peoples. Here, we were so subhuman that we were incapable of possessing that. And, 3 years ago, this country decided that we were incapable of a committee with no power. Like, this is the colony. It's quite unique in the violence it visits upon blackfellas because it has a motivation. And we see in the current discourse around, monoculture, lols, the way in which the erasure of blackfellas who were a multicultural continent way before settlers arrived on the ships. But that we see in that idea of a monoculture, there's still this attachment to a myth of a particular nation that does not look anything or feel anything like the neighbourhood I live in, at Anala, in the outer suburbs here of Brisbane. But there's this delusion that people are clinging to. And these racial ideas, people are deeply attached to them because it benefits them. And we saw the absurd attachment in the previous speaker. And while it was pleasing to see that not continue, it is reflective of the leadership in almost any institution in this country, even the most benevolent spaces. So on the one hand, this reflects this flat denial and the delusions that settlers still cling to despite the High Court finding that terra nullius was a lie.
Thank you. I'll let other people ask questions.
Senator Thorpe.
Thank you. Thank you for appearing today. Dr. McGuire, you pointed to the Senate inquiry into missing and murdered First Nations women and children. What are the systems that stand in the way of preventing our women and children from being disappeared or murdered?
I mean, one of the things, the reason I call about this framework of disappearing is because often there is a focus, as we talk about interpersonal racism, we also focus a lot on individual perpetrators, but there's an entire framework of disappearance that allows for acts of violence against Aboriginal women to occur, but also entrenches disappearances or that violence or leads to a refusal to deliver justice to families in whatever way that justice looks like. And one of the leading perpetrators of state-sanctioned violence against Aboriginal women are, of course, the police. And in Queensland particularly, we have a specific violence of the police that directly leads back to the frontier and the native mounted police force, which was a paramilitary killing squad which actually perpetrated genocide and sexual violence across Aboriginal communities all across the frontier. And this is particularly specific to Queensland and is why the Queensland Police in particular are incredibly violent. And we don't see those stories talked about, and we don't see, I talk about killings in custody, not just deaths in custody, because we have several Aboriginal people who have been killed in custody and we see their deaths go to inquests. They don't go to any other criminal court, and that's the same with deaths and disappearances of Aboriginal women, where the entrenching of the disappearance, so the police's refusal to search but then investigate properly and then actually press charges, it goes to coronial inquests. and which lead to findings that go nowhere. And I've sat in on several coronial inquests where this has happened, and it is incredibly shocking. It's not just violence. That's why I talk about femicide. It's a colonial violence. It's a continuing colonial violence as well. And I think it happens all across the country. But when you look at the particular violence in Queensland, you can trace it back to the formation of the settler colony and the state of Queensland, which required the Queensland Police. And the Queensland Police is still required in relation to the horrific policies that the Queensland government is currently perpetrating on Aboriginal people. And I think the other thing I would make a point of is my background is in independent Indigenous media, and I've also seen over the past couple of years a horrific silence from the media in relation to reporting the violence perpetrated against blackfellas. And I see that I look at the media every single day. I check the media databases and everything, and compared to like even 10, 15 years ago, the silence is absolutely horrific, and silencing is part of this violence. And so when we talk about believing black witnesses, centering black witnesses, blackfellas are the ones who have the authority on racism and can speak to that. And they should be the ones believed over white authorities and other forms.
Thank you. You answered a couple of other questions in there, so Natalie. Mrs. Wadago, you say that in the absence of sovereign agreement or another just foundation for Australian political existence on these lands, racism is the cornerstone of Australia's legal and political institutions. Can you please outline for the committee what this looks like?
Well, I guess much to what I referred to before is that when we can look to other English-speaking settler colonies, we were so subhuman that we lacked political sovereignty. Like race was the vehicle for that determination with such authority that that defied the reality of those conditions. And this, despite the Mabo decision, which proved everything blackfellas been saying for a long time, there is still this failure to deal with Indigenous sovereignty. A refusal, I would say, not a failure. It's a refusal. It's a conscious decision this nation makes. And then we wonder why we have people espousing a monoculture so popular. It's just a more vulgar articulation of the same ideology that forms this nation state. So we can't distance ourselves from the likes of One Nation as how did that happen? We're part of this machinery because we refuse to recognise the political sovereignty of the Indigenous nations in this place. And, you know, I was shocked by the Queensland Government's sudden decision to do away with treaty and truth-telling, but I have to say I wasn't devastated because we're seeing the state construct the idea of treaty or use the language of treaty when in fact it's just entrenching a service agreement around our disadvantage and only knowing us through our disadvantage. And so we've been, in the 20 years post-abolition of ATSIA, Indigenous affairs has been shaped by this language of equity, of inferiority, which itself is a racialised logic. We are known through the state via our departure from whiteness as wellness. So if that's the framework of equity, like that itself is racist. But if we think through sovereignty, foregrounding Indigenous sovereignty and an Indigenous humanity, what might the relationship be between the state and Indigenous nations? But we won't even ask that question. Not even through a committee. That's how bad it is here.
I did ask it during the referendum, and the government said we don't have to worry about that, and we have legal advice that you still have your sovereignty, but they won't acknowledge that we are sovereign.
If I can just add, in the aftermath of the referendum, there has been this discourse about the increase in racism. And I disagree that it's increased. It's like I said, is the overt forms have been shocking to us. But during that referendum strategy, we were advised to be silent about race and racism and about sovereignty in the hopes that the settlers would grant us this thing. And it didn't work out for us. And there is a racial violence that was perpetrated through that strategy upon our own people, which I still contend that the architects of that strategy owe our own people an apology for. Many of us who spoke about the structural nature of racism during the referendum campaign were demonised, professionally and personally. And still we continue to be cast as radical outliers, despite our work being grounded in our scholarly work. Intellectually informed, we are still seen as possessing this radical position that asserts Indigenous humanity and sovereignty.
Thank you. I advocated for this inquiry to look more specifically at systemic racism, but was shut down. I guess that says it all, but can you tell us why we cannot just address individual racism, but must address systemic racism, and why nothing will change unless we do so?
Look, we've seen a tradition with the racism inquiries from the ABC to the AFL. And we see it in the inquest. We like the lone wolf bad apple type of racism. We can spot it, but also we can distance ourselves from it. Racism has become like smoking. It's like this stigma that people avoid. And so that individual form, it's an easy one. We call it low-hanging fruit. I'm less concerned by Pauline Hanson's latest musing. I'm more concerned about the policies that are being implemented in the state of Queensland and the reality that it has in the material conditions of whitefellas. They are connected, they're not separate. So it's just more the overt vulgar form or expression of racism which we can see, like the overt racial slur. So Meta can't seem to even see primate as a racial slur. So the systemic, the structural, it is hard because it requires us to look at our own complicity, every one of us. As an academic, I'm complicit. Universities were the factories that cemented the idea of race scientifically. I come from the health and biomedical sciences. They institutionalised the idea of race as a legitimate scientific thing. I'm part of that tradition too. And so I think we like the racism of the spectator in the stand or the anonymous social media post because they're always over there, far, far away. And when we understand racism systemically, we have to be honest about how we are all complicit in, how we all benefit from.
Just thinking about the policies within federal parliament and the legislation. Will I take photos?
Sorry, Mr. Bowen, you're not allowed to take photos without the express committee consent of the committee.
Staff were taking photos and videos.
I don't want my photo on your phone.
Staff.
You don't have my permission.
Neither do I.
Thank you. Yeah, you have to get consent of the committee to take photos. Thank you.
Oh, do I have consent?
No, I think the committee's said no. Thank you.
Okay.
Sorry. Sorry, Senator Thorpe, were you in the middle of asking a question? or were you taking-
So federal legislation. Is there any good legislation for Aboriginal people in this country at the federal level that you see from your expertise?
I mean, what do you think? Look, the ideological trap we've been in for the last 20 years. I mean, I'm old enough to remember ATSIA. I was a bub, but I remember we used to have black community-controlled organisations. We had black leadership that was voted by black fellas. May not be perfect, but certainly the current system we've got is certainly nowhere near perfect. There was an organising infrastructure. I remember as a student reading discussion pieces that came out of ATSIA that engaged with local and global issues on human rights. And 20 years of dispersing the natives and creating a black leadership infrastructure that is at the mercy or validation of settlers has been destructive. And it has impacted the kinds of solutions that even we put up, because we're putting up what we think they'll give us as opposed to what we know we believe, or what we deserve. So I'm quite cynical after 20 years of mainstreaming. You know, and we I think Amy in a recent piece talks about there's this discourse about what if Pauline Hanson becomes Prime Minister. But everything she said back then is what Howard did. He instituted it. The pendulum had swung too far. So it's not this idea that what happens when the overt extreme racist has a position of power. It's how are those ideas cemented in place without him even needing the space to speak. And that's the nature of systemic racism. You don't need individual racists to express it. It's good when they do, so we can show it. But we don't even need him to show how racism works in this country.
I was just going to add to that because I was thinking the exact same thing, is that we focus a lot on those overt racist things that Pauline Hanson says. But John Howard, his 10 years or 11 years in power led to a horrific dismantling of Indigenous self-determination, which blackfellas had fought for a very long time. And we're still dealing with the ramifications of that. It's never been repealed. It was, in fact, pretty much enforced by successive Labor governments. So I wanted to make one point, was the CDEP program, which it had its faults, but it was one of the most successful programs for Indigenous mob. And if you go to particularly a lot of regional places like New South Wales, other parts of Queensland, the destruction of CDEP had enormous ramifications for Aboriginal communities and led to a lot of other forms of forms of violence. And Howard and the governments that come after have never been actually fully held accountable for that. And so it really bypasses and instead silences the really destructive forms of systemic and institutional racism that has been foregrounded and has infected Indigenous policy over the past 10 years, which is led up in the dismantling of ATSIA and the watering down of Indigenous self-determination. But blackfellas still hold that power, and they still hold leadership within their own communities in different ways. And I think that's the real strength. It doesn't lie in the state, it lies in the continuing resistance. And blackfellas are always going to talk about the neoliberalisation of Aboriginal policy and how that is still enforced today in so many different ways that Indigenous policy, both in the state and the federal level, is playing out. You see Howard, which had its impetus in Pauline Hanson. So Howard was able to pass a lot of those destructive policies using sort of Hanson as this cover as the extreme racist. And then he was there talking about responsibilities and the responsibility agenda. And we're still dealing with the fallout of that in Indigenous policy. And I think the difference we're seeing right now is there's such a silence around the violence of Indigenous policy and what's happening. And there's no one really following it up, and no one can really tell an actual story about what is happening in Indigenous policy now. And I think there's been a lot of talk in this inquiry about Indigenous media. I think that's the role, particularly of Indigenous media, and it's very hard to do that when you are funded by government or you're beholden to government funds to actually hold government to account for the benefit of black witnesses.
And part of I think the failing in terms of anti-racist strategising is the response has been this, what I think is referred to as the representational anti-racism. That if we put blackface in a white space, that will remedy all of the structural conditions that produce racist outcomes. We know it takes its toll on any black fellow that's been put in as the one black person in a system that is inherently violent. And so we've tried that strategy in the absence of an organising infrastructure, but no matter where black fellas sit on the political spectrum, it is harming us all.
Thank you. Ms. Wadago, in your submission you point out that the Racial Discrimination Act is inadequate and too often suspended to be able to be racist to our people. Can you tell us why it's not adequate to counter racial discrimination in its current form and how it would need to be reformed to actually do so?
Yeah. So it's noted in our submission that the Racial Discrimination Act has been suspended 3 times in this country and related to blackfellas. It's connected to land, of course, because that is the vehicle for dispossession. But racial complaint, I've tested the racial discrimination process at least twice here in the state of Queensland. And despite being a race scholar and having senior counsel working pro bono and all of my best evidence, not only was my case determined that there could be no inference about race, the Courier Mail headline was I was the real racist after all, and I was fined $7,000 to pay for their legal costs against the Queensland Police having assaulted me in the Brisbane Watch House, in which they acknowledged they deleted the footage despite my request to preserve it. That is the nature of racial complaint. You will be punished for speaking out, no matter how intelligent you may be, how well informed your strategy might be. This is the state of Queensland. And no one has been held accountable for the bruises that were inflicted upon my body in the Brisbane Watch House. We know that the law, the legal system, and this is the thing I think as blackfellas, many of us will come to these processes in the hope that we'll get justice, because we have been conditioned to think that justice sits in the legal system. We know that not to be true for the most part. And the way in which it's set up, so the definition of what counts as racism under legislation is the lone apple bad wolf overt racial slur. Even then, we'll struggle with it. Certainly not trauma-informed in the process, as someone who's gone through it. I still remember doing one mediation in the Queensland Human Rights Commission, and on this one occasion, I had a woman of colour who was the moderator with me against my employer at the time. And in that one, for some reason, the woman of colour had to bring a white woman into the moderation to make sure it was balanced. Now, in any of my meetings and moderations at the Queensland Human Rights Commission, the white person who was a moderator was never accompanied by a woman of colour. I was always the lone black woman in that room. So even, I would say, the Human Rights Commission and these processes reproduce the idea of race, reproduce racial harm in that process. I think we've called for a review of the way in which racial complaints work for blackfellas at state and federal level. There should be a way to find out how it's working, to show numerically that it's not serving blackfellas. We know that. We know the one time it worked in this country, we had a whole, the country was obsessed with this conversation about the right to be bigots. So the moment this race legislation works for us, there is attempts to tinker with it to make sure it doesn't really work for us, because they know it's not meant to work for us, really. And so, we do a lot of work with people who are going through the racial complaint process to help them be aware of the way in which this process can reproduce racial violence, because what we see is the ways in which blackfellas get broken, not in the encounter of racism, but the process that's most supposed to deliver justice. And that shouldn't happen. That shouldn't happen. And I think myself, my colleague, Kevin Yao, Amy, we do a lot of after-hours work supporting mob through various racial complaint processes, not because it's our job, but it's because our duty as blackfellas. The system could be better and should be better.
So on that, and I'm happy to pass after this, the human rights framework for anti-racism has been given to the federal government some 20 months ago. No response. Ministers pass the buck. I've gone from door to door to door to door to door, say where it is. It's sitting in Minister Ali's office on the shelf. It's got all the tabs on it. And she says to me, it's not operational. We can't operationalise this. So is it worth pushing to have the National Anti-Racism Framework and the Parliament accept it and deliver it, implement? Or, if the government aren't interested, then what's the hope? Is it a tool that we should be using and pushing for?
In our submission, we've supported the uptake of the National Anti-Racism Framework. We see it as an important start, but it's telling that something as, I wouldn't say inoffensive, but it's something as practical, I mean the word was impractical, but something that has practical, tangible opportunities to shift where we are as a nation when it comes to the matters of race, which is so, these blow up all the time in public discourse. Imagine if we actually had a strategy for addressing that so it didn't have the same potency that it has. It's unfortunate that in a Labor majority government where the referendum failed, that this couldn't be taken up as pretty much a moderate position. We saw at state level, Labor pandered to the far right in the suspension of human rights initially around youth justice reforms. It didn't save Labor then. It's not going to save them now federally. And I just think we have to take a position where we stand when it comes to race and racism. You can't be neutral and objective to this matter. It is real, and pretending that you can be impartial and objective when it comes to race is a futile position, but it itself reflects a position. And I think we just have to agree, where do we stand with our commitments to eliminating racism?
Did you want to comment?
Oh, no, I would just concur with Chelsea.
Thank you.
Thank you, Senator Thorpe. So you talked about the attacks that you got from the media in particular. I'm wondering if you've got any contribution or anything that you want to advise the committee about in terms of where you feel the media's role in all of this, and what would you like to see happen?
Yeah, I mean, I think the media plays a role, but I often find in conversations about race, we blame the media as this monster, as though blackfellas aren't active agents in the media as well. I think I remember my first op-eds I wrote for the conversation over 10 years ago. I think it was about Invasion Day actually, so it was longer than that. But they had to suspend the comments on the article because as an academic I was accused of being a petrol sniffer. Now, I wasn't surprised at that. It was disappointing that there couldn't be an actual conversation about an article in the conversation, which was its purpose. But for me, the media is also something I use and harness. And I use it strategically. Blackfellas use social media. I think about Amy's work around black justice journalism, that we are players in it. And our mob have always been quite savvy around black media. I think about the legacy of the Watson family, Uncle Tiger Bales and the formation of 4AAA and using the media. Unfortunately, mainstream Indigenous media is the eye seems silent in Indigenous, but our roots were grounded in taking control of black media and using that medium. I think about the legacy of the late John Newfong, who was critical in the movement, who was, left the job with mainstream media because his editor said it was a problem that he focused on reporting on black issues. And so I think there's also, yes, the media is a problem, it's a beast, but in that conversation, how do we resource independent black media and supporting blackfellas who really creatively harness it and play with that as a tool and as an instrument?
Yeah. Okay. Sorry, go on.
Yeah.
Oh, yeah, no,
This is the journalist side.
I would agree with Chelsea in the sense that what we're seeing, like the mainstream media or the imperial media, has always been its focus in relation, particularly in Queensland but across Australia, was in really justifying the original sin on this land, which was the theft of Aboriginal land and building the nation. And that's something that it's continued to do even in a commercial sense. We have the highest, densest media concentration in the country. I think Chelsea mentioned the Murdoch press earlier, which has been highly violent towards Aboriginal mob, and particularly in relation to when we were talking about the neoliberalisation of Indigenous policy and winding back Indigenous rights. Murdoch media has been a key violent force in relation to that and incredibly powerful. That's something blackfellas have always recognised, and from the very first beginning of the original invasions, blackfellas were utilising the media in different forms in order to be a resistance to that. I think the issue we have is something that Chelsea just alluded to, was a lot of our Indigenous media, for example NITV, I would never call for it to be defunded, but it is operating like a white version of black media because it has to be under SBS. If you talk to a lot of people who were advocating for NITV, which led to the NITV. What NITV was and what it was funded for was a far cry from what blackfellas and black media legends were actually calling for. And so that's really, it's always been a far cry from the original aspiration for what black media is. And what we see as black justice journalism or independent black media is a media that really fights for the rights of blackfellas. And that's actually in opposition to a lot of the cornerstones of the way journalism and journalistic practice actually operate, and standards of journalistic ethics. So black media is actually there as an arm of activism, and that's how it's always been. So we have, for example, the example of Uncle Graham Brady, Uncle Lionel Fogarty, Auntie Cheryl Buchanan, who were involved with Black News Service here, which would go out and actually, and I think she can talk more in detail to that, who actually went out and actually told communities who were living under the Act about the violence of Indigenous policy in Queensland and what was happening. And so black media plays such an important, critical role as a resistance to the continuing racist violence across the country. That's what community radio, Indigenous community radio, has always been. And if you go back and actually look at what was being called for, which led to NITV, it was a far cry from what NITV actually was. And so that's where we talk about it's already happening, but it's different to the way that other people envision journalism or media. And so I think independent black media is that continual resistance and a voice for blackfellas that is not authorised through white authorities.
As if I can just add on to that, I think often our anti-racist strategy, we centre the perpetrator. And I think about even teaching, when we're teaching in a classroom about race and racism and these emotional, people are sensitive and emotional, or even any Indigenous content in curricula in Australian higher ed. We were met with that overt racism hostility. And, over the years, we reflect on our methodology that there are times where that one student who was the most resistant, whose mind you're never going to change no matter how much facts and evidence and proof you give them. And there's a danger when we centre them in our pedagogical approach, because everyone else misses out on the opportunity to think about what their anti-racist strategy might be. And so learning from that teaching environment, in our anti-racist strategy, our focus is not appealing to the perpetrator of racism for validation. That in itself is us buying into that racial logic. Where we focus a lot of our energy in is building a black infrastructure that fights racism. And I would hope that through this inquiry we think about not how do we get people to say yes to the thing we're putting up and offer a more moderate solution, but how do we instead just invest in building the infrastructure of blackfellas who are capable of fighting racism, and building a collective and a coordinated strategising, whether it's the arts, media, the academy, and thinking about how do we invest in Indigenous organising infrastructure fighting racism. It doesn't mean we still don't do that, but we can't just be smashing our heads against a wall to someone who's never going to see our humanity. How do we organise, how do we build our communities? Because we used to have that. As our communities are becoming more geographically dispersed, it's becoming harder to do that. And so we have day jobs, but we also have, Amy's established the Disappeared Project for an organising infrastructure. We established the Institute of Collaborative Race Research. We built an Wonga, no operational funding. It has existed for 20 years. We just build this infrastructure outside of our day jobs because we know we need it. And it shouldn't be an aside, it should be at the centre of Indigenous affairs.
Thank you. I feel like there's probably some more questions to come your way, but we are at the lunch break. Thank you very much for taking the time to come and speak with the committee this afternoon. We really appreciate your valuable insights and contribution to this inquiry. Any information you've taken on notice or any additional information you want to provide, if you can please forward it to the Secretariat by the 18th of August. And you'll be sent a copy of the transcript of your evidence and have an opportunity to request any errors that you see there.
Okay.
Thank you very much
for having us.
We will now suspend for lunch and return at 1:30. We will resume from lunch. I now call on Ms Natalie Lewis, former Aboriginal and Torres Strait Islander Children's Commissioner in Queensland, and representatives from the Queensland Council of Social Services to give evidence. For the Hansard record, would you please state your full name and the capacity in which you appear before the committee?
Hey, thank you. Good afternoon. My name is Natalie Lewis. I'm a Gimiloro woman. It's in a personal capacity that I appear this afternoon. I am the former Commissioner for Aboriginal and Torres Strait Islander Children here in Queensland and can speak to the submission that was made in June.
Thank you.
Prior to completing, yes.
Yeah, appreciate that. Thank you very much, Ms Lewis.
Good afternoon. My name is Amy McPhee and I'm the CEO of the Queensland Council of Social Service.
Excellent. Thank you very much. Although the committee does not require you to give evidence under oath, I should advise you that this hearing is a legal proceeding of the Parliament and therefore has the same standing as proceedings of the respective houses. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege and is being broadcast live on the Parliament's website. You can see from the nameplates in front of us who is joining you in the room today, and I might just take the opportunity to do a quick check to see if we've got Mr Venning joining us via teleconference. Oh, no, he's not. No, he's not online. No, he did tell me he wasn't returning after lunch. That's my error. I'll now invite you to make a brief opening statement. I might start over here.
Yep, sure. Okay, so thank you, Chair and committee members. Can I acknowledge that we meet on the lands of the Yagara and the Turrbal people? Can I pay my respects to their elders? This place has a significant history of strong advocacy for Aboriginal and Torres Strait Islander children and young people, and it has truly been the grace of my professional career to be able to advocate in a similar way for our kids in statutory systems across the state. My central message is simple. Racism is not only what individuals say or do, it's also what institutions permit, what they reproduce, and what they eventually learn to call normal. When racial disparity is known and predictable, continued inaction becomes a policy choice. Aboriginal and Torres Strait Islander people should not have to keep proving that racism exists. Governments must prove that they are prepared to act. Today, I'll try and just cover off very quickly three things that were central to my submission: how institutional racism operates, the developmental harm that it causes children, and why the Commonwealth has both the responsibility and the power to act. Racism is empirical. We see it in who is watched and who is believed, who receives care and who receives surveillance, who is protected, who is removed, and who is punished. For Aboriginal and Torres Strait Islander children in Queensland, racism is not an abstraction. It is encountered in their schools, their hospitals, the Child Protection Office, the courtroom, the watch house, the detention centre. Government creates these systems, appoints the decision makers and funds their operation. It cannot build the machinery, ignore its results and then declare itself innocent of the harm that has been caused to children. These systems do not merely respond to disadvantage. Too often they create it, they compound it, and then punish children for its consequences. Racism is fundamentally about power. Institutional racism does not require explicit intent. It operates through those whose knowledge is accepted, whose risk is exaggerated, whose family strengths are discounted, and who encounters state coercion. Racism was not named in the terms of reference for Queensland's Child Protection Commission of Inquiry. It was seen to be outside of scope for discussion. That omission mattered and will result in significant policy reform that will absolutely harm Aboriginal children in this state. Aboriginal children are not overrepresented by chance. We are asked to look directly at a profound and persistent racial pattern of overrepresentation and pretend that race is absent. The absurdity is not hidden, it has been made official here in Queensland. Aboriginal and Torres Strait Islander families must account for every perceived failure, while the system is not required to account for the racial pattern of its decisions and the harm that it has produced. That grants the system a presumption of innocence, never extended to Aboriginal children or their families. For children, racism does cause developmental harm. The evidence is unequivocal. Racism is a determinant of children's health and development. It activates chronic stress, harms mental and physical health, disrupts sleep, concentration and learning, and damages identity, safety and belonging. Sadly, discrimination doesn't wait until adulthood to cause harm. Racism reaches into childhood and makes inequity feel like destiny. Racism is a condition imposed upon our children. It determines who enters the world presumed innocent and who enters it already under suspicion. It reaches children through humiliation, but also through the quieter machinery of government, the assessment, the funding formula, the placement decision, the refusal of bail, the closed door, and the service that never arrives. Each decision may be presented as ordinary. The accumulated result is an extraordinary inequality. It is built into laws, funding models, service thresholds, institutional cultures, workforce arrangements, risk tools, and the distribution of decision-making power. Those structures shape what happens in individual cases. One family will be offered support, another will be subjected to surveillance. One child's distress is understood as vulnerability, another child's distress is treated as danger. One child is diverted and one child is charged. The decisions may be made at a point in time, but they are not made in isolation. They are produced within systems that determine what options are available, what risks are recognised, whose knowledge is trusted, and where resources should be directed. Racism survives when government separates these decisions into individual files and refuses to examine the structure connecting them. Overrepresentation is the accumulated result of that structure. It is not the cause of the inequity, and it is not an explanation for it. Government collects extensive data describing Aboriginal disadvantage, but it must begin producing evidence about the laws, institutions, and resource decisions that manufacture the harm. Inequity is not an unfortunate outcome at the end of a system. It is built into the conditions under which decisions are made, reproduced through those decisions, and then presented to the public as if nobody designed the system. Racism doesn't end when the insult is spoken, the file is closed, or the child is released from custody. The science measures part of the injury. The child carries the rest. Aboriginal children have demonstrated extraordinary resilience. The question is why government continue to construct systems in which they must be extraordinarily resilient simply to survive an ordinary childhood. Protection from racism must include the active protection of culture and cultural rights. Family, kinship, community, country, language and culture are fundamental rights, sources of strengths and foundations for identity and belonging. When our senior political leaders in Queensland describe children as scum, as grubs, race need not be named for racialisation to occur. In a system where Aboriginal children are grossly overrepresented, this language turns Aboriginal childhood into an object of fear and contempt. Dehumanising children prepares the ground for them. It is the public degradation of children by adults who control the institutions capable of arresting, detaining and punishing them. It invites the public to see punishment before childhood and contempt before possibility. It asks us to see the offence and to forget the child. Its foreseeable effect is particularly dangerous for Aboriginal children already subjected to racialised suspicion, surveillance and punishment. Political language shapes the environment in which police, courts, caseworkers, service providers and the public make decisions about children. A government cannot credibly claim to protect children while teaching the public to despise them. Dehumanising language is not separate from policy. It prepares the public to accept what policy may do later. And that is exactly what we are witnessing in Queensland. Dehumanising children is incompatible with the responsibilities of public office, and the Commonwealth cannot claim national leadership against racism while accepting the behaviour of politicians in Queensland. The Commonwealth cannot dismiss racism in these systems as solely a state and territory responsibility. Safe and Supported already recognises that protecting children is a national responsibility and commits governments to addressing overrepresentation. The Commonwealth has powerful levers: legislation, funding, agreements such as closing the gap, for those of us that have any confidence left in that, national standards and intergovernmental agreements. It must use them. The Commonwealth cannot fund systems, observe their racial consequences and then claim that the harm belongs entirely to Queensland. When the Commonwealth sees the harm, holds the power and chooses not to act, it is complicit. I might end there because I think I don't know if we're running through some time. But
You're welcome to table your opening statement too.
yeah, if I can,
Yeah.
that would be great. But
Yeah.
just if I can, just in closing, that the evidence just leaves no neutral ground. Racial disparity, developmental harm, and the removal of Aboriginal authority here in Queensland is connected to expressions of power. The Commonwealth must move from acknowledgement to obligation, from consultation to shared authority, and from measuring disparity to eliminating it. Aboriginal and Torres Strait Islander children do not need another government to admire their resilience. They need governments to stop demanding it as the price of survival in this country. Thank you.
Thank you, Ms. Lewis. Ms. McVeigh.
Thank you, and thanks for the opportunity to speak to you today. Can I begin by acknowledging that we're on Turrbal and Yagara land and pay my respect to Elders past, present, emerging, and to all of the First Nations people in the room today. And I can I particularly pay respects to Ms. Natalie Lewis, who has provided decades of leadership in Queensland and made a phenomenal contribution, including until recently as our Aboriginal and Torres Strait Islander Children's Commissioner. QCOS is a peak body for community services in Queensland. Our vision is for equality, opportunity and wellbeing for all Queenslanders. We are a non-Indigenous organisation and our submission was based on feedback from our member organisations who are community organisations across the state. Our submission was limited in terms of the terms of reference that we responded to, and in particular we talked about the initiatives that are effective in combating racism targeted at First Nations people, as well as responding to other matters that were relevant. We focused most specifically on institutional racism or institutional discrimination. And those systems are those systems where we see that disproportionate harm done to First Nations people. We spoke specifically about overrepresentation in the child protection system, the youth justice system, in homelessness figures and in victim survivor figures of domestic and family violence. There are some really clear examples of things that have gone well in Queensland, and we emphasised those and encouraged such measures to be used into the future. The first is truth-telling, treaty and voice. We expressed our deep disappointment at the brutal ending of the Truth-Telling and Healing Inquiry and the repealing of the Path to Treaty Act in Queensland. Queensland must have a truth-telling and treaty process, and we will continue to advocate for these processes to be recommenced. We also point to the success of government policy that's underpinned by the right to self-determination, and in Queensland this has included strategies such as Our Way in the child protection space and Our Place in the housing space. It also includes ensuring that we have roles like an independent Aboriginal Torres Strait Islander Children and Young People Commissioner. We are really concerned that these approaches are being abandoned in Queensland. Finally, investment in community-controlled organisations in Queensland has led to significant positive outcomes for First Nations people and in combating racism. We advocate for the expansion of these types of services, further investment in these services, and including expansion into being funded to provide specialist domestic and family violence services and specialist homelessness services. I'm happy to take any questions. Thank you.
Excellent. Thank you both for your opening statements. We'll proceed to questions and begin with Ms Cook.
Thank you, Chair. Thank you both for coming today. We really appreciate your time and your submissions as well, which were quite detailed. Ms Lewis, if I can start with you, can you expand on your concerns around some of the recent state legislative and policy developments that we've seen in Queensland, and any concerns specifically around youth justice, or if there's other areas? You've already touched on quite a few in your opening statement, but if there's some that you haven't yet had the opportunity to talk about, could you share some of that with us?
Yeah, certainly. I think that there has been a very deliberate dismantling of spaces where Aboriginal and Torres Strait Islander people in leadership positions across multiple portfolios have an opportunity to provide input or to provide critique of proposed changes to policy. I think that we've seen very active efforts around mainstreaming, whether that's in the health space, in the education space, in the child protection space. There's been an absolute aversion to any targeted efforts that seek to address the disproportionate representation of Aboriginal and Torres Strait Islander children, either in statutory systems or in targeting their underrepresentation in terms of equitable access to universal and targeted supports. So this idea that anything intentional, deliberate, resourced and led by an Aboriginal or Torres Strait Islander person or unit within a government department is seen as these unnecessary, special benefits or additional extras that we're, that are giving for Aboriginal people. There's no recognition that those responses and those dedicated responses have been necessitated because of decades of government failure to actually uphold and promote and protect the rights of Aboriginal and Torres Strait Islander children who interact with government systems. So,
thank you. Can you also discuss, in your experience during your time as the Commissioner, can you talk about the experiences and impacts on First Nations children that you came into contact with in relation to some of the harmful practices, both within those institutions and the systemic racism that you described earlier, but also in terms of some of that mainstream media and some of the online spaces, just kind of the breadth of that? I know you've talked about some of it, but if you could just expand about what those children had experienced that you had that contact with?
Well, certainly in my previous role we had a function of performing oversight, not just of the statutory systems, but in looking at access to education, in terms of health services and things like that. And so I've always taken an approach that is anchored in children's rights and sort of commences and ends with the people who are most impacted, and that is children. So talking to children and young people who are impacted by those decisions or by those systems, in those interactions, I have never had an engagement with young people where racism has not been a feature of their disengagement from school, their lack of safety in community, the impact on their identity of consistently hearing nothing but negative things portrayed, in terms of the media. They bear witness to the community anger and sentiment that they know is absolutely going to be squarely targeted towards them. And so I think that there is not a single area of social policy where racism has not been a significant contributing factor to the disengagement of our children or the underutilisation of the types of services and supports that we would reasonably expect every child in this country to have access to.
Thank you. Just some questions for you, Ms McVeigh. What kind of initiatives would you like to see expanded if more funding were directed towards them from your member organisations? Is there a bit of a priority list, or what's at the top of your list in terms of where you would like to see direction of resources?
I think we start by looking at those areas that have a disproportionate impact on First Nations people. And so if we, for example, look at the youth justice system, we have a trend in Queensland towards a more punitive approach to youth justice that commenced under the former government and has continued. In 2024, we have a Human Rights Act in this jurisdiction, so when we have new laws tabled, there is an acknowledgement of whether there is an unjustifiable limit to a particular group of people's rights. And in 2024, when we had the introduction of the adult crime laws, which treat children the same as adults in the justice system, there's a specific acknowledgement that those laws have a disproportionate impact on First Nations children. So taking that as an example, if we look at the reasons why First Nations children might be coming into contact with the youth justice system, it is very clear that we need to address the root causes of antisocial and problematic behaviour if we're going to address youth crime. And what are those root causes? Those root causes are things like homelessness, poverty, intergenerational trauma, domestic and family violence. And so those are the types of things that need to be addressed. How do we address those things? We need to work with First Nations communities to develop culturally appropriate place-based responses. So those would be the types of services we'd like to see further investment in. If you look at domestic and family violence in Queensland, we have a recently established domestic and family violence peak body that is only able to represent specialist domestic and family violence services. If you look at how many community-controlled organisations there are in that space, we haven't been able to identify any. And so, and the same in the homelessness space, we have a disproportionate representation of First Nations people in homelessness data, and yet we don't invest in community-controlled specialist homelessness services.
Which follows to my next question around, in your submission you called for co-designed investment and a roadmap to fund, looking at the funding gaps and service duplication. What does effective co-design look like? I understand the community-controlled element, but what would that look like?
Well, I think we need to start from a place, so say, I think we made that point specifically in relation to the youth justice space, because alongside these punitive laws, we saw increased investment into youth justice services, which is obviously on face value a really positive thing to see more investment into services. But we didn't see, we had an Auditor General report that came prior to that, which looked at what kinds of services we should be investing in. And it's not that we should take a scattergun approach. We should be working directly with community, in community, to design services. And so we need those enabling strategies like the Our Place strategy that I referenced, or the Our Way strategy, to then put a framework around how co-design will occur and ensure that people are brought to the table in genuine partnership.
Thank you. Just one final question, Chair, for Ms Lewis. Have you, well, earlier today, one of the people giving evidence, I think it was Commissioner Kiss at the time, gave quite an extensive list of, I think it was described as sort of a systematic dismantling. You've also referenced that sort of systemic and systematic dismantling of Aboriginal and Torres Strait Islander positions, policies at a Queensland state government level. Have you heard about that? Can you talk about that some more in terms of what you've seen across the Queensland government over the last, say, 12 months?
Yeah, I mean, I think there's certainly been a fairly, I mean, commencing with abolishing the, Truth and Healing inquiry, but in terms of positional authorities, so board representation, there's obviously been a lot of departures of Aboriginal and Torres Strait Islander people from those boards, not necessarily voluntarily, across different government agencies. My position was the only identified statutory officer across all of those bodies. There are now none, and there is no commitment to replace that role going forward. So I think that they're one aspect of it, and they're the things that have been really visible, and they're the things that have that I certainly, in my experience, in that, in my last 18 months at the Commission, I could see, witness every single day that's those spaces were fewer and fewer, and there were less and less of us. There was certainly a very obvious aversion to accountability, and for people speaking out, criticising, government policy. So I think it has become very apparent to anyone paying attention that independent critique, rights-focused advocacy doesn't have a place currently, and that is highly concerning, because that social experiment will end poorly, and most poorly for Aboriginal and Torres Strait Islander children. And so, so I think that, you know, it's important to pay attention to those things. But at the same time, you know, we still haven't seized the opportunity at a national level for, Commonwealth human rights legislation to anchor within that framework all of the things that we have signed up to, all of the treaties that we have ratified. Aboriginal kids want nothing more than what has already been promised under the ratification of the UNCRC. But yet we have no clear plan to embed that in domestic law. So I think that for me, the thing that's missing the most is the focus on accountability and an architecture that is grounded in the human rights of all Australians, because it is in the examination of that the inequity for Aboriginal and Torres Strait Islander children becomes most apparent. So I think that for me, those big structural reforms are critical. Accountability of governments, and I can only say from my personal experience, I could care less if I never saw another national agreement or strategy, because I have literally sat at the table at Joint Council for Closing the Gap. I have, contributed to the previous national framework, the current national framework, the action plans for Aboriginal and Torres Strait Islander children, and I wonder what is the value of those pieces of paper beyond a photo op? Because when we come back to the table in these shared decision-making forums and we have states willingly abandoning the obligations under those agreements with no consequence, like, that I think that's for me what reinforces the importance of having legislative architecture and having the Commonwealth very, very clear about when they can exercise, the type of powers and powers of intervention in the interests of Aboriginal and Torres Strait Islander children, instead of for the control and surveillance of them. That would be really welcomed.
Here. Well done. Thank you.
Thank you, Ms Cook. Senator Thorpe.
Thank you. Thank you for your for both appearing today. Mrs. Lewis, I'm an independent sovereign black senator, and a lot of the things that you just raised, I personally have been pushing the last government and now this government. Thought we had a little bit of hope with this government, but there's actually no appetite from the federal Labor government. Absolutely zero. On truth-telling, on the Aboriginal Child Placement Principle, which they handball to states and territories, even though they have the constitutional power. There's no movement on deaths in custody, suicides, homelessness. We have a Mount Isa community about to be evicted. We have homeless people in the NT about to be evicted, Aboriginal people. So there's absolutely no appetite here. I'd just like to know what your thoughts are about the ongoing genocide of First Peoples in this country, and whether you think this constitutes a genocide, and whether you think that without any action from a government that we have now, who promised the world and delivers nothing, whether they are also complicit in this ongoing genocide.
Yeah, thanks for that question, Senator. I think what has become incredibly disappointing is that there is a massive opportunity in terms of having such a massive majority to be able to pursue ambitious transformational reform. We have spent 2 decades tinkering around the edges and thinking that funding initiatives or programs or whatever is somehow going to radically transform this nation. And I think that the opportunity that is before us to progress those transformational changes is not going to come around again in the near future. And so it is very frustrating to think that more of the same is the best that we're capable of. And when we think about what is happening here in Queensland, we have raised so many times in different forums how much we need for the Commonwealth to flex and to engage and to promote and protect the rights of Aboriginal and Torres Strait Islander children. The youth justice reforms that are happening here in Queensland, we don't get the luxury of talking about unintended consequences and throwing apologies around in another decade, because we know and we proceed anyway. There is an abandonment of evidence. Nobody is interested in evidence that says that when you treat children with dignity, when you address their needs, when they feel safe, they are less likely to offend. But people don't want to hear that narrative. They want to believe that the monster is lurking and that the government is doing all it can to protect, its, good citizens from these wretched kids. And so when we have evidence in front of us, it is the function of government to make informed decisions about policy in the interests of the people in this country. And to see evidence play such a little part, or in Queensland, no part, in decision making is irresponsible governance. And I have to believe that we are still far capable of far better, and that there will be people that step up and lead. And as much as it's convenient to flick past the responsibility to jurisdictions for the issues around child protection and youth justice, while the states may operate or administer those systems, the Commonwealth is responsible for the treatment of children within those settings. And so when we see those decisions being made where we know the pathway only ever ends in harm to children, and we turn away and don't intervene, that's unforgivable.
Thank you to my answer on genocide, but it was in the Bringing Them Home report.
Yes.
Taking children away and...
Well, it would be difficult to argue with Commissioner Kiss's breakdown of it this morning.
Thank you. Thank you. In your submission, you state that racism is embedded in system design and that current accountability mechanisms are insufficient to deliver equitable outcomes. What could effective accountability mechanisms look like?
I think we've started with the establishment of the National Aboriginal Children's Commissioner. I think that in terms of having an independent secured in legislation and having very clear, unapologetic language around rights and oversight and accountability, like within that legislation, I think is a good start. I think that an amendment to the Racial Discrimination Act to enforce a positive duty on public entities, employers, service providers, to prevent and eliminate discrimination, I think would be welcome progress and definitely contribute to accountability. I think a requirement for all oversight bodies to be able to measure racial disparities across policy decisions, their implementation and the outcomes achieved for people. I think that provides a lot more clarity and honesty about the role of structural racism and the impacts on individuals. I think that there has to be greater accountability attached to government funding. It can't just be about delivering a certain number of activities or holding a caseload of a certain number of people for a certain amount of time. There has to be a positive obligation on people to report on how they're utilising those funds and how in the utilisation of those funds they are promoting and protecting the rights of children and young people.
Great, thank you. Ms McVeigh, whilst we're on the subject of positive duty, Can you tell me, with the organisations that you represent, how they contribute to systemic racism?
Thank you for the question, Senator. I think that one of the things that we were looking forward to as a sector in relation to the truth-telling inquiry was to examine the role that the community services sector has played in the harm that's been caused to First Nations people. As you know, a lot of our organisations have their genesis or their origin in faith-based organisations, so it's an important conversation that we need to have. QCOS recently undertook a consultation with our members looking at what are the key characteristics of an organisation that achieves excellence, when excellence is defined as achieving outcomes connected to your mission. And through that consultation, which went over a year or so, cultural capability emerged as one of the, I think it's 7 pillars that an organisation needs to focus on. So the sector itself acknowledges that if they're going to achieve the outcomes they need to achieve as an organisation, they need to pay attention to how they work with First Nations people.
Can you tell me what cultural capability is?
So in relation to our excellence, when described in our excellence framework, it's about having the capability to work with First Nations service users.
And what does that look like?
So there's many elements to that, Senator, but one thing, organisations need to take multiple steps. So, for example, that could include reviewing your EBA to make sure that you have appropriate employment conditions for First Nations staff. It can include having a HR strategy that makes sure you're giving as many opportunities for employment to First Nations staff. It can include making sure that your staff are regularly trained. It can include looking at opportunities to divest your particular services to other services that are community controlled and better suited to delivering those services.
Anything about racism?
Yeah, I mean, I think that's that should be explicitly called out, and I should have said that.
So all your organisations are checked for racism?
No.
Do they all, are they encouraged to undertake anti-racism training?
Look, I think, so for community organisations in Queensland, I would say the majority are government funded. And then it depends which government department you're funded by as to sort of what the...
As the peak body?
Yes. Do we require our members to undertake...
Not to be racist?
I mean, we don't play a regulatory role. We certainly have a set of values that we ask our...
Is one of those not to be racist?
It is not.
Why not?
So that's a good question, Senator. At the moment, our membership criteria includes being a community service organisation that operates in Queensland and wanting to be part of a movement that seeks equality, opportunity and wellbeing for all Queenslanders. The reference to equality obviously speaks to discrimination, but we don't use the word discrimination explicitly.
Is that something that you think should be? Like, given you're at the racism inquiry and we're talking about racism and how racist this country is, including the services that our people have to beg at the door for to get a home or a feed or one of those services, as a peak body, wouldn't you want to ensure that you don't have any racist organisations that you're representing?
Look, if we were aware that an organisation was a racist organisation, that would be a significant concern to us. We we take our responsibility to partner with community-controlled organisations and other peak bodies really seriously. We advocate for organisations to be engaging to increase their cultural capability. QCOS ourselves, we are continuing to be on that journey as well.
A bit like the place I work in, you know, always trying and developing another plan and another inquiry. What evidence has QCOS gathered about the impact of racism on Aboriginal and Torres Strait Islander women seeking housing, income support, child protection, healthcare and legal assistance?
I can't answer that question specifically, but I'm happy to take it on notice because we would have captured data in a range of different ways, and so I can't answer today, but I'm certainly happy to take it on notice, Senator.
Thank you. Does QCOS believe that mass incarceration of Aboriginal and Torres Strait Islander people is itself evidence of systemic racism? And if you do believe that, what has QCOS publicly advocated?
Yeah, so yes, we do think the overrepresentation of First Nations people in the criminal justice system is an indicator of racism and is itself a form of institutional racism. At QCOS, we have had a significant focus on the youth justice system in particular. We partnered with Change the Record to campaign for raising the age of criminal responsibility to 14. We have been a very active and public voice campaigning for reducing the use of punitive approaches. We have hundreds of mentions in the media talking very publicly about the disproportionate impact of the youth justice system on First Nations children. We are partnered with QATSIP, the Aboriginal Torres Strait Islander peak for child protection. We partner with them to deliver the youth justice service, and when I say partner, they are the leader and we follow their lead in that space.
And you talk about divestment. So services that realise that our services are better to provide it, are they actually closing shop and given their funding to the community controlled? And if so, how many have done that and how many more will do that?
Senator, there are specific examples of organisations doing that, and I'm happy to provide the response on notice with more detail.
Okay, thanks. And just back to Mrs. Lewis. You emphasise the importance of independent Aboriginal and Torres Strait Islander-led oversight, yet we see how undervalued independent commissioners are by governments across the country and how rarely, if at all, their advice is being followed. So how could this actually operate in holding governments truly accountable and leading to change?
So I guess the experience of commissioners, First Nations commissioners across the country are all probably different because they've all got different legislative mandates. They have different powers, different levels of independence, different resources. We've got, some in South Australia that have all the powers that they would need. They've got the full powers of a Royal Commission, but they're starved of resources, so I can't really do anything with those powers. Then we have sort of the other example of my previous role, while it still exists in legislation, the extent to which my role could focus, utilise resources of the Commission, advocate for Aboriginal and Torres Strait Islander children to a large degree, and when I look across how that role has played out across the previous decade, has been subject to the benevolence of the Principal Commissioner. So as much as the, White Commissioner, Principal Commissioner, is prepared to resource the work that you're saying is a priority, or open up spaces for you to lead decision making, or to decide what types of oversight activities you're going to conduct. All of those things are constrained by the will or the imagination or the comfort level of the person who leads the organisation. So I think that has problematic, and what has been, interestingly, again, under safe and supported, agreed by every state and territory, was progressing independent, empowered, appropriately resourced commissioners for Aboriginal and Torres Strait Islander children to perform functions of advocacy and oversight and accountability of governments. Every jurisdiction agreed to that nearly 5 years ago, and none of them have progressed any further towards achieving that legislated independence and resourcing of those positions. So it's hard not to look at that and question the sincerity or the commitment to actual oversight and accountability when it comes to Aboriginal and Torres Strait Islander children. And when you've got jurisdictions like Queensland that have actively walked backwards, so, you know, are now not committing to even have the gammon roll that did exist, that is concerning. But again, no consequence, you know, for failing to uphold that commitment.
Yeah, thank you. You outlined a number of important recommendations in your submission, including the introduction of a statutory duty to act. Can you outline what this means and how it would operate?
Yeah, I think that, you know, we've got a lot of organisations and departments, you know, that talk about, you know, them being committed to eliminating racism. They usually cite the priority reforms from Closing the Gap, and the sort of verbalisation or the writing of that on a document is usually testament to, you know, like their commitment. But then we see very little action. So in terms of an enforceable duty to look for, to monitor and to report on systemic racism as it plays out in policy design, in policy implementation, in practice and in outcomes for people, I think raises the bar and levels the playing field, you know, where it's not just a pleasant thing to do or where it's, you know, a demonstration of wokeness. It's actually a commitment to uphold international law and the commitments that we've made, you know, to all Australians around our stance on racism. So if we believe that, we would back that in, and people that accept that would be willing to accept the accountability that comes with it. But one of the things that we do see play out is, you know, around when we talk about things like cultural safety. And so when we look at regulatory schemes that operate, particularly around the safety and wellbeing of children and young people in their interactions with government services and in funded services, we have the Child Safe Organisation scheme here in Queensland. We have now the Reportable Conduct scheme. Most of where that bar sits is the demonstration of, you know, your commitment around cultural safety in terms of the universal principle. Most often just lives in a document, you know, and it doesn't translate into the interactions that Aboriginal children have with DV providers, with early childhood and care services, with, you know, their local GPs. That's the litmus test in terms of, you know, how safe are Aboriginal and Torres Strait Islander children. And I think that sometimes it seems that the terms like cultural safety have just become a polite way to avoid having to say racism and address it. And so I think that while having our culture visible, respected in spaces that we are, that's important. But at the most foundational level, those interactions should be lawful. That'd be a great start. And so in terms of taking racism seriously, we've got to be careful that terms like cultural safety aren't used to mask a lack of willingness to tackle racism in institutions and in services.
I'll do one more. I was waiting for you to look at me.
You also got one question, so you're welcome.
You also recommend the establishment of threshold triggers requiring mandatory system response. What could such threshold triggers be?
If you're looking at disproportionality, so if you're looking at seeing the child protection system, when you look at, there are different points along a continuum where the overrepresentation of Aboriginal and Torres Strait Islander children grows. And so when you look at the policy settings that establish those points across the continuum, you can see those numbers fluctuate from time to time. So when we see the disproportionality of, the rate of disproportionality increase of Aboriginal and Torres Strait Islander children that are being notified to the department, there's a threshold there that tells us this is above the norm. Like, or this is, you know what I mean? Like this is going to actually result in higher rates of removal, longer periods of time away from home, less likelihood of reunification, high probability lifelong poor outcomes. You know, like, so there's these triggers that we can look for that are reflective of different policy settings that are open to be changed and adapted. So when we're starting to see a big influx in terms of rates of notifications of Aboriginal children in a particular location, then that should trigger a response and understanding of what is driving that. Is there an issue in terms of accessibility to DV support services? Is there a change in the manager? Like there's a number of things that should capture our attention and cause us to ask questions and to course correct, rather than sit on a policy framework for decades and be unsurprised by an ever-increasing number of Aboriginal kids being removed from their families.
I'm happy to hand over.
Thank
I
you.
do have more, but go all day.
Thank you, Senator Thorpe. I just had one question, really, which is, I mean, you've talked about how a part of the challenge with agreements like closing the gap or whatever, whatever kind of policy or commitments we make is that people feel really comfortable not achieving any of those objectives or those commitments, and there's no real consequence for it. I think you talked actually quite a bit about that in the evidence that you've given to the committee today. Where do you see, like, do you have a view about what some of those consequences should be when you think about what would be fair in response to state and territory jurisdictions not meeting their the things they signed up for? And have you had a conversation with other people as well? And do they share your views, or are there kind of a variety of views about what the consequences should be for state and territory jurisdictions who fail to meet their obligation and in fact go backwards?
Yeah, I think that there's been a lot of, while it's a separate committee, but I think in terms of the discussions around youth justice, there's been a lot of discussion, and actually there's a fair amount of consensus on the need to utilise funding as an incentive or as a disincentive, or as and so I think those types of levers, the funding levers, are incredibly important, but they become even more meaningful when you have, sitting above that, a commitment to the rights of children and young people, and from that can flow budgetary processes that prioritise particular outcomes, that can prioritise particular populations that do experience a disproportionate adverse outcome with their interaction of systems. And so when that's guided by a clear intent to address inequity and to hold service providers, it's not just about the government, but it's also about service providers. There should be the level of tolerance for the investment in failure, just blows my mind. And so when you see time and time again initiatives that are funded through the Commonwealth into states and territories that do not move the needle at all, in fact, just further entrench what is a poor policy platform, and they continue to reward it by providing funding to tap programs on, to legitimise that or demonstrate that policy in action. And I think that requires greater scrutiny. I think that when you see things like the child placement principle, which in terms of its 5 constituent elements, I don't understand how anybody finds that contentious. that people have a right to participate in decisions that affect their kids, that they should have access to preventative services, that they should partner with the people who are closest to that community and accountable to that community, that we value the connection of children. Everyone gets fixated on this idea about a placement hierarchy and think that that's the extent of the principle, and that by somehow eradicating that, you know, we're going to make all children safer. When we know from the Commonwealth where that came from, where that policy was born, we have to take that seriously, and we have to value and treasure that and protect it. And so when you see the Territory walking that back, Queensland will respond on Thursday to the Commission of Inquiry findings. We will not be far behind. The Commonwealth needs to intervene and look at opportunities for legislating at a national level, compliance with policies that protect and promote the rights of Aboriginal and Torres Strait Islander children, their continuity of connection to culture and to country, regardless of the statutory system that they're in. That is the type of influence and leadership that's required in spaces where Aboriginal kids are most harmed.
So, okay, so when you talk about consequences, you're talking about using kind of funding as part of that one kind of, or that stick, I suppose.
Yeah, absolutely.
To hold state and territory jurisdictions accountable. And when you say that, are you talking about holding back the Aboriginal Affairs funding they get, or are you talking about, you know, in my case, I'm using Victoria as an example, like holding back funding for the suburban rail loop if you don't meet the obligations under the Closing the Gap outcomes? I'm interested in,
whatever floats the boat. You know, it's just kind of, I think that some people are motivated by or incentivised by, you know, certain funding.
Yeah, okay, so use those relationships to understand what the leverage is and what the, what's the thing of interest for people that might get them to motivated to get better outcomes for our kids.
Yeah, and when there is funding that is specifically around closing the gap, it must demonstrate an outcome. It must produce an outcome. It must have independent accountability mechanisms sitting over the top of it. So there's some, I think, controls that can be placed around not just closing the gap, safe and supported. You know, a whole range of the national strategies where performance and outcomes that make a difference in the lives of Aboriginal and Torres Strait Islander children and families should be a requirement of that funding. It should be a demonstrated requirement of continuing to receive funding. And right now there wouldn't be many jurisdictions that can demonstrate anything but ongoing harm.
And I'm interested in one of the comment that you made, the level of tolerance for the investment in failure. It blows your mind.
Yes.
I'm interested in what your thoughts are about why that happens, and what are the answers to that that you see. I know that's not necessarily an easy question, but
Yeah, well, when we talk about failure, there's not a single indicator across in terms of outcomes in statutory systems. So for kids in out-of-home care or in youth justice systems, there is not a single indicator that has improved in any jurisdiction in the last 5 years. And so that is a clear indication of the policy setting is wrong, or we are resourcing the wrong things or the wrong people, you know, to make a difference. And so I think that this habit of under closing the gap, and I'm not saying this to be controversial, I understand that peaks have a, you know, they have a space, they have a role, but peak bodies have been significant beneficiaries in terms of investment from closing the gap. There has been an increase in scale and scope and footprint for just about every peak body that is, you know, a signatory under the under closing the gap. At what point do we stop focusing on that being the measure of success, that growth and expansion, and actually expect dollars to reach children, young people and their families locally to produce outcomes that are meaningful to them, irrespective of whether there's a target attached to it or not? But I think that we have seen such little progress in those spaces. And I have seen, and I've previously was the CEO of the Queensland Aboriginal and Torres Strait Islander Child Protection Peak. I have seen our peak bodies grow to mimic the systems that fund them. And your ability to mimic bureaucracy is a real threat to the concept and the principles of community control as I grew up understanding them. So, yeah. So this is not a call for get rid of peaks. This is our central focus, the primary beneficiaries of efforts that occur under Safe and Supported, under Close the Gap, under the domestic and family violence strategies, must be Aboriginal and Torres Strait Islander children and their families. And we have barren for evidence to demonstrate where the investment and the approach has resulted in a positive change for them.
Thank you very much. That does bring us to the time that we have with you this afternoon. Thank you very much for taking the time out of your day to come and give evidence to this inquiry. It's appreciated. If you've taken any questions on notice or you want to provide any additional information to the committee, if you could please do that to provide that to the Secretariat by the 18th of August. And you'll be sent a copy of the transcript from today. And if, when reading through it, you see any errors in there, you can request corrections to any errors that you find.
Okay.
Thank you very much. We'll suspend very briefly while we welcome our next witnesses. We will now resume. I call on representatives from the Caxton Community Legal Centre, Sisters Inside and National Network of Incarcerated and Formerly Incarcerated Women and Girls and Queensland Indigenous Family Violence Legal Service to give evidence. For the Hansard record, would you please state your full name and the capacity in which you appear? And I might start down this end of the table and work my way down.
I'm Tabitha Lean and I'm a member of the National Network of Incarcerated and Formerly Incarcerated Women and Girls.
I'm Zofia Wozniak, Director of Programs of Sisters Inside.
Thelma Schwartz, I'm the Acting Chief Executive Officer of the Queensland Indigenous Family Violence Legal Service, or QFLS, and our acronym.
Aaron Lukey, Acting Executive Director of Queensland Indigenous Family Violence Legal Service.
I'm Claire Coles, Legal Practice Director at Caxton Community Legal Centre.
I'm Leanne Collingburn. I'm the Secretary of the Management Committee of Caxton Legal Centre and also a partner at Hopwood Gunham Lawyers.
Thank you very much. Although the committee does not require you to give evidence under oath, I should advise you that this hearing is a legal proceeding of the Parliament and therefore has the same standing as proceedings of the respective houses. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege and is being broadcast live on the Parliament's website. You can see from my name tags who's at the committee hearing today with you. I now invite you to make an opening statement. Have each of you got an opening statement that you would like to make? Or I might start down this end of the table again then.
Well, thank you, Chair, Committee and my sister, Senator Thorpe. Thanks for the opportunity to speak today. My name is Tabitha and I appear for the National Network. I acknowledge the elders, both Earthside and in the Dreaming, on whose country we stand today. And I also want to start by acknowledging the violence of the prison system and hold space because in this moment, while we sit here, more than 25 incarcerated and formerly incarcerated women in Adelaide are fighting in the courts for justice because they were all raped by a prison officer, while that same prison officer runs the defence that criminalised women's testimony should not be treated as reliable because they are quote-unquote criminals. In our culture, we begin with story because stories carry truth and our bodies hold the evidence and they hold what can never be erased. I was imprisoned in one of these countries' cages where, like all prisons across the country, racism is rife towards Aboriginal prisoners. Today I wanted to tell you everything I know about anti-Aboriginal racism in prisons and police, what it's like to be caged in places that kill, contain and harm, but I don't have time in my 2 minutes to tell you more than the following. Part of the story I'm going to share with you I tell with shame and also a lot of rage. When I arrived at prison in the back of a tin can divvy van, I was shaking with fear. I was bustled out and placed in a holding cage about the size of a cheap motel shower cubicle. From there I was taken to admissions, I was strip searched, made to shower, my hair was ploughed through for head lice, my clothes were taken from me along with my dignity, and I was issued my prison greys and a 6-digit number. I am officially number 177057. Then I was taken to intake where an officer began reading me the prison rules. When they told me it was against prison regulations to have a physical relationship with another prisoner, I must have looked confused. So the officer leaned into my ear and barked, basically, Ms. Lean, don't fuck anyone. At that stage of my sentence, I didn't actually realise it was the predation of the officers that I should be worried about. That learning about that violence came a couple of months in. Then they asked me a question that's stayed with me ever since. Are you Aboriginal? I hesitated, and I say that with deep, deep shame because I know my visibly black sisters have never had the privilege of hesitating. They don't get mistaken for anything else. But I was scared. These places kill people like me. Before I could answer, the officer snapped, Ms. Lean, we know you're Aboriginal. Don't start your sentence by lying to us. And that was one of the first lessons the prison taught me about racism. When an old prison wing was being decommissioned because it was run down and riddled with rats and mice, they moved the white women out, rounded up 12 of us Aboriginal women and moved us into it because that's where they thought we belonged. Prison did not create racism. It gave racism a uniform, a set of keys and the authority of the state. When I later progressed to lower security, if there'd been a fight in the yard, officers would line us Aboriginal women up with our arms outstretched, fists up so they could examine to see if we had been the ones fighting, all the while non-Aboriginal women in prison stood and watched. That wasn't about prison security, that was racial humiliation. I remember another incident that has never left me. After a prison officer assaulted me, my cellmate who witnessed it reported what had happened. That night, the officer came into my cell, left a green sheet on the bed and quietly pointed out all the hanging points of my cell. He said nothing, but I knew what he was suggesting. Prisons do not just warehouse Aboriginal people, they rehearse our deaths long before we die. Prisons are factories of racial violence. They manufacture fear, humiliation and hopelessness and death, and then they call the outcome justice. When the state kills us, it investigates itself, expresses its condolences and calls that accountability. But our loved ones are still dead and the system that killed them remains intact. And these are not isolated experiences, nor are they unique to me. They are the reason the National Network Joint Submission with Sisters Inside argues that racism cannot be understood simply as hateful words or individual prejudice or even a few bad apples in the prison or police service. It is embedded in policing, in prisons, in child removal, in bail laws and surveillance. Racism is not a bug in the criminal legal system. It is one of its operating principles. It determines who is watched, who is believed, who is punished, and ultimately who lives or dies. For Aboriginal people, racism isn't something we walk into. It's a conveyor belt the state keeps feeding us into. If this inquiry is serious about confronting racism against First Nations people, then it must be prepared to confront the institutions of the state that continue to produce and enforce it. Thank you.
Thank you, Ms. Ling. Did you have an opening statement too, Ms. Wozniak?
Yes.
Excellent.
My name is Zofia and I'm here on behalf of Sisters Inside. I appear alongside Tabitha, who's a part of the National Network of Incarcerated and Formerly Incarcerated Women and Girls, and together we welcome this inquiry. First, I would like to start off by acknowledging the lands that we stand on here today, the lands of the Turrbal and the Yagara people. I acknowledge that the Turrbal and Yagara people have cared for and been sustained by these lands and waters since the very first sunrise. I pay my respects to the elders of this country, both earthside and in the dreaming. For more than 30 years, Sisters Inside has worked alongside criminalised and incarcerated women and girls across Australia. Every day we see racism is not simply experienced through individual acts of prejudice, it is embedded in the institutions that govern people's lives. Too often, discussions about racism focus on interpersonal abuse or online hate. While those forms of racism are real, they cannot be separated from the systems that produce and legitimise them. For Aboriginal women and children, racism is embedded in policing, prisons, child removal, bail laws and surveillance. What is often described as overrepresentation is not an accident. It is the predictable outcomes of systems that continue to criminalise and control Aboriginal people. Criminalisation itself must be understood as a form of racial violence. Across Australia, governments are introducing harsher bail laws, expanding surveillance and making it easier to imprison children and criminalise poverty. These measures fall disproportionately on Aboriginal communities, while Aboriginal women continue to be imprisoned and Aboriginal children removed from their families at devastating rates. But our submission is not simply a critique, it points to where solutions already exist. Every day, Aboriginal-led organisations like Sisters Inside work alongside women before, during and after imprisonment. We know that care, not punishment, creates safety. Community, not incarceration, creates belonging. Support, not surveillance, prevents harm. If this inquiry is serious about addressing racism directed at First Nations people, it must examine the institutions that continue to produce racial harm and invest in the Aboriginal-led organisations that have been building alternatives for decades.
Thank you very much. Swartz?
Thank you. Thank you, Chair and Committee, for the opportunity to appear before you today. As I've indicated, I am acting as the Chief Executive Officer of the Queensland Indigenous Family Violence Legal Service, joined my colleague Aaron Lukey. QFILS, as I've indicated the acronym, is a very proud Aboriginal and Torres Strait Islander community-controlled organisation, and importantly, in the context through which I speak today, a family violence prevention and legal service provider, an FEPLS. Our mission and goal within the ambit of being an ACO and an FEPLS is to provide culturally safe legal assistance and holistic support to Aboriginal and Torres Strait Islander victim survivors of domestic, family and sexual violence across our regions here in Queensland. What we see in our work, and it was remiss of me to start by ignoring the fact that I sit here as a visitor through my Torres Strait Islander heritage on the beautiful lands of the Yagara and Turrbal peoples. It's important to note that. It's important not to forget, because part of what you have been tasked to do through the terms of reference is to examine truth and identity. And these are uncomfortable things when we talk about race and the place of Aboriginal and Torres Strait Islander peoples in this country in 2026 and beyond. It is an important segue that you are all tasked to examine and penultimately report on. In the context of what our ACO does, domestic and family violence is often the point at which Aboriginal and Torres Strait Islander people come into contact with systems, they being policing, child protection, housing, health, and penultimately the justice system. Through our work, we see how racism compounds the impacts of domestic and family violence and creates additional barriers to safety, legal protection, and ultimately justice in whatever form justice takes to meet the needs of victim survivors. For our clients, racism is rarely experienced as a single incident. It is often cumulative, occurring across multiple institutions and influencing whether they feel safe to seek help, whether they are believed, or whether they receive the protection they require. We encourage, and I should add before jumping across into my key messaging, the overarching tenor of our submission, which you have before you, is this. Racism is not merely a social harm to be managed at the margins of policy. For Aboriginal and Torres Strait Islander peoples, it is structural, intersectional, and cumulative. It shapes who discloses domestic and family violence, who is believed, who is protected, and who bears the cost penultimately when systems fail. It determines the conditions in which Aboriginal and Torres Strait Islander children grow up, the likelihood that they will come into contact with the child safety system or the youth justice system, and inevitably the criminal justice system, and the probability that they will face those systems without the culturally safe support that could change their trajectory and life outcomes. We urge the committee to approach this inquiry as an opportunity to name what the evidence already shows. That racism, overt, structural and institutional, is a driver of domestic and family violence, a barrier to justice, and a mechanism by which the disadvantage of Aboriginal and Torres Strait Islander peoples is reproduced across generations. Australia has known this for a long time. We have a plethora of reports and unanswered recommendations. What has been waiting is the will of both Commonwealth, state and territory to act upon it, and to see racism not only as a political football, but something that we as Australians, when we identify what is our culture, who are we as Australians, one of those core tenets must be, we do not tolerate this in our society. The issue, as I have outlined, is not a lack of evidence. We're beyond that. But now, truly, a lack of consistent implementation. I sat here and listened to Natalie Lewis, who is a very powerful speaker, and you can hear the passion within which she's articulated the mounting pressure of that evidence. Yet we still commission more and more reports to produce the same result. We must get to a point now where we consolidate and coordinate urgent action. I'm not getting any younger, but I know that I have a duty for the next generation of children coming through to take protective steps now to ensure that they have a better future and a better outcome than what we have collectively gone through, and why we have the privilege, and it is a privilege as a woman of culture, to sit here and speak to you and hopefully emphasise to you the need to consolidate action now. Thank you.
Thank you very much. Ms. Coles. Good afternoon. My name's Claire Coles, and as I said before, I'm a Legal Practice Director at Caxton Legal Centre, and I'm joined by Leanne Collingburn today. Thank you for the opportunity to present to the committee in relation to our submission to the inquiry, which was made by Caxton in collaboration with Hopgood Gannon lawyers. I acknowledge the Yagara and Turrbal peoples whose unceded land we meet on today. I pay my respect to elders, past and present, and extend that respect to all Aboriginal and Torres Strait Islander people who are here today and those who have given their expertise to this inquiry. I'm not a First Nations person. I have not been subjected to the racism, hatred and violence that this inquiry is examining. We urge the inquiry to listen carefully to the Aboriginal and Torres Strait Islander people and organisations who are experts in their own experiences and who have the solutions to the problems you're examining. Our submission focused specifically on item 2 of the terms of reference, that is the effect of online platforms on the reach, prominence and harm caused by racism and hate directed at First Nations people. Our submission used a particular case study of online content from October 2023 to demonstrate online racism directed to First Nations people. For a period of 2 weeks, following a media outlet's publication of a controversial opinion piece about First Nations people in Australia, we captured the online public response via various platforms, including social media channels and digital media. Our submission contains excerpts of the content we collected and is a powerful demonstration of the rapid spread and harmful rhetoric directed at First Nations people enabled by online platforms without adequate moderation or accountability. The fact that we were able to capture this content demonstrates that the existing regulatory frameworks to protect First Nations people from this type of harm is not working. Reform to strengthen regulatory frameworks and to promote accountability is necessary. However, that reform needs to be grounded in a human rights framework and focus on prevention and proactivity, not just response. Though we acknowledge the right to freedom of expression, this needs to be balanced and read alongside other fundamental human rights. For example, Article 20 of the ICCPR, which mandates that states must prohibit propaganda of war and speech that advocates national, racial, or religious hatred that incites discrimination, hostility, or violence. Our case study demonstrates that online platforms can create an environment where racism and hate speech are normalised. This can lead to real-world consequences, including increased discrimination, social exclusion, and real harm for First Nations people. Rather than relying on post-harm complaints, online platforms should be required to identify and remove hate speech before it is published. The committee should ensure that the onus of protecting rights shifts from those who have been harmed to those with the power to prevent such harm. Thank you.
Thank you very much to each of you for those opening statements. We'll now proceed to questions and begin with Senator Thorpe.
Thank you. Thank you for appearing today. I'll first go to Sisters Inside and the National Network, so whoever wants to respond. How does racism contribute to over-incarceration and criminalisation of our women and children?
It underpins the entire criminal legal system. It underpins how we are policed in our communities, the types of laws that are written that we know overwhelmingly will capture our people, including our children. And it also underpins the way the justice system works, the courts play out, and then our experience in incarceration. It's no mistake that every time Queensland puts through new legislation that is about caging children or people in this state, that they are entirely incompatible with their own human rights statements. This is deliberate. Prisons are an institution that needs to feed off itself in order to survive. And prisons are full of Aboriginal people and Aboriginal children. It's because legislation is written in that way that it captures our children. We've got the circuit breaker legislation coming in here, the Youth Amendment Bill, which is actually about removing kids from their communities, their classrooms and their country and putting them in a remote and regional area, as if lifting them out of the current geographical space that they're in can change the material conditions that our people are facing. These systems are designed this way. It's not an accident. It's not a broken system. What it does is they over-police us. For example, in South Australia, we have a Aboriginal basketball academy, which is attached to the Department of Education. It's funded by the police. So undercover police officers play basketball with our kids. Our kids vie to get into this academy, and then those kids end up on watch lists because the police are there surveilling our children, working out and calculating their criminogenic risk factors. So kids who are there to play basketball on behalf of their community are being surveilled. None of this is by accident. This is about the way they scoop our kids up and place them in jail because they need to fracture our community in order to hold on to this country.
Thank you. Ms Wozniak, can you give the committee an idea of a woman from your experience and your expertise, an Aboriginal woman trying to navigate a system, the systems, the plethora of systems that we have to navigate as Aboriginal women with children or just Aboriginal women?
So there's two fronts there. I've got a personal experience with the system, which I can talk about. So my mother was a woman from my very earliest memories. I can remember her being in prison, and to this very day she's still in prison. So some of the things that I remember experiencing when going to visit Mum, about 20 years ago, going into the visits process, I was actually searched by the prison. I was told to take my shoes, my socks off, empty my pockets. You know, me and my other siblings were also told to do these things. Then I would go into the visit Mum, and then at the end of the visit I would be ripped and torn away from my mother. You know, by the guards. The guards would be in the middle of us, separating us. Like, this harm also has an effect on the women inside prison, but it has an influencing effect on the families and also the communities. And I often reflect on that, and I can still see these issues still happening with the women that we support. You know, a few years ago we supported a woman an Aboriginal woman who is giving birth to a baby in her cell with no support, no medical support or anything. You know, and then just given a Panadol to relieve her pain. And then, you know, the effects of that has on that woman, she's hysteric, she's screaming, and so then she's shoved into the DU, which is the detention unit, further isolated from any of her supports, any of her sisters, any of her family. You know, there's issues where Aboriginal women are giving birth in hospitals, shackled to the beds in these hospitals, and then as soon as their baby is born, they have been removed out of their hands. Like, these systems, like, this is the impact that it's having on these women and also their families. So yeah, that's from my personal view, and also the women that we support. They're just some of the issues that how it's impacted me and also the women and girls of the community.
Thank you. Do you think people out there know any of this?
I don't. There's certain things that are told, but no one really wants to listen. And a lot of people just turn blind eyes to it because they are the criminals, you know. Everyone's worried about the victims. But these women and these people in prison are also victims. They are also victims to sexual assault, violence by the state in particular.
Can I ask, with the woman who gave birth in the cell, and then was put in confinement, what happened with the baby?
It was, so the baby was a stillborn. Yeah, so the baby did not survive.
Sorry about that. In the submission that was put forward, you state that interactions with police, courts, prison, family policing systems can create barriers for women seeking help, increase vulnerability and reduce trust in authorities. All of this contributes to too many of our women being abused, disappeared or murdered, again with little response. How can we create a system that prioritises safety, care and support for all of our women and children?
I think from the outset we need to stop criminalising our people. This country needs to stop criminalising Aboriginal existence. They criminalise our resistance and they criminalise our ability to actually live in our country. The reality is that we could stop the caging of children. Like, there's no reason why a 10-year-old, 12, 13, 14, or even 15-year-old, 16, 17 should be in prison. We could do that right away. We could start decarceration, actually shifting people out of prisons. We have a massive amount of people being held on remand, not yet found guilty of a crime. I was speaking to an Aboriginal woman today, and her sister spent 6 years waiting for her trial to happen. She was held on remand for 6 years, only to be found not guilty for the offence. So she had given up 6 years of her life for this system, and there's no justice in that for her. She walks out of those gates with her life completely decimated, and usually you walk out of those gates with just a clear plastic bag of the belongings that you had when you went in there, with no support. And we should be defunding the police and prisons, and we should be reinvesting in our communities. Our communities know what safety looks like to us, and it's not cops, it's not prisons, it's not harsher bail laws. What it looks like is building up our community, keeping our kids on country, reinvesting that money into real community safety. And the reality is prisons and policing are quite young in this country. We carry within our DNA a time before that, before this sort of carceral monster that we have. The solutions rest with us, but they exist at the margins where most people don't ever wonder to get the answers. But every day Aboriginal people are doing the work of like this. If one of our children is not doing very well, we will step in and support them. If we know that our sister doesn't have food, we will provide the food and the support. And criminalised women do this incredibly well. So we already have the ability to do this. What we need is the resourcing and support. And what we need is the money taken out of those institutions that are actively harming and ripping us apart and taking our kids off of country, out of the community, out of their classrooms, into children's prisons, children's cages where they're strip searched at the age of 10, and many of them are not even having access to education. We need to actually abolish this system.
Thank you. I'm going to go to the Family Violence Legal Service now. You talk about the intersection of misogyny and racism. How do they mutually reinforce themselves, and what impact does this have on our women and children?
Yes, thank you, Senator. Queensland has been on a trajectory of examining the prevalence of domestic and family violence for many years, and it's culminated more recently in the Women's Safety Justice Task Force reports, Hear Her Voice, reports 1 and 2, looking at how we strengthen responses. One of those key recommendations that came out of the Women's Safety Justice Task Force Report 1 was the holding of a commission of inquiry into police responses to domestic and family violence. That commission of inquiry occurred. It was chaired by Her Honour Judge Richards in the commissioner function. Out of these 78 recommendations that she made, she conclusively found out of her inquiry the prevalence of systemic racism, sexism and misogyny rampant within the Queensland Police Service. We then led to, when we look at this trajectory of reforms and mechanisms, so you had a total of, Aaron, correct me if I'm wrong, 288 recommendations from the Women's Safety Justice Task Force for safety for victim survivors, particularly Aboriginal and Torres Strait Islander victim survivors. We had a total of 288 plus 78 recommendations from the Commission of Inquiry. A recommendation to create an independent implementation supervisor. We needed someone independent to oversee these recommendations and to ensure that when we're stamping out the prevalence of racism, particularly with policing responses, you had someone independent from police doing it. The independent implementation supervisor was enacted. They commenced reporting. The last report occurred in, I believe, February of this year, but obviously we've had a change in government. And with the change in government, we had the cessation of the role of the independent implementation supervisor. So all of these groundbreaking recommendations aimed at securing the safety, security and well-being of victim survivors, irrespective of where you live, your gender, your race, have now been pushed back to each department to oversee, and particularly the Queensland Police Service to oversee themselves. So when I look at systemic intersections, what concerns me is that when my client finally breaks, and she will break in the circumstance through an act of retaliatory violence. What's going to happen when police rock up? They're going to see her. She's going to be standing there with an implement. She's going to be angry. They're going to see him sitting in a corner very quiet. They will then say, you're the perpetrator, you're the perp, let's treat you as the perp. Bang, over there. You poor thing, let's get you looked after. Let's take out all the care and protection we need, and we're going to arrest her and take her. What they don't then bother doing is that call back to base. Oh, there's been about 50 call-outs to this premise in the last month alone. Oh, there's been a domestic violence protection order taking out the past naming her as the aggrieved, him as the perpetrator. So my clients have a genuine concern of reporting to police because they know what happens when they report. They're either going to not be believed, they're going to be misidentified, or they're going to be charged. Now, when she does report, when she's finally had enough and there's no other acts of retaliatory violence at play, there is a fear, a justifiable fear. Her children will be taken. And they are taken by child safety because we've seen that in Queensland's recent Commission of Inquiry into Child Safety and the recommendations coming out of that. So I don't mean to sound facetious, but I'm getting a little bit tired of a plethora of reports telling me the exact same thing and the trajectory of what happens when Aboriginal and Torres Strait Islander peoples, particularly women, seek help. We are demonised, we are blamed, we're not believed, our kids are taken, and then we fight to get them back, if we're lucky to get them back before that system penultimately breaks us.
Thank you. Interesting that the Queensland cops are racist too. We just come from the Northern Territory. They're racist too. So we're travelling around the country and we're discovering that there's a whole bunch of police forces around the country that are simply racist and causing immense harm to our people. So thank you. You've got 3 government reps here and I'm the independent black senator that gives them a hard time. We also have a federal government that has walked back any black rights in this country, not interested in deaths in custody, not interested in child removals, not interested in the suicide rates. What's your message to the federal government and what should they be doing as part of this inquiry and recommendation?
With all due respect to the federal government, I think I'm beyond the Pontius Pilate washing of your hands. I really am. And the levers that exist for the Commonwealth in relation to Aboriginal and Torres Strait Islander peoples exist in our National Partnership Agreement on Closing the Gap, which have been signed by each state, territory, local government association and the Commonwealth and ACOS. So we've got a measure in place. We have 4 priority reforms. Priority reform 3, the transformation piece, and embedded at that heart is tackling racism, weeding it out, committing to doing something about it is right there. It's sitting unactioned, and we see that in the report from the Productivity Commissioner saying, hang on, what are you doing? The government is taking, all levels of government are taking a business as usual approach. Let's keep implementing the RAPs. Now, with all due respect to that, they're pieces of paper that mean nothing to me when I can't see action in place. And I get really alarmed and very upset when I see that continuing rise of data. We can see, we're starting to track our data better. We can see it better. And it says that there is something not right here. But we seem locked in this sense of paralysis. We're happy to be bystanders to the massive train accident happening and saying, not my problem, it's a state and territory issue. It's not with that Closing the Gap National Partnership Agreement. We also have specifically the Our Ways, Strong Ways, Our Voices, specific plan for Aboriginal and Torres Strait Islander peoples to end violence against our women and children. We have the signing of United Nations human declarations that we've accepted, that we're signatories to, yet we turn a blind eye to it. So what is lacking, with all due respect, is political will, political leadership and political courage to stand up and say enough. You know, it opens a door that we're seeing where we're being called to question around why there is no point of multiculturalism in this country. We should be returning to a system of monoculture. Well, which single monoculture are we talking about here? I mean, if this is the political vacuum that we're existing in, and we're not getting to the root cause of what is eroding us, I don't think we're ever going to fix this. And I look at the Closing the Gap National Partnership Agreement, and I'm really starting to believe it's not worth the paper it's written on, because I'm not seeing any action occurring in Target 13. The measure of it, when you're looking at reducing the rates of violence against our women and children, is actual hospitalisation rates. Now, we know that violence occurs against our women not only in physical acts, which they may go to hospital for, or they may not, but non-physical acts of violence. So I'm sorry, Senator, if I'm sounding just a little bit frustrated, but I'm getting a little bit annoyed with the same reports telling me the same thing, the commissioning and the absolute stagnation of both Commonwealth, state and territory to actually progress this without making it a political football to score political points within our communities.
Thank you. Closing the gap targets don't have any penalties for not meeting them. They're just a nice to have. So in terms of the action from the feds, because when I go to the Closing the Gap briefings with the Minister for Indigenous Australians, I'm told that deaths in custody and child removals are state and territory responsibility, and I've written a letter. Is that good enough reason for you? That the Minister for Indigenous Australians is actually just writing letters to these violent, racist governments that are committing ongoing genocide on our people?
As an ACO, in receipt of government funding, we have funding agreements.
NDA, maybe.
With our funding agreements, obviously, if we don't deliver on the KPIs within those funding agreements, there's an economic consequence on us. Applying that same logic back to states and territories who receive money specifically through the Commonwealth to achieve outcomes, I would absolutely endorse what Natalie Lewis said to this committee, that there is an economic consequence for non-delivery and failure. They're technically breaches of contract. Now, I'm a practicing lawyer. This is Contract 101. Why we're not doing it, I don't know. But it's time to get serious and it's time to get tough, because as businesses, if we do that, we lose our money. It gets pulled. So I think the same rhetoric needs to be applied to states, territories. And if they don't want to be a part of it, then pull out, and that money should be redesigned and reallocated to business units and Aboriginal and Torres Strait Islander community-controlled organisations who are already doing the hard work and heavy lifting on the ground.
Thank you. I just have one question for I have lots more for National Network. I know you hear about Clause 2, but I'm here for all of them, so I'm going to ask how many Aboriginal people come through your door because of racist cops in Queensland?
I can't give you a precise number, but it's quite a lot. We have, as part of our practice, a program which provides advice and representation to people who have experienced discrimination in interacting with the police and other government agencies, and it's quite a lot. We also have a program that represents families in coronial inquest processes, and a large proportion of the work that we do in that space is in relation to people who have died in custody, including in interactions with the police, predominantly people who have been shot in interactions with the police. So it is a large proportion of our work.
And how safe are coronial inquests for Aboriginal people?
From my experience, they're not safe at all. The Queensland Court has some processes. They have one Aboriginal liaison officer whose role is to provide cultural capability advice to the court, as well as to provide some support to families going through that process. But in my experience, it's not safe for families.
Happy to hand the call. I've got lots of questions, but happy to hand it.
Thank you, Senator Thorpe. Ms Cook.
Thanks, Chair. I might start at this end of the table and work my way down. Thank you to both of you for sharing your personal experiences. They're very powerful and important and horrific to hear, but important. We know that First Nations women are the fastest growing prison population in the country. Can you talk to us about that, and are there things that you'd like to share with us as a committee about that?
I think, unlike Ms Schwartz, I'm tired as well of investigations and inquiries. I think the only people that actually benefit from them are the people conducting them. Often we talk about the fact that Aboriginal people are overrepresented in prison, and while that's a fact, I think that we should be saying that we don't want any Aboriginal person in prison. No number is satisfactory. It is true that women are the fastest growing prison cohort in this country, and that should alarm all of us, because that means that our women, our matriarchs of our family, of our country and of our community, are being taken out of our homes and our country and our community and put into cages. It should alarm us because it leaves behind children, a bit like Sophia spoke about her experience. There are hundreds of children across this country, thousands of children walking into prisons to visit their parents every single day. Worse, some children are not actually allowed to go in and visit their parents. So the fact that we have mothers being disappeared from our communities into prison should alarm everyone and should be a cause for action. And some of those women don't actually make it home. They're killed in prison or they're recriminalised as soon as they get out. So this whole idea that, once you've done your time, you do the crime, do the time, and you get out, and they can't hold you beyond your sentence, is becoming an absolute lie. We've got women being held on extended supervision orders so that when they do get released, they might have served 10 years. They've done their time, they get out, and then they're held on supervision orders where they then have an ankle shackle, electronic monitoring for another however many years. Here in Queensland, they're looking at extending people's sentences by 10 years if you're classed as a serious offender. This is taking our women out of our families. No longer can you do your time inside with an end date. You're coming out and you're still being held. And the disconnection from our children is an enormous point of grief. So many of our women do never get their children back. And that means that these kids are stuck in the system. And Sisters in Size recently authored a report on the family policing system in Queensland and the actual horrendous things that children are experiencing while in care. And for many of these children, their mothers are in prison, their aunties, their grandmothers. And that's because of racist policing, not because we are inherently criminal, but because we are criminalised for existing in this colony.
Sorry, could you provide that report to the committee?
Yes. Yeah.
Sophia, did you want to add anything to that as well? No. Is there anything else that you want to share with us specifically that you think might be unique to Queensland that perhaps you think maybe other jurisdictions might not, or do you feel like some of the things you've talked about are national issues, whether it's across policing, courts, law enforcement? Is there anything unique to Queensland that you think we should know about?
I think Queensland is often the instigator of these punitive and violent laws. For example, adult crime, adult time, these slogans that the Queensland government loves to roll out, which really is just a catchy phrase to explain the way they're capturing our people. And what happens is Queensland brings out legislation like this, and they boast about actually overruling people's human rights. And then what happens, we see across the country, other places follow. So we saw the serious crime, adult time legislation elsewhere, and we're seeing South Australia boast the most punitive laws against young people. So I think that this is a problem across the country. Criminalised people are largely overlooked in every single area, but yet we are often at the very pointy end of racism in this colony. So while I don't think that Queensland is the exception, I do think that there are times where they are the instigators. And Chelsea Watergo spoke this morning about the violent policing that we see happen here in Queensland. They've just introduced new weapons for police here in Queensland off the back of a woman being shot by police in Cairns. There's been a massive billion-dollar investment in new weapons for police in South Australia off the back of just 2 people recently being killed by police. So what happens here is just happening everywhere, but it's experienced differently because our communities are different.
Thank you. For Quibbles, thank you for all of the comments that you've made so far and for your submission as well. Your submission does talk in quite a bit of depth about racism shaping who discloses violence, who is believed, who's protected, who's prosecuted. You also spoke about that imbalance and trying to identify who is the primary aggressor. And just for the record, I'm doing little inverted commas around those words. Can you talk to us about some of your clients' experiences? You've already shared some of them, but some things that might stick with you over the years that you think we need to know about as part of this inquiry, and if there's anything else you want to add that you haven't had an opportunity to say yet that you'd like to say.
Thank you very much. In terms of the practice of QFLs, as a family violence prevention legal service, we focus on both legal and non-legal supports. Our primary practice is in domestic and family violence, child protection, supporting victims of sexual violence, sexual assault, Victims Assist Queensland applications, so victims of crime, compensation matters, and traditional Torres Strait Islander child rearing practices, for example. So when we come into connection, let's say with these government agencies, I'm going to go to child safety at the moment, and the reason why I've got a real focus point on child safety is that in our practice, the majority of my practice litigation files are child protection litigation files. We are fighting the department. Normally it takes around, Aaron, correct me if I'm wrong, between 2 to 2.5 years to fight an application to remove a child into long-term guardianship orders. Now, what we see that demonstrates, in my respectful submission to this committee, the hallmarks of racial profiling are these types of assessments that are conducted by the department, and we see this leading to the basis for removals. We will have child safety assessing that extended family members living in a house places the children at risk. So you might have, let's say, 10 to 15 people living in a house. But let's put this into context. You've got a house, let's say, in Bamaga, for example, and there is a chronic shortage of housing. You've got a number of people living within one house, and there's no indication of more housing being built by the government. Child safety assessing that children sleeping on mattresses in a common living space would place them at risk of harm, or children not having their own bedrooms is a concern that warrants and validates a removal with an assessment that a long-term guardianship order should be made for that child. Child safety assessing that an overgrown yard would place the children at risk of harm. Now, I'm not being facetious. This is an assessment from our litigation files as to the basis for removal. Child safety assessing or identifying a home to be unhygienic, and when asked to particularise, will refer to just or general clutter being a reason to take a child. Child safety assessing that being a young mother under the age of 21 years is considered a child protection concern. Furthermore, in situations where the mother is a child in care herself, which many of our clients are, subject to a long-term guardianship order, that somehow that means that her ability to parent, mother, nurture and raise a child is compromised and limited, despite, ironically, child safety actually being the guardian for that young person. Child safety assessing that having a number of children, 4 or more, is a child protection concern, specifically referencing being able to meet all of the children's needs. Now, I'm not being facetious, but I'm taking what's in my files, and the other key concern of removal is the prevalence if my client has consumed alcohol, particularly, or intoxicating substances. That somehow makes that a child safety concern to remove those children without looking at the genesis of why she is self-soothing, and that is because of the prevalence of violence and how she is dealing with the trauma. So I can put that in that context of how that particular institution responds. When we look at policing, I've given you the misidentification aspect, but we've had a situation which is not uncommon where we're assisting a woman, and the makeup of our practice, over 70 to 80% of our clients identify as female. So we've had a client turn up visibly bruised and battered on her face. She's come to court for her child protection matter. She's travelled many kilometres and many hours to get to court in a remote locality. She tells my lawyers and support staff, he's flogged me, he's punched me, and I fell to the ground. He's pulled my hair. He's abused me, and it's continued all the way to the home. We've then said, okay, we need to get you to the police. We need to make a police report. She consents to making a police report. We need help. She doesn't have a domestic violence order. The police should be your first point of urgent intervention. We take her to the local police station. We're told to wait while she goes in to make the complaint, to seek assistance. We think it's going to take a while, a couple of hours. My team are waiting. Within a couple of minutes, she returns, holding a blank application for domestic violence protection order. She tells us that the police officer told her to, quote, fill out the form and file it next door, love, referring to the courthouse. Police did not bother to take a statement, did not bother to issue and commence an investigation into what clearly was evidence of bruising that she did not consent to her body. We then urgently had to go across to that courthouse. Thankfully, the magistrate was sitting, and file an urgent application for protection order, obtaining urgently, successfully, an ousted condition to get him out of the house because he was waiting for her to come back from what he thought was child protection proceedings. Aaron, sorry, was there anything else you wanted to add to those examples?
Just going to add to that, if that's all right, Committee. Importantly to note as well is the access to justice point. Our clients and communities, obviously it was established in 2022 with the Call for Change report around the racist misogyny and in that report. That's obviously been around for a lot longer than 2022, which we know. It has been established. What we're dealing with in community and our lawyers are dealing with is that access to justice point. One, dealing with QPS or police that are in that, come from that racism, sort of systemic racism in that community, as well as are now being put into these communities where they're dealing with situations that they just have no business being in. Our clients are now being seen by these kind of QPS, including their court system, where we've had instances where the court would sit for only a particular point in time, and that's once a month. And once that time is up, then that court is closed, and no longer you'll have to wait to the next month. What we're seeing is the fact that no after-hours courts are going to sit. So that incident that Thelma described could have been after hours, which now our clients don't have that access point. But it is the issues that we see are definitely that access to justice point.
And just a question for Caxton. You did talk about platforms being required, this is just shifting speed a little bit, around platforms being required to publish reporting on complaints and what's happened to them. What we did have Meta in here earlier, talking about some of their information and what they do and they publish. What would you like to see in that space around their practices and processes? And
thank you for the question. I think this case study is based on one letter and a 2-week period, and we have over 200 pages of harmful content. That harmful content should not be allowed to be online. It should be screened before it gets to that point. The current system, I guess, puts the onus on the person harmed, as Claire said, to bring an action if they find this type of content harmful. And that's a really heavy burden to bear. So I suppose shifting that burden is obviously the priority, so that this type of content is in the first instance prevented from ever getting online, and having proactivity on behalf of platforms to ensure that this really harmful content never gets out in the online space.
I think my colleague next to me might have some questions.
Mr. Smith.
Thank you. Quills, how you guys going? Love your work. Got a couple of friends work for your service. I guess one of the risks of reporting, which you touched on a little bit, another thing I hear when I'm travelling around the Cape is that women are reluctant to report family and domestic violence at times because of the negative outcomes for interactions with police for the partner as well as. So there's this just inherent fear that sort of keeps going. Then you obviously identified, child safety gets involved and you lose the kids. And if you're stuck in Lockhart River, for example, the chances of you being able to facilitate any programming at all to jump through the hurdles to get the kids back is next to none. So I think often we find a lot of our women and children putting up with it rather than taking, putting everything else that they love under threat, which is basically what's going on. So it's not enough just to be benignly not racist. You have to be aggressively anti-racist. And from there, could you take us through Auntie Henrietta's Maori model and the project and what that would look like on a national level?
Look, I think it was really quite courageous that Auntie Marie came up with her husband with the Buckle model that was used with Queensland Health. And Health, I think, with credit to Health, have always been a little bit more proactive. Obviously, you're dealing with people. It's very heavily people-focused. We go there when we're sick, and especially Aboriginal and Torres Strait Islander peoples. And the racism matrix that was created isn't based on individuals. We're looking at system responses. And for Health to actually undertake that in Queensland, and then from that, this is hard when you're doing those assessments. There were findings made, and then, okay, what are our recommendations? It led to the creation of the Health Equity Strategy here in Queensland, which, set up a framework of actually doing things a little bit better with Aboriginal and Torres Strait Islander peoples. Now, I know more recently we've had issues with the rheumatic heart deaths in our Gulf communities, and there are issues that need to be worked on, but credit is due where it should be due. They actually undertook a racism analysis by an Aboriginal and Torres Strait Islander individual who is highly experienced in this area. We've got a racism matrix that's been created by the Human Rights Commission, you know, but Auntie Henrietta and Uncle Adrian came up with this back in the 90s under our old Anti-Discrimination Commission framework here in Queensland. So you can see that there are good things that can be done. And, you know, if you commit to doing it, if you embed systems and processes, you can weed it out. Now, what I find when people start looking at the prevalence of systemic racism, let's say in the police service, for example, the language that is used is the language of unconscious bias. And I think it's more palatable to use that term unconscious bias when you're trying to formulate what is necessary to make a decision. And the part of the training that we at QFLs have been doing and have had successfully done with the Queensland Police Service is, okay, what are the frameworks? What are you thinking when you're going to make a decision when you're faced with someone who might be an Aboriginal Torres Strait Islander person? What do you need to take into account and unpack? So if it's more palatable to call it unconscious bias as opposed to, okay, let's call out the racism that you're going to be using here to assess an individual. Okay, you know, I just playing semantics. But you can see that when you start this type of training, and I don't know if this training, it was embedded within the 5-day specialist course of the Queensland Police Service that we were a party to and running around cultural capability and upskilling. We last delivered that in, I believe it was June, and we've been delivering it for a number of years with the Queensland Police Service. And that was our commitment to walk hand in hand with police to assist them not only with how to avoid the traps of misidentification, but also how do you actually respond to your own internal unconscious bias and provide a service to a person desperately in need of assistance. If I can turn to the remoteness and the statement around, you know, wanting to keep families together, we hear this from our clients. What they will say to us is, I want the violence to stop. Simply having a criminal law response is not sufficient to end the violence. We need other measures, and we need a commitment within prisons, if prisons are the model that continue to address behaviours and to support people live healthy, strong lives, but also within prisons addressing that inherent racism that sisters inside and the national network have spoken to.
And I guess if we're using prison as that mechanism, even when people come out, like I've met guys in community who come out after a stretch in the pen and they can't get a job, and you know there's that shame, and you know they're a bad night away from going right back. It's just cycling up.
It's an ugly cycle, particularly where a number of the jobs in our remote communities require you to have a blue card.
Yep.
And what is going to come up is that particular offence of violence. It's going to be noted. You can't have a blue card, you can't get a job. You're then locked into social security dependency. Okay, and that creates the breeding ground for resentment, hate, anger. And it's not only just in that little family unit, it's going to be in the broader kin community unit that causes problems. So you're looking at, you know, there are measures here that you've got to think about and implement that will have real impact. And we have been calling as an FVPLS for many years about different ways of approaching and working with our families, particularly in early intervention and prevention methods and methodology. This is where we can actually do a lot of really good work. But the racism matter, as we've said, comes into play when we hit that system. And I'm not talking about the day-to-day racism that we get as Aboriginal Torres Strait Islander peoples, and we've really felt since the failure of the voice referendum, but I'm talking particularly about a system response here.
I think too, if I might add, I think too, a lot of these, and I think someone may have said it earlier, but there's no surprises in terms of the numbers. We know what the numbers are. The numbers are a direct reflection of the infrastructure that is set up before us. There's no ifs or buts about it. It's clear across all. But we keep, as those who've gone before me have said, we keep talking about those numbers as if they're going to change. Thelma mentioned political will. There was legislation introduced back in the 1800s which removed and it was around opium and protection of Aboriginal people. But that was introduced to displace communities and Aboriginal people. We're still doing that today. You fast forward and we're still in those communities. We put legislation around those communities that are not built for communities, and then we ridicule and prosecute for it. So the numbers aren't, they're a product of what we've put together for those around those that have gone before us.
Thank you.
Thank you, Mr. Smith. Just one question from me, and I might get everybody from the panel to respond if that's okay. We've heard a term called project invisibility from the media here in Queensland in particular, which is particularly targeted at deprioritising Aboriginal and Torres Strait Islander leadership roles, not platforming Aboriginal voices across this state. I'm wondering if you can speak to what you've seen and how you think that impacts the women, the people that you work with, and how you think that continues to perpetrate racist or supports racism in this country and state. I might start down this end and work my way up, do the opposite of what others have done.
I mean, I think that is something we have seen, particularly with this state government. We are a mainstream organisation. We have a First Nations working group of people, but without visible, strong First Nations leaders in positions of power in our community, I think it makes it very difficult for the First Nations clients that we support to see themselves in a positive way in our community, and where this government particularly is consistently implementing legislation which is designed to remove Aboriginal children from their families, to put people in prison. I think it's extremely detrimental.
Thank you.
I think it's probably, in terms of the issue of project invisibility, the first act of this incoming government in terms of legislation passed was to slip into the bill relating to the upcoming Olympics here in Queensland, the dismantling of our Path to Treaty Act and the decommissioning of our Commissioner, who had just started the truth-telling inquiry. Now, if we're talking about project invisibility and being really open and honest about it, that's when it started. And it happened under a smokescreen. Now it's becoming more overt, and it is heartbreaking to see. You have people who have worked, they work very well, they've got the merit base, they've got the skill set to work hand in hand with government to lift Indigenous and non-Indigenous peoples to a space of working collaboratively together to improve outcomes for Aboriginal Torres Strait Islander peoples, but all of our community. Because when you improve an outcome for an Aboriginal Torres Strait Islander person, you improve an outcome for all of us. It is absolutely heartbreaking to see it. We have seen it, and it makes you feel afraid, to be very honest, as an Indigenous woman sitting in this space, of how far you can stick your head up without there being a negative impact, because you have a responsibility to serve your community, to ensure that your community receives funding it gets what it needs to continue to survive. So when you see this, and I am aware of project invisibility in place, you wonder what it says about who you are and where you belong. And that opening remark I made to you at the very beginning, what is the place? What is my place in my country in 2026? What are those little kids back home, no matter if you're living in the city, out bush, on the islands? What do they think? Where do they belong? Where do they see themselves? That's what it means to me and makes me feel.
think Project Invisibility started in this country from the day when people stepped ashore. I think Queensland just likes to give things very catchy names. I think it's a colonial Australian project to invisibilise us and erase us, cage us and kill us. So I'll just speak to two examples that I'm seeing play out through Sisters Inside in the National Network. We recently had an Aboriginal woman who was released from prison who was unable to get housing, and the housing provider that was supposed to provide support did not. They gave her a tent instead. And then when she went to try and camp in the place where people have camped forever, she was told to move on because this was not a place that she could be. So not only was she given a tent when she came out of prison, she then had nowhere to actually pitch that tent. She was then put into some accommodation and was sexually assaulted by the person next door. Instead of them moving him, who had assaulted her, they wanted to evict her from there. And now while Sisters Inside is trying to negotiate and support her around that, the housing provider, which is funded by the government, is saying that she is pulling a rape card to try and get special treatment. This is how criminalised Aboriginal women are treated in this country. So they are invisibilised from the very word go. The second way we're seeing it play out is through the defunding of Aboriginal services for children in care. I've been told a story today about an Aboriginal child who had been in 45 homes before he came to that Aboriginal placement. And now that one's being defunded, this child has been told that he'll be moved to a non-Aboriginal service and no one knows where he's going. And he's sitting in fear after being stable in this Aboriginal placement for 4 years. He's now in fear of where he's going and no one knows where he's actually going to be going. This is what's playing out for people, but these are not new things. They just have a really good catchphrase now and a really concerted effort by the LNP. But Project Invisibilisation has happened from the very start. Criminalised Aboriginal women have been invisibilised in this system. They're invisibilised in DV services where we're told to call the police, where we're told to engage in these racist systems that actually entrenches racism in here. We are invisibilised when we're killed in prison. We're invisibilised in the courts. This is an ongoing project. It's just got a catchy phrase right now here.
Yes, and just to carry on from that, just some experiences from Sisters Inside, I can attune to the defunding of particular programs that we actually have. Talk about a bail program that we had for Aboriginal young people. It was 90% successful. We had figures, we had reports, everything presented to the government, but yet LNP have come in and then they have defunded that program. So that to me is just like invisibilising the work that Aboriginal staff are doing with Aboriginal young people that are helping them to keep them out of prison. And yet now the LNP have decided to fund these white organisations that have no relationships with these young people, that have no relationship with women inside, with kids inside prisons, and they are now been giving millions of dollars to support our young people, and they aren't actually doing the job. The programs that are doing that we have done for many years are now being defunded through the LNP because of the racist systems that they have come from.
Thank you very much. The Queensland Department Families, Seniors, Disability Services, Child Safety, Queensland Police, Queensland Corrective Services, including Lotus Glen Correctional Centre in Cairns and SES Queensland were all invited to participate during these hearings and have all declined to attend, which is a real missed opportunity for them to respond to some of the concerns we've heard throughout today and the concerns that you've raised.
Weak racists, that's what they
But that concludes the time that we have for you. We've gone a little bit over, so I appreciate you hanging around and thank you each for the work that you do. If you've taken any questions on notice, you will have until the 18th of August to respond, and that includes if there's any additional information that you want to provide to the committee to support the work that we are doing. You'll also be sent a copy of the transcript of your evidence from today, and if when reading through it you see that there's any errors there, you can request corrections to those errors. Thank you very much. We're taking a very brief suspension and we'll return at 4 o'clock from afternoon tea. We might resume. We will now return. I call on representatives from the National Aboriginal Community Controlled Health Organisation, better known as NACCHO, to give evidence. For the Hansard record, would you please state your full name and the capacity in which you appear before the committee?
My name is Dawn Rosemary Casey, and I'm the Chief Executive Officer for the National Aboriginal Community Controlled Health Organisation.
Thank you. I've just got a short spiel that I'll read and then I'll invite you to make an opening statement. So, although the committee does not require you to give evidence under oath, I should advise you that this hearing is a legal proceeding of the Parliament and therefore has the same standing as proceedings with the respective houses. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege and is being broadcast live on the Parliament's website. I'm joined by committee members today. In the room we have Senator Thorpe, Ms Cook and Mr Smith, and myself, Jana Stewart, Senator Stewart. I now invite you to make an opening statement, please.
Thank you, Chair. I begin by acknowledging the traditional owners of the land on which we meet, and I pay my respects to their elders, past and present. I extend the respect to every Aboriginal and Torres Strait Islander person following these proceedings. I'm Takala from North Queensland, and I am the Chief Executive of the National Aboriginal Community Controlled Health Organisation. I speak for 148 community-controlled health services who operate in excess of 550 clinics throughout Australia, delivering comprehensive primary health care. I'd like to thank Senators Thorpe for the invitation to appear. Chair, this committee has been asked to examine whether racism, hate and violence harm Aboriginal and Torres Strait Islander people. I want to be honest with you about that question, because we are not a conciliatory people when it comes to the truth. That is not the question. We answered it a long time ago. In 1992, the highest court in this country looked at the doctrine the whole of the nation had been built on, terra nullius, the legal fiction that is, this land had not belonged to no one, and it named that doctrine for what it was, unjust and discriminatory. It took 204 years and one Miriam elder, Eddie Koikoi Mabo, who did not live to hear the verdict, to make law of this country tell the truth. And before Eddie Mabo's case, there was John Kawata case from Queensland, who received funds to purchase the Archer River pastoral property. The Queensland government did not approve and to which John took proceedings against the Queensland government, and in response the Queensland government declared that the Commonwealth's Racial Discrimination Act was invalid. The High Court upheld that it was incorrect. It was correct. It was valid. The government then changed pastoral property into a national park, and John Kawata also did not see, he died before ever seeing the thank you that a later Queensland government gave to him. I want this committee to sit with what that means. For 2 centuries, racism in this country was not a feeling, it was not the fringe, it was the law, it was the system, and it did not correct itself. It was corrected only when the truth was finally forced upon it. That is the lesson I bring to this table, because the same thing is true today. Racism in this country is not a matter of bad manners. It is a structure. It is who gets believed in an emergency health department, hospital department, and who walks out before they're ever seen. It is a child in Northern Territory where the rate of our young people in detention has doubled in 4 years. It is on every platform our people open, where we hold a list of more than 700 racist terms and still cannot keep pace with the abuse. It is in the evacuation centres where our elders are sent to makeshift conditions while community-controlled health services are locked out of the response. And it is killing us. Up to half of psychological distress carried by our adults can be traced to everyday discrimination. The burden of disease our people carry is more than twice that of other Australians. These are not opinions. These are the findings. So, our Aboriginal and Torres Strait Islander people are 55 times more likely to die as youths from rheumatic heart disease. Our Aboriginal and Torres Strait Islander people are 4 times more likely to experience racism in health settings. We are 3.7 times more likely to have kidney disease and 3.3 times more likely to suffer from diabetes, 3 times more likely to have preventable hospitalisation, and 3.2 times more who will suicide as youths. And there are many other data that I can continue to advise on. But I did not come here today to lay our pain on this table for inspection. We are not the problem to be managed. We are a people who built the answer ourselves. In 1971, when the mainstream system was not safe to walk into our community in Redfern built the first Aboriginal community-controlled health service in this country. 55 years later, the Closing the Gap targets that are moving, the ones that are actually improving, are the targets where the community is in control. The evidence is not ambiguous. Let us stop pretending we do not know what it works. We do. So I will be direct about what we ask of this committee. Name racism for what it is, structural, institutional and personal, and act on the framework already written to address it. Fund the community-controlled health sector to do more of what already works. We know in health that there is a $4.4 billion shortfall by states and territories and the Commonwealth annually on what's spent on other Australians and what's spent on Aboriginal people. That's approximately $5,000 per person shortfall for Aboriginal and Torres Strait Islander people. Hold every government to Priority Reform 3, the commitment that they have already signed to transform their own institutions. When the High Court handed down Mabo, 2 of its judges warned that this nation would remain diminished until it acknowledged and turned away from the injustices of the past. That dispossession has left, in their words, a national legacy of unutterable shame. I'm asking this committee to be courageous, name it, fund what works and tell the truth. Thank you, Chair. I welcome your questions.
Thank you for that opening statement. We'll proceed to questions and begin with Ms Cook.
Thank you, Dr Casey, for your opening remarks, and I'm conscious that you very clearly just set out what you believe the most effective responses are in terms of naming the racism, implementing the framework, addressing that health shortfall spend, holding the governments to those priority reforms in terms of reform number 3. You also, in your submission, ask for First Nations-led independent oversight of law enforcement. Can you talk more about that?
Yes, sure. So what we think around independent law enforcement, and many years ago, I worked in the Department of Prime Minister and Cabinet and managed to negotiate the Commonwealth State response, joint response on deaths in custody, and it was in there that people, in my view, you know, we saw how people ended up in jail, and it really needed structural reform in terms of responsibility given to states and territory governments. So we see that an Aboriginal and Torres Strait Islander-led independent oversight committees to investigate law enforcement is really, really important, and an accountability mechanism to ensure that jurisdictional government decision-making aligns with their commitments nationally. And they really do, you know, they provide commitments, but they don't actually, there's no one monitoring and them being held accountable for it. And investment also we see is important in culturally safe, trauma-informed early support for justice, health and diversionary and rehabilitation programs. Now, the current Minister for Commonwealth Department of Health has done a lot of work towards this end and has managed as part of the hospital, well, it's not only called the Hospital Reform Agreement, it's a Commonwealth State Health Reform Agreement, to have ministers agree that we start some measures with prison health, for instance. And what we're seeking to achieve there is an agreement across justice departments, health departments who run prison health across the country to agree on a certain small number of standards that they can all be held accountable for, like not having women in labour in handcuffs when they're in labour, or not having prisoners going through chemotherapy being handcuffed during that. So that will start to, I strongly believe that working through the community control health sector, who've been around, many of us, for over 50 years, will then start to change the attitudes.
Thank you. Those were some really great examples of what we could do. Are there any other particular programs, models or principles that you believe could be scaled nationally that are community-led and controlled as the most effective responses to racism? That could be in health or otherwise, if you want to talk about it more broadly. Are there other things you would like to let the committee know about?
Well, I think what we need to do is look at where the structural reform, because I've been around now for 50 years as well in the public sector, and out working for government NGOs. I think what I found is the structural reform component is really important. We have achieved that with the Commonwealth State Hospital. It's not the hospital reform, but it is the health reform agreement, where we have a schedule in that agreement with all states and territories about how they need to deal with racism, cultural safety, etc. And that's built into their funding agreement. And we have a monitoring and accountability group, which is made up of our sector, and we're developing the monitoring systems, and we are independent, but we want to work closely with Commonwealth State and Territory government and our Commonwealth health colleagues to make sure that people are meeting those outcomes. So that's structural reform. I ask that people look at structural reform. And the other issue is the National Agreement on Closing the Gap is really, really important and has certainly helped us in health, with the health department, who now I think leads the way on making sure that they're sitting down and working with Aboriginal and Torres Strait Islander communities and organisations to develop our ideas and start to implement that. There's no point in government members and politicians taking a program that they think might be good. It then gets locked into this government authority, and then you haven't got any flexibility. So the ideas and the plans could come from the communities themselves. But also the community, what we've done is taken into account that, for instance, the aged care system, that it is a mainstream system. We're not going to have a separate aged care legislation for Aboriginal and Torres Strait Islander people, but we need to make those mainstream institutions work and change. And we have separate funding, clearly, for community control organisations to help their people negotiate and do assessments, etc.
When you were talking about the monitoring and accountability role through health, what would then be the possible, consequence of not meeting, if you identify through that monitoring that they're not meeting those requirements, what would be the actions out of that?
Yes, so there are two other parties that are helping, several other parties that are helping with what are the performance indicators that are being developed by AIHW, and then the Health Commission, which is working on overall standards, etc. I would see that, in fact, government would look at their funding as an end game, but because we're at the table, and I tend the Deputy Director General's meetings that are responsible for implementing that, I would see it, working over the next couple of years. Like, it's already that agreed to all of this, and that took us almost 3 years, all that negotiations and the agreement, including on our sector, our Aboriginal and Torres Strait Islander communities, to reach that agreement. So I think we're on the track of the hospitals and the health, state and territory health departments fulfilling most of those reforms, albeit it is going to take 3 years, 2 years in development, and then start the monitoring. And we will certainly have the data to demonstrate that.
Thank you.
And we will print it in our annual reports and make it very public, because 20% of, in a couple of states and territory, 20% of our Aboriginal and Torres Strait Islander people leave hospitals without completing their care. That's a shocking rate. So what I'm asking too is why I'm saying that the system, you guys need to look at the system. As I said, there's a $4.4 billion shortfall in funding for Aboriginal people, and we're arguing, we're putting our proposals, and we've given that to the Minister. We've developed exactly what health services do and costed it with health economists, etc. And what we're also saying is we know up to 2021, our population grew by 22%. It's projected to grow by a further 20% by 2031. So we're saying that all needs to be taken into account. It's based on race, that Aboriginal and Torres Strait Islander people don't get funding when it's absolutely there. All the data is there, etc. Why else? Why are people treated like this?
Thank you.
Thank you, Ms Cook. We'll now go to Senator Thorpe for questions.
Thank you, Chair. And thank you, Dr. Casey, for appearing today. Pardon me. The former Aboriginal Children's Commissioner in Queensland, whose powerful evidence we just heard, calls for true community-led solutions on the ground. She said that peak bodies mimic the government who fund them. Our peak body for health, do you find that you need to toe a certain line because of that?
Absolutely not. So what we've done, NATO was around, and it started off as NAHO over 50 years ago, and sure, over the years, not every complete, every community organisation has been maybe in terms of governance hasn't been as good, but they have never ever been funded to the level that they need to be funded to deliver comprehensive primary health care. And certainly NATO as a peak body doesn't conform to government. We have taken the lead on developing the core services with all of our ATOs, because I think it's only right that we have a national agreement right across them to identify what services we deliver. And so and in terms of the hospital reform agreement, we initiated that. And thankfully, from your strong support around prisons, that came from all of our mob. So there's no doubt in any, whether you're a white organisation or an Aboriginal organisation, you will have some people who either work with government. There's an article on ABC or SPS not long ago where the World Wildlife Foundation, is working with governments instead of doing the independent job of not killing the bears up in the Northern Hemisphere. So I don't think we should sit back and just agree with some of those comments, because let me tell you, 99.9% of our organisations operate. They provide the most compliance, they provide the most data, and there's only, on less than one hand can I count them who've had governance issues.
Thank you. Should the federal government step in and use its constitutional power to legislate the Aboriginal child placement principle so that states and territories can't walk back on it?
I'm not sure that will get up. So we're having the same issues with the current government on the Thriving Kids and NDIA, and I don't think you're going to get anywhere by just going and arguing that you legislate for that, because that just takes forever and you're going around in circles. I always try and find the loopholes of where you can make the structure reforms around a whole series of things, and that makes change happen, albeit sometimes slow. I don't think we've got the political nous in this country at the moment to do that legislation. And there are rules that the federal government can do in their grant agreements and that we need to be involved in right from the start, so that the state and territory governments can do that where they're receiving funding from the federal government. But it is a difficult, the state and territory, the Constitution, I'm not sure I would use that for that particular purpose.
Thank you. We heard earlier that any organisation or business not delivering on an agreement will have its funding pulled. However, this is not the case for state and territory governments doing little to nothing. In fact, they're committing genocide. They're not meeting any of the, they're not interested or meeting the closing the gap targets, and practically actively against them. Should the federal government penalise through withdrawing funding from state or territories in these instances?
I think it's just really difficult to do that, because in the end, Aboriginal people suffer even more. I think we really do need to have, and we're having the same issue around Thriving Kids. And the Commonwealth should have listened in the first instance to say, writing into their agreements, that they need to consult with Aboriginal and Torres Strait Islander people. So they haven't done that, but with the next plans, they're going to do that, and all of our statewide affiliates are going to negotiate that. It's going to be a tough ask, but I just think it's really, really difficult to use the money to try and drive reform. I think we've got to sit down, and our sector has done most of the work, and it's taken several years of my life working with our sector in terms of getting the hospital agreement. But there's other areas too. There's access to medicines, for instance, because you're Aboriginal and we've got all these old diseases like rheumatic heart disease, etc. The medicines are not listed. So there's a whole series of structural reforms that, whilst it take time, it just does need to be worked on really it'd be good if you guys do say, you know, you can change the constitution, but I'm not sure that that's going to happen.
We've been dealing with this for 200 years. I don't know how many more reports and plans and inquiries, and we've heard the evidence today after evidence after evidence that people are sick of plans. People are dying. Children are being traumatised, strip search. We have a rise in deaths in custody. We have a rise in suicide. People are dying every day now because of the boot on our neck and the racism, the violent racism from cops and systems. What is your suggestion for the federal government to do? Because system change has been on the table for 200 years. NAO talked about systems. So we're 2026. I was around when NAO was there. So what do you suggest then that the federal government needs to act on now so that no more Aboriginal people die and no more children are being traumatised and removed from their families and country? What is the thing?
Well, I think, yeah, and I agree. I know that this is all frustrating. Like I said, I'm 76 soon and I'm still working, only not because I need to, but because this change is really so important. I came in years ago to write the Commonwealth's first equal opportunity plan and then the first reconciliation process, so it's been horrible. But I do think the national agreement on closing the gap is really fundamental to making government departments, not hardly any government departments, work with our communities to change the way they do things. And that includes, and I do believe that with prison health, for instance, I do think our community control sector, when we start to negotiate for a set of standards that they must all adhere to with the Justice Department and with the health departments, etc., that is going to take some time, but we can't. But at the same time, the government needs to fund programs to support, like we fund 30 regions, but we need 50 regions supported to do suicide prevention and suicide aftercare. So you do need a multi-pronged approach. And our mob also need to be drafting up stuff, like we have done all the drafting, etc. And then the government departments who keep saying they don't have enough staff and all of that, but once you give it to them, they do that. So I think it also, even though it's not fair or right, I do think our mob also need to try and work together to get these changes in place.
We have states and territories that are walking it back, as I said earlier. We have governments in this country that couldn't care less about closing the gap. A lot of blackfellas don't care about it either because it makes no difference to their lives. And whilst we get the minister, you know, deadly health minister, rocking up and being all deadly, dancing on the dance floor at the Nacho conference, he still won't stop shackling of women giving birth. He still won't remove hanging points in prisons. He still won't provide the Medicare rebate that he has jurisdiction to do for medicines in prisons, so on and so on and so on. We've got an update on closing the gap tomorrow, which we know is going to be dismal again. People have lost faith in closing the gap, including me, because 24,000 Aboriginal children, Torres Strait Islander children, are in out-of-home care. That's genocide. So whilst we might be, whilst it might be a good idea that, mob get together and make friends with the government and try, it is not working. It is not working. What is the federal lever here that the federal government can do to stop this genocide?
Well, let me say to you, I think because of you, as Lydia too, and whilst the Minister hasn't turned on overnight and said because he can't, because of the state, you know, the Commonwealth Constitution and the federal, state and territory governments, we have now at least got a process for starting to not have hanging points in prisons and dealing with the atrocities that happen in prison. That's not going to happen overnight, but, you know, I'm convinced that we will make some changes over the next 2 years in relation to what happens in prisons across the board. And we just do need everybody, and it's not making friends with them, it's holding them to account and getting them to change. So I know you're frustrated, as I am with frustration, but I think Butler at least, and while some of our mob, that's the problem. We all attack each other in our mob about what's not working and when in fact there are some things that are working and it needs to be spread out more. We shouldn't be attacking each other. So I agree with you, it's frustrating, but I have seen change here over the last several years, and I hope that the Minister is going to deliver on increasing community controls health services, funding up a little bit next year. I agree it's frustrating, but I think that's the way. And it'll be like ATSIA. You're going to throw out the national agreement, like people threw out ATSIA when there were a couple of little pockets that didn't work, but that was a real opportunity for decision making at the local level. And yet we had a couple of crooks in our sector, and so the whole plus the Labor Party agreed that we throw out ATSIA. We shouldn't continue to keep changing the systems that we recommend in our sector, our mob recommends.
Good luck. No hope.
I'm going to rotate the call and go to Mr.
Chelsea
Smith.
Watergo says fuck hope.
Hey Dawn, Matty Smith here. You touched a little bit on the FIFO services, particularly to rural and remote communities, and I guess the impact that has on the delivery of healthcare. And as I've seen firsthand, even the difference in medical records between state-based organisations and the ARCHOs themselves. What's the interaction like between the ARCHOs and the state-delivered health services, particularly Queensland Health, I guess?
Are you there, Dr. Casey?
Best question ever, worst question ever.
Hello.
Hello.
Sorry, Mr. Smith just asked a question. I'm just checking if you heard the question.
No, I didn't hear anything.
Oh, wow.
Okay. All right, maybe ask the question
I'll
again.
ask the question closer to the microphone. You touched on the FIFO workers, particularly in the health services, and how that impacts the delivery of healthcare, particularly in the remote communities. I'm also interested in the interaction between ARCHOs and the state-based health services, Queensland Health in particular, and even something as simple as using different medical records, which makes tracking of patients' treatment and care a little bit harder. Are you able to comment on that at all? And also, just finally, I guess, in terms of community-led health outcomes, the Torres model of care that was being pushed for a couple of years back.
Hello, can you hear me?
I give up. Surrender to whoever wants to go next.
I think
Okay.
Mr. Smith is.
Dawn, I'll catch up with you.
I think Mr. Smith is having issues potentially with his microphone. He's been trying to ask questions. We're just going to.
I heard the question.
Oh, okay, great.
Yes. So I can answer the questions.
Excellent, perfect, thank you. So we thought there were some tech issues.
Yeah, so I'm a Queenslander and worked in communities, including in the Torres Strait for many years. But let me tell you, Matt, that Queensland is the most frustrating place to try and improve health outcomes, particularly in the Torres Strait, they've got shocking health outcomes, and in Cape York, because the community control health sector has been set up to a degree with Apuna, and the Torres Strait hasn't got any community control. Oh, they've got one on the Torres Strait. But it's the communities themselves, people split in communities, working for the state and territory, the state government, Queensland state government, so they get into this issue of not sharing the data. We keep saying that in Doomadgee, for instance, they should be sharing that data, but the politics within each of those communities is fraught. So what we're trying to do, and it's going to take some time in Queensland compared to the Northern Territory and Western Australia, is transfer to Aboriginal community control. But it's going to take a long time. It is so frustrating, and you can see the health outcomes are not good.
So I guess further to that, there's been a downscoping of practice for Aboriginal and Torres Strait Islander health practitioners, whereas they used to be able to function more as nurses, but that's been taken away in recent years. Is that something that the ATSIA would be pushing for to reinstate?
Yes, we've certainly been pushing that since COVID, because our sector around the country were really initiated the response first up before even the government had initiated it. We started calling for meetings with the government in January of that year. The government finally met with us in March and then immediately accepted what we were saying. And so we had no deaths in the first 18 months. What we had was Aboriginal health practitioners and Aboriginal community control services doing the contact tracing, albeit some states were trying to do it and they just didn't catch up with people for 3 weeks yet the family had been in. So during that period, health practitioners were given, their scope of practice was extended to do much of the work. Then it reverted. Now, in WA and the Northern Territory always has Aboriginal health practitioners doing the high level of work and we can claim a bit under Medicare. So we're chasing for those health practitioners to have the scope of practice, but they won't ever allow it into hospitals in Queensland government. They just won't allow it. So that's why they need community controlled health services. The Apuna needs expanding and the Torres Strait needs their own community controlled health services as opposed to relying on the state government.
The Torres...
And what we've done with health practitioners over the last year since the Labor government's been in, they've given us funding to train Aboriginal health practitioners certificate 4, 500 traineeships, and we've done almost 300 that are completely trained. And so we've still got 200. We've still got 200 to go on that, but they're being trained and accredited, etc. But and some of them do go work, and they do work in the health state and territory health systems, but they don't have any say in those systems.
Yeah, I guess the Torres Strait is one that I'm particularly concerned about because it's not unusual for, particularly over Christmas time, for your locum nurses just to go home and you're left with just a health worker with not enough scope of practice servicing an island like Iama, which is, you know, a good 45 minutes to an hour in a helicopter before you could get somebody out there.
Yeah, so maybe with you being the member up there that we can push over the next few years a change from the state running the health services to community control.
Love to do that with you, Dawn.
Yeah.
Completed.
Thank you. Yep.
Thank you. That concludes the questions that we have for you this afternoon. If you've taken any questions on notice or you want to provide any additional information to the committee, if you could please forward it to the Secretariat by the 18th of August, we'd be appreciative. And you'll be sent a copy of the transcript of the evidence from today. And if when reading through it you see that there are errors in it, you are very welcome to request corrections to any errors that you find. Thank you very much. We will now suspend for 5 minutes.
Yes.
Thank you very much. Appreciate
And
it.
thank you all.
Thank you.
Thank you all for listening.
Thank you. We will now resume from our brief suspension. That concludes today's proceedings. I thank witnesses for their attendance and broadcast. I thank witnesses for their attendance and broadcasting, and the Secretariat for all of their support throughout today to make it all happen in the background. I declare this public hearing closed.